Yep. I declare open this public hearing of the Legal and Constitutional Affairs References Committee inquiry into Australia's youth justice and incarceration system. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live via audio. Before we begin, I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you're a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard to record proceedings. Mobile phones and electronic devices should be switched off or turned to silent mode. I now welcome representatives from the Law Council of Australia, the International Commission of Jurists, and Dr. Lisa Ewanson. Thank you all for taking the time to come and speak with the committee today. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could I please get you each to state your full name and the capacity in which you appear? And perhaps we'll start with the Law Council of Australia.
Thank you, Chair. Tanya Wolfe, President of the Law Council of Australia.
Thank you. International Commission of Jurists. Sorry, you're on mute.
Not unmuting for some reason.
It's not unmuting. There we go.
We've got you. No,
Sorry,
we're still not getting any volume, Mr. McIntyre, for some reason. Maybe we will come back.
We'll come back there. Dr. Ewanson?
Yeah, my name's Dr. Lisa Ewanson. I'm a Chancellor's Research Fellow at the University of Technology in Sydney.
And Chair, I'm also joined by Dr. Fletcher from the Law Council of Australia. Thank you.
If I could just ask him to state his full name and the capacity in which he appears.
Yes, Dr. Adam Fletcher, Senior Policy Lawyer at the Law Council of Australia.
Thank you. And have we got sound? I don't know if you want to try and speak and see if we can hear you.
Yes.
That's right. We can hear you. Yep.
We have you.
Brilliant, we've got you.
And Mr. McDowell, if you could just give your name and your capacity for the record.
Yes, Greg McIntyre. I'm a Vice President of the International Commission of Jurists.
Fantastic. Does anyone have an opening statement? Yes? Okay, so we might start Law Council of Australia first and then we'll work our way through in the same order that we just went in, I think.
Thank you, Chair. The Law Council of Australia thanks the committee for the opportunity to appear today. We also acknowledge the traditional custodians of country throughout Australia and their connections to land, to sea and to community. We pay our respect to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples participating in this hearing today. Child justice policies and laws across Australia disproportionately affect First Nations families and communities. This fact must be firmly borne in mind, and any solutions developed by this inquiry must be developed in partnership with First Nations peoples, consistent with the UN Declaration on the rights of Indigenous peoples. Like my predecessor, when appearing before this committee in February last year, I want to be clear, children can and do commit crimes, and we do not minimise the effects of those crimes on victims. What we do say is that the policy responses being adopted are costly and they are not working. Despite the work of former National Children's Commissioner Anne Hollands in her Help Way Earlier report, and almost 2 years since this issue was first referred to this committee, we continue to see backsliding by many jurisdictions across the country, with children detained at greater rates and still from unacceptably young ages. Governments are turning to increasingly punitive measures that are inconsistent with the evidence about approaches that work and are sustainable. These measures are incurring unacceptable costs, both in terms of funding and impact on vulnerable children's lives. I've personally seen the conditions in which children around the country are detained. Those conditions often fall short of compliance with Australia's obligations under the optional protocol on the Convention Against Torture, the International Covenant on Civil and Political Rights, and the Convention on the Rights of the Child. The requirement in Article 10, paragraph 3 of the ICCPR to keep children separate from adults and to make the essential aim of the system reformation and social rehabilitation is also, sadly, being overlooked in many jurisdictions. The legal profession is very concerned by these trends. That concern prompted the Law Council to publish a policy statement on child justice reform last year, which we commend to the committee. As we wrote in our submission, the cost of detaining one child in Australia has reached more than $1 million annually per child, for a collective total of more than $1 billion per year. If this funding were redirected to diversion and support services administered by specialists across relevant sectors, including justice, health and welfare, it could make a transformative difference in children's lives. It could also result in a lasting improvement in community safety, which research shows will not be achieved by taking a punitive approach. Community-based supervision costs on average $424 per child per day, compared with $3,635 at the moment for detention, and research shows it often has better outcomes. This crisis in our justice system also continues to attract international attention. Addressing the minimum age of criminal responsibility and overrepresentation of First Nations children in the criminal justice system featured among the recommendations made in Australia's 4th cycle Universal Periodic Review, and were of deep concern to the committee on the elimination of racial discrimination in its recent alert to Australia. There is a wealth of information about what works and what doesn't work in this area before this committee. As a national body, our focus remains on the role of the federal government and compliance with Australia's international human rights obligations. We acknowledge recent efforts by the Australian government in this area, including substantial funding towards justice reinvestment, the establishment of the Commission for Aboriginal and Torres Strait Islander Children and Young People, and the Attorney General's letter to the Northern Territory Government in May about the concerning state of legal aid in that jurisdiction and compliance with the Convention on the Rights of the Child. Our recommendations identify additional ways the government can lead. These span a number of possible legal levers, including raising the federal minimum age of criminal responsibility, reviewing Section 20C of the Crimes Act. In addition, funding levers, including justice reinvestment, and a model that directs Commonwealth money to programs with demonstrated outcomes, and engaging with our international obligations, including withdrawing Australia's reservation to Article 37C on the Convention of the Rights of the Child and accelerating OPCAT implementation. Thank you.
Excellent. Thank you. Dr. Ewanson.
Thank you. Thank you, Chair and members of the committee, for the opportunity to appear today. So I'm joining you all from the unceded Gadigal lands of the Eora Nation. So my name's Dr. Lisa Ewanson. I'm based in the Faculty of Law at UTS, and my professional background's in both social work and law. It's important to firstly highlight that it remains deeply unacceptable that First Nations children continue to experience proportionate rates of detention at 60% of the overall youth detention population across Australia. What was clear through my research with children and young people previously detained in New South Wales is that social policy institutions had failed these young people, their families, and communities long prior to their incarceration. Poverty, racism, exclusion from education, under-resourced families, and inadequate housing were common experiences for these children prior to detention. However, importantly, these children and young people also told me what they valued most in their lives: trusted relationships, meaningful education, cultural connection, safety, stable housing, and resourced families and communities. Some of the children and young people I interviewed described accessing meaningful education for their first time within detention, and some described the relief of having access to a bed in detention. These findings are a stark and distressing indictment on the deeply unjust state of our nation. Concerningly, these children also describe significant harms and enduring hardships that youth detention imposed on them. Volumes of government reporting across the nation over decades tells us that youth detention centres are often unsafe for children and young people. And as my predecessor just mentioned, the Productivity Commission reports that youth justice detention is wildly expensive, up to $1.32 million per year, and it does not reduce crime in the medium to long term, with about 84% of 10 to 16-year-olds coming back to youth justice supervision of some form, either in the community or detention within 12 months. So I recommend substantial youth justice decarceration through the 5 key steps which are outlined in my submission, but I'll just touch upon them briefly. So raise the age of minimum criminal responsibility to at least 14 across the nation. Only detain children as a very last resort for the most violent, serious offending. Eliminate the use of pre-sentence detention, that's remand. Do not detain any children who have fetal alcohol spectrum disorder or any other neurodevelopmental disorders, and cease the mass overrepresentation of First Nations children in detention across Australia. Noting, however, that the abolition of youth justice detention is the ultimate goal. I advocate for nationally enforceable human rights standards based for youth detention, and I welcome a future Federal Human Rights Act as a key step towards firmly embedding enforceable children's rights. Any dramatically limited form of youth detention should comprise of smaller therapeutic home-style environments in various forms, not high-security, punitive adult-style institutions. My research proposes a relational rights-based approach to youth justice detention, one that recognises children as rights holders whose development depends upon nurturing relationships, cultural connection, and meaningful opportunities to flourish. The majority of staff in such environments must hold qualifications in the caring professions, and the staffing should culturally reflect those who are detained. Spain, through their diagrama centres, demonstrates how such relational rights-based arrangements can be achieved. Scandinavian nations use secure welfare units instead of large, high-security penal environments. So security must be supplementary, not core, to any very limited in size future forms of youth detention in Australia. So the provisional relational rights-based model for youth detention is framed as NEST, with N being for nurturing relationships, E being for comprehensive and meaningful education, S for safety in all forms, cultural, physical and psychological, as well as through legislative mandates, through endorsing OPCAT, and then T, transition, which must be long-term and resourced. When it comes to the promotion of human rights, legislative frameworks are absolutely necessary, but in themselves alone, they are not sufficient to create the full societal change required. Rights need to be pursued through public discussion and advocacy, creating a permanent shift in underlying societal attitudes. In detention contexts, human rights can only be protected and achieved if those administering the detention do so in a way which engenders the dignity and well-being of those detained. Currently, we do not have a comprehensive embedded rights-based culture across all government policy and program implementation. So this NEST model aims to recognise and respond to the structural constraints imposed upon and experienced by children and young people before, during and after incarceration. It intends to assist young people to live flourishing lives, ultimately contributing to community safety in the long term. Human rights standards aren't self-executing in any environment, especially where there are significant power differentials, but they can be maintained within environments and work cultures that philosophically embrace such approaches. But finally, our primary responsibility through our social democracy is to promote the full spectrum of children's rights throughout all childhoods in their great diversity from the very beginning of their lives. If we do this, far fewer children will ever reach the youth justice system. Families and communities must be generously supported, poverty must be eliminated, adequate housing for all must be ensured, and public education needs to be inclusive and amply resourced. These are just some of the key elements where our attention must focus. This approach is consistent with our obligations under the Convention on the Rights of the Child, which includes the child's right to development. Thank you.
Thank you. Mr McIntyre. We might need to unmute you again. Yes, we've got you, Mr McIntyre.
Yes? No?
Yes, we have you. Yep.
Thank you. The International Commission of Jurists supports the submissions which you've heard this morning and a number of the others which have been made to you during the course of this inquiry. Particularly the submissions of the Australian Human Rights Commission, the Justice Reform Initiative, all of which reiterate a number of the issues which are echoed in no doubt many of the submissions you have before you. What the International Commission of Jurists wishes to emphasise is that the Commonwealth has responsibility for compliance with the international human rights instruments which it has ratified. In particular, the most relevant of those, of course, is Article 37B of the Convention on the Rights of the Child, which provides that no child shall be deprived of his or her liberty unlawfully or arbitrarily. The arrest, detention or imprisonment of a child shall be in conformity with the law and shall be used only as a measure of last resort for the shortest appropriate period of time. We want to emphasise that clearly if the Commonwealth wished to legislate, it clearly has the constitutional power to do so under section 51(29) of the Constitution, the external affairs power, which through the international conventions it has ratified gives it a wide-ranging power to do what would need to be done if it needed to be done legislatively. There are, of course, other ways in which the Commonwealth can intervene. It has the capacity to fund states and territories to comply with the obligations which the Commonwealth has in relation to its young people under the Convention on the Rights of the Child. And it ought to be providing an example by reviewing the operation of Section 20(c) of the Crimes Act of 1940 and adopting the recommendations of the Australian Law Reform Commission for greater consistency in sentencing young federal offenders and using detention as a measure of last resort for the shortest possible period in compliance with that article of the Convention on the Rights of the Child. Since the Middle Ages, governments have been proceeding on the false logic that increasing penalties will reduce crime. The definition of insanity is doing the same thing over and over again and expecting different results. That's what's been happening with our youth justice system for decades. I'm speaking to you from Boola or Perth in Western Australia. the land of the Whadjuk Noongar peoples. What happens in Western Australia is that they have one single detention centre for the whole of the state, and they transport youth from the vast distances in the north of the state to be held in a detention centre, sometimes merely because they couldn't get bail. They're there for several days, or they're there for weeks, or they're there for months. You will have heard already and be very aware of deaths in the detention centre in Western Australia. I am reliably informed that things have improved somewhat, but they are still doing that. The West Australian government has announced that it's going to create a new facility, a replica of what it has, to create a greater capacity to incarcerate more and more youth. I understand that you may have heard recently from representatives from a group who have been travelling around Australia from the US, from Spain and from Hawaii, who have told you about their experiences in each of those countries, and perhaps unapologetically the representative from the United States said, well, we've done well in some states and not others, but they have reduced the incarceration of the youth by multiples. They're down to very much smaller numbers than they ever had. That is happening in the United States, which are led by Republican governors, and they are seeing the economic sense of doing that. They're doing it well. It's being done in Scotland, as you've no doubt been told as well. It's time for the Commonwealth to provide leadership to the states and the territories and to come into line with what is demonstrated internationally as possible to be done to please the committee.
Thank you very much for those opening statements, and I'm conscious of time, so we will jump straight into questions. Senator Stewart, you have the call.
Thank you. The awkward couple of seconds it takes to get everything started. My first couple of questions is to the Law Council. One of your recommendations is to create a national evidence base or clearinghouse of effective child justice policies to guide policymaking. Can you elaborate on what you mean and how it would work in practice and what would change because of this approach?
Thank you, Senator. That I think was recommendation 3, and we were referring to sort of a centralised Commonwealth-supported repository. So basically, jurisdictions can see what's working elsewhere, and they can find that rather than each trying to reinvent the wheel. Clearly, this committee has already seen and heard so much evidence of what's working internationally, but there's also some evidence of what is working domestically or within this country. And it also responds directly to a finding from a review that was commissioned in the Help Way Earlier report, which identified 6 recurring systemic problems across 12 years of child justice protection inquiries. And that, I think, included inadequate cross-system information sharing and a lack of mechanisms for oversight and monitoring and transparency. And it matters for this hearing as well because there are concrete models that would already be good for this clearinghouse right now. There's the Tasmania's model of care might be something to look at. The Hoops for Health in the Northern Territory might be something to look at. Even Victoria's Violence Reduction Unit. There are various jurisdictions where that's already working, and there's no single mechanism right now to ensure that a jurisdiction that's thinking about reform can actually see the evidence before legislating, and so this was one of our recommendations, Senator.
Thank you. It's surprising that something like that doesn't already exist in terms of just being able to see what's working across the country. And for Dr. Ewanson, your submission identifies, unsurprisingly, I think, poverty, inadequate housing and underfunded schooling system, limited access to mental health services as the core drivers for pushing children into contact with the youth justice system. And I appreciate that the question I'm going to ask is kind of like choosing your favourite child, but which of these Commonwealth levers do you consider the highest priority for early intervention?
Well, yeah, extreme poverty, the extreme inequality. Like when I conducted narrative inquiry interviews with young people who'd recently been released from youth justice detention in New South Wales, and they told me about their time in detention in New South Wales, but through their stories, they told me a lot about their lives, of what led to them being involved in the criminal justice system. And they, without exception, very challenging lives with an undercurrent of extreme poverty, families and communities not being supported, and really overstretched child protection systems and schools that don't have the resources to support all students or that aren't doing it as well. So look, unfortunately, I don't think I can pick just one.
No, I thought that might be the case, which is why I did preface it saying it's like choosing your favourite.
Yeah. Okay. Yeah. Look, it's just we need to. It's just shifting, and the lives of these children and young people, they have so much potential that's not being harnessed, and then they're further traumatised in detention, and it can't be surprising that when they come out, things may go further awry because they don't have anywhere safe to live, and they don't have opportunities to help them flourish to reach their full potential. So, it's a really broad problem.
Absolutely. I appreciate that. I'm wondering if you've got some some kind of specific examples that the committee both might be able to use to kind of paint that picture of some of the circumstances that these kids are coming from. I think that's always useful, I think, to be able to kind of speak to some of the experiences of young people in this country who come into contact with the justice system.
Well, the stats, and I'm sure you've been hearing the statistics through this process, but look, of the young people I spoke with, most of them weren't engaged in school prior to their time being incarcerated. They didn't have stable housing. Over half were involved in the child protection system, which we know is really stretched. And their families and communities more broadly were not supported, from what I could ascertain from the stories I heard. So it's a really complex picture, but I think it's one that as a social democracy, as a wealthy social democracy, we should be able to resolve these issues. We have the resources. And when it's wonderful that representatives from Spain and the diagram centres have been able to speak with you, because there are some great videos about how youth detention centres which in Spain, they look very different. They're smaller houses, only for those who've committed the most serious offences, and they're nurturing. They're staffed by social workers and psychologists and teachers, and then there's a few security guards around the edge. They're not high security penal environments where the overuse of force and restraints are kind of everyday features, and the use of isolation cells. Those are things that I heard of, and also in my previous time working in a youth justice context in Victoria. So I think, and they're in Spain, the rates of the young people who are released coming back into the community, the criminal justice system, it's 15% instead of 85%, which we have here in Australia. So, and they're also much cheaper to run. So overall, we want a society free from crime. That's what we all want. And we want all of our children and young people to be nurtured and flourish and live great lives contributing to society. So I think it's a broad picture, but those who do end up in some form of limited size of youth justice detention, I think it can be shaped very differently in Australia, quite readily, leading to much better outcomes for those children and for the community overall.
Thank you. I'm just mindful of time. I think we've already got you to under 15 minutes now, so I will share the call and just flag. I'll have some questions on notice for you.
Thanks, Senator.
Thank
For
you.
each of you. Yeah.
Okay.
Thank you very much for your assistance, Senator Stewart. Senator Shoebridge.
Thanks all for your ongoing engagement in this. And I think each of you describing it as a youth justice crisis in your own way, I think it emphasises just what an important job it is for the federal government to actually get involved. I might just sort of drill down into a couple of things that I think are mentioned in both the ICJ and the Law Council submissions. One is the operation of Section 20C of the Commonwealth Crimes Act. I might just go to you, Ms Wolfe, to start on that, and then either Greg or Lisa, if you want to sort of contribute after that. Why is that important?
Thanks, Senator. Just want to check I'm not on mute.
No, we can hear you.
Excellent. All right. Section 20C currently allows a child who's charged with or convicted of a Commonwealth offence to be tried or punished or otherwise dealt with as if the offence was against a state law or a territory law, so it's where they're located. And in practice, this means that a child prosecuted federally has their treatment determined by whatever sentencing regime actually operates in that local jurisdiction. So as states have been and continue to harden their approach, Queensland removing detention as a last resort, Victoria with the adult time for violent crime laws in December. As that happens, Commonwealth prosecutions of children could passively inherit those harsher standards by default, and with no independent Commonwealth check on that. And so the ALRC has also previously recommended a greater consistency in sentencing children for Commonwealth offences, and with particular regard for children's wellbeing and detention as a last resort. And so this recommendation really asks the government to pick that up. And also, like another one of our recommendations, it sits squarely within the Commonwealth power. It governs Commonwealth, which can govern Commonwealth prosecutions. It doesn't require constitutional wrangling or external affairs powers.
And it's become more urgent as state and territory sentencing provisions have become harsher and less compliant with our international obligations, even in the last 3 years. Is that why that's front and centre?
That's correct, Senator.
And would it operate to say an amendment could be of a form such as, sentencing reflects the law in the jurisdiction, save that, and then you put in the rights of the child provisions, sentencing as detention as a last resort. You'd put in those kind of principles, which would then operate to modify how those state and territory sentencing arrangements worked. Is that what the essence of where you go?
I think that thought could be given to how it was actually framed, but it is our submission that it ought to be done, and it can be done.
Could I ask you if there is any sort of more granular thinking about what that would look like from the Law Council, if you could perhaps respond on notice about to try and give this a push along, not to just leave it as an abstract idea with the Attorney General's Department. In my experience, abstract ideas go to die in the Federal Attorney General's Department. A more concrete provision would actually help push this along.
Thanks, Senator. We can take that on notice and respond to the committee.
Mr McIntyre and then Ms Everson.
You then need to support that with with funding from the Commonwealth to set up systems which actually make it work, and that can then have a flow on. I mean, it would then mean that the Commonwealth needs to get involved in youth incarceration and insist on models which are compliant with its legislation for Commonwealth offences, which ought to then have an impact on on state sentencing practices as well.
And if for no other reason, Ms McIntyre, then if the Commonwealth is contracting out the detention under Commonwealth offences to state and territory officials, it can't then just turn away from what are on a number of the submissions torture-like conditions in where the Commonwealth is sending young people. That seems to me a kind of essential Commonwealth obligation in the space.
Absolutely, couldn't do anything other than agree entirely with that.
Yeah, to the extent that the ICJ's had some thought about what those support measures would look like to sort of give life to amendments to 20C, would it be possible? Again, I'd invite you, if there is any of that assistance you can give, to provide that on notice, what that kind of support package would look like to wrap around amendments to 20C?
I'm sure I can do that. As you know, our chair is a district court judge who no doubt has day-to-day experience with this.
Yeah. Dr Ewanson, yes, I'll come to you.
On those points, I agree with both of the prior comments on the panel. Thank you, Senator. Yep.
Thanks. Could I then ask about the reservation to Article 37C of the Convention on the Rights of the Child? And we might just go through the same order again. Why is that important, and what would that mean in practice, removing that reservation? Ms Wolfe?
Thank you, Senator. Article 37C requires a child in detention to be separated from adults, unless that separation isn't in the child's best interests. And Australia currently holds a reservation to this article, which means it's not bound by it domestically. I understand there were various reasons for that reservation, including the geography of Australia, and there was some concern that in certain remote areas that wouldn't be feasible to do that. I'm not entirely an expert on that. This committee can get further evidence. But Australia holds, the UN Committee on the Rights of the Child has specifically recommended that Australia withdraw that reservation, as has the National Children's Commissioner in her report, Help Way Earlier, and I think there have been various other jurisdictions, including, I think, the Law Society of WA, that separately called for state legislation requiring separate facilities. And it isn't abstract, it's the direct legal issue that is actually underlining Unit 18 at Casuarina, where we had the tragedy of Cleveland Dodd in 2023, while he was housed in what was, legally an adult prison facility that was repurposed for youth detention. And there were recommendations by the coroner about that. And I understand that there's an indication that it won't be accepted. But this makes it a live, current example rather than a historical one, and it's important in our view.
And Mr McIntyre, I know you're familiar with what's been happening in WA, and I think it wouldn't be, if this recommendation from the coroner is rejected by the WA government, it wouldn't be the first time in relation to youth justice that the WA government has refused to follow the warnings given by the Supreme Court or other concerns that have been directed to them when judges are told about the conditions in which children are being detained in WA. And for me, it highlights the need for Commonwealth to act when a state government keeps refusing to even heed the calls that are coming from its own Supreme Court. But I'd be interested to know, you've been following this closely in WA. what your position is.
Yes, I mean, there are no youth detention centres outside of the metropolitan area of Perth, the Banksia Hill Detention Centre. So whenever a child is arrested in the Kimberley or the Pilbara, the only place to detain them is in an adult police watch house, and that's where they go. Or they're flown down at vast expense to us all to Perth. But no doubt they will spend at least 1 or 2 nights in some police watch house being detained by the police. So that's and the so-called justification for the exemption is, oh well, they'll be close to family if they're held there rather than somewhere else. But what they need to do is what Diagramma do and other countries around the world do. They work out that you don't create large single destination facilities, particularly in large areas like we are. Yesterday, I was at the presentation by the Justice Reform Initiative, and the Welcome to Country told us that these children are being removed from their families. Anyway, but what they said was that the small non-government organisation facilities which exist around the world is what actually works. That's what Diagramma is, a non-government institution, and that's how they work. They have small cottage-like or home-like facilities which reintegrate children into the family that they are often missing. I mean, what we learnt from Commissioner Holland's report, when some of you went to the presentation of it last year, those children who had been in the system, once they were reintegrated into somebody who cared for them and took an interest in them, they reintegrated back into society. Whilst we isolate children into these large institutions, we're creating dysfunctional members of our society. Sorry, I've strayed from the question. Yeah.
No. Well, if there's anything you'd like to add on notice to that, I'd appreciate it, from the sort of that the interaction between Supreme Court judgments and findings and the WA state government. I'd appreciate that, given your knowledge in that space. But because of time, my final question to Ms. Ewenson, Dr. Ewenson, the state becomes the guardian and parent for so many of these children, and if a parent behaved like the state behaved, the state would take the child away from them. The neglect, the violence, the indifference that the state shows. And it's difficult to see how this can ever be justified. This is a kind of state-directed violence against the children under the guise of protection. But what are kids telling you?
Thank you for that question, Senator. Look, I completely agree. The state has an ethical, moral and legal duty to treat children under their care like children who, just as Mr. McIntyre was saying, they need nurture. When we're young, we need nurture to flourish, and the conditions that some of these children are held in are reprehensible. And it is unbelievable that, given the amount of reporting and all that we know, that it's still continuing within these giant, punitive, high security institutions. So, yeah, look, I think the underpinning approach needs to change ethically, morally and legally for children in detention in Australia, across Australia.
Thanks.
Fantastic, thank you. And Senator Cox, I believe you have one very quick question before we wrap up.
Yes, thank you,
with
Chair.
these witnesses.
Just within your recommendations, you recommended some monitoring and assessment on the impacts of justice reinvestment. So I'm just hoping to get some more information, or if you can elaborate on that recommendation. Just that I'm aware that the Commonwealth already have a measuring and evaluation framework that they announced back in May, but if there are particular insights that you wanted to share with the committee if you could do that, particularly around justice reinvestment, given that it is some of the direction that the federal government is moving in, and also has good international evidence around its work in places like Belgium, in the juvenile justice system in particular. So I'm happy if anyone wanted to provide some quick commentary, but also if you could take it on notice to elaborate a little bit more for us on that recommendation.
So I'm not sure if that question was for the Law Council, but the Law Council is fully in support of, expansion of justice reinvestment initiatives and any evaluation. We understand that, there's a substantial amount of investment that was made by the government, about 81.5 million, I think, for 30 community-led initiatives, and these are really very important initiatives, and we would just encourage their further investment in them, and to build up that evidence base, which I understand from your question that is already happening, but to see that as one of many levers that are open to the Commonwealth Government to progress.
Thank you. Yes, sorry, it was directed at the Law Council. Just to correct that.
If I can just add a comment, whilst there are a number of justice reinvestment initiatives around the country, they are still a drop in the ocean. There needs to be a more comprehensive approach to it.
I agree. Thank you.
Thank you very much, Senator Cox, and thank you very much for giving evidence to the committee today. If at the end of this you go away and think there was something you really wanted to tell us that you think would be very helpful as we start forming recommendations, please don't hesitate to email that through to the Secretariat. We'd be very grateful for that. But otherwise, thank you. We really appreciate you taking the time to give evidence today, and with that, you are released. And we will just suspend for a couple of minutes as we switch over. I now welcome representatives from the Human Rights Law Centre, Amnesty International Australia and the UN Youth Australia representative. Thank you for taking the time to speak with the committee today. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could I please get you each to state your full name and the capacity in which you appear? And we might start with Ms. Mehta.
Sure. I'm Sohini Mehta and I'm appearing in my capacity as Senior Lawyer in the First Nations Justice Team at the Human Rights Law Centre.
Fantastic, thank you. Uncle Dylan?
Rodney Dillon, yes. Yes, my name's Rodney Dillon and I'm the Aboriginal Advisor to Amnesty International.
Thank you very much. And I'm not even going to try and apologise, so I can't wait to hear how it is. Satara, if you wouldn't mind.
Sure. Satara Ade-Kamara, 2025 Australian Youth Representative to the United Nations on behalf of United Nations Youth Australia.
Fantastic. Good to see you again. Do any of you have an opening statement that you would like to provide?
Got one. Yeah.
Just please, if you'd like to proceed.
Of course. Thank you, Chair. I begin by acknowledging the traditional custodians of the lands on which we gather, the Ngunnawal and Ngambri people, and I extend my respect to every First Nations person in this room, and I hold in my heart the First Nations children currently locked away in concrete cages. Sovereignty was never ceded. This always was and always will be Aboriginal land. They stripped me in my cell. The moment they pulled my pants down, that's when I stopped feeling like a human. Those are the words of a 14-year-old boy inside Ashley Youth Detention Centre in Tasmania, a child. As Australia's youth representative to the United Nations in 2025, a role coordinated by United Nations Youth Australia alongside the Department of Foreign Affairs and Trade, my role was to conduct the largest face-to-face listening tour of young people that year, with the intent of capturing the unvarnished realities and voices of thousands of young Australians. I then represented those voices and that of Australia at the United Nations General Assembly. As part of my mandate, I also went looking for the children this country has chosen to forget, walking into the darkest, coldest corners of this nation, the concrete shadows of our youth prisons. And what I found broke my heart. I found a brutal machine that takes our most fragile, traumatised children and systematically strips their humanity. Inside Bimberi Youth Justice Centre, right here in the ACT, a 15-year-old girl pressed a letter into my hands. I'm 15 and I'm writing from Bimberi. Most of the time we are locked up in our cells for up to 17 hours. I've watched Bimberi use force on a young person for 20 minutes. Bimberi Health doesn't listen to or help with female problems like endometriosis. They refuse to give heat packs or adequate medication. No kid in here knows when they will get out. It is impossible to get help. The system is not working. End of story. In my role, I sat across from 10-year-olds inside walls like these, children so incredibly small that their legs still swing from their chairs because they cannot even reach the floor. These are children who should be stumbling through their first books. They should be running outside until they are breathless and falling asleep, safe in the arms of someone who loves them. And instead, we hand them over to strangers with handcuffs. I'm 23 years old. These young people are my peers. They are kids who remind me of my cousins, my siblings, my friends. I look around this room and I have to ask, how is it that I have the privilege of sitting here before you, safe and heard, while they are locked away in the dark? Some of them just down the road from us right now. The stark, heartbreaking contrast between my freedom and their confinement, simply because of the cards that life has dealt us differently, shows that the promise of a fair Australia is our greatest lie. Perhaps this is best made evident through the words of a group of young men I met from Cobham Juvenile Justice Centre in New South Wales. We're still sons, brothers, friends. Some of us are artists, some are cooks, some want to work with cars, some write music. But when we're locked up, people stop seeing us as human. They stop believing that we can change. When I leave this inquiry today, my immediate priority will be attempting to return to those very prisons, to sit back down with those children. But I will have to look them in the eye and tell them whether the adults in this place are finally ready to listen, or if we have to go and lock the door and walk away again. As the former Australian youth representative to the United Nations, I say this to you without an ounce of hesitation. We are torturing children on Australian soil. By strapping spit hoods to the faces of terrified, distressed children and subjecting them to cruel, inhuman and degrading treatment, Australia is an active, undeniable breach of international law. We are explicitly violating Article 37 of the UN Convention on the Rights of the Child, the UN Convention Against Torture, the UN Declaration on the Rights of Indigenous People, the International Covenant on Civil and Political Rights, and the Convention on the Rights of Persons with Disabilities. As a 17-year-old girl from Western Australia told me, they lock up 14-year-olds with disabilities for 23 hours a day, then wonder why they broke. I urge this committee, walk away from a system built on cruelty and embrace one built on healing. We must immediately raise the minimum age of criminal responsibility nationwide to 14 immediately and prohibit the holding of children in adult watch houses. We cannot claim to be a civilised nation while a child is legally permitted to be treated like an adult criminal. We must redirect funding from prisons to prevention through a national social reinvestment framework. When a 16-year-old in Queensland told me, I committed armed robbery just to eat, and another confessed that life is better in a cell with bed and a food as opposed to the streets, the failure is obviously not theirs but ours. Every dollar wasted on caging that desperation must be redirected back into community kitchens, school counsellors, and guaranteed housing security. Programs like Backtrack, the Irriman Project, and Sisters Inside prove that when we invest in people instead of prisons, children thrive. As I directly heard from young detainees in New South Wales, in your eyes we might be criminals, but we're still people. These diversion programs succeed precisely because they remember this truth. We must also use the Constitution to make the abuse of vulnerable children a legal impossibility. By leveraging the external affairs power, the Commonwealth can override state laws to ban spit hoods and solitary confinement nationwide. Additionally, Section 96 must be used to financially penalise non-compliant states. This combined legal and financial force ensures that no 15-year-old girl is ever locked in a cell for 17 hours, only to conclude no one listens or helps. Recently, the Australian government declared that a 15-year-old is too vulnerable, too fragile to safely exist on social media. With sweeping world-first legislation, we banned under-16s from platforms like Instagram and TikTok. The message from our leaders rang out clear: we must protect our children. The contradiction is impossible to ignore. We have decided that a teenager cannot navigate an algorithm, but a 10-year-old can navigate a courtroom. We shield adolescents from screens, but subject children to strip searches. We fear the harm of a digital world, but accept the damage of a concrete cage. Right now, we are hiding our wounded children in the dark. The endless political debate over tough on crime policies, policies that do nothing but crush young lives for cheap political points, must end. Australia already has the answers to this crisis. Our leaders just lack the political courage to care. And if you still cannot find the courage to care, then I leave you with one final plea. I began today with the words of a child held inside a Tasmanian prison, and that is exactly how I will end. And this 15-year-old told me to take his message directly to the leader of this country. Prime Minister, I strongly believe that you should come to Ashley Youth Detention Centre so that you can hear our voices in person. It will break your heart. Our children are crying out from the dark, trying to come back to us. It is time we stopped building higher walls to hide them and finally lay down the paths of love, dignity and community that will bring them home. Thank you.
Thank you very much for that. Were there any other opening statements? If not, we can proceed into questions. Oh, there are?
No, I'm happy to keep going.
Keep going with
questions?
I
have an opening statement, but if, in the interest of time, I'm also happy to proceed.
Yeah, fantastic. And if you'd like to table that, then we can still include that in our evidence, and that would be fantastic. Thank you very much for that. What we will do is I'll give the call to Senator Shoebridge.
Thanks, Chair. Mr Dillon, when you hear Satara's evidence about a little 10-year-old, what's that put in your mind?
That it puts a lot of things. Like, I'm a 70-year-old, 70 not long ago, and I've been in this area all my life. And I thought as a young person that we could change it in my life, but we haven't done it. It's just as bad or worse. We're in the same predicament, and it's actually become a political scoring implement now in society. So I worry about the kids in the system, the kids that are in there 23 hours a day locked up, kids that are strip searched, kids that are in adult lockups. You've heard it all this morning, and you've heard it, and you know it yourselves as well. These places, putting kids in police cages and carting them around towns, locking our people up. I just wonder how much longer this keeps going on for in my life. I think it's an international crime. And like someone was saying just a while ago, if we as family locked our kids up for 23 hours a day and didn't let them out, or if we put spit hoods on them, or if we hit them with tear gas, we would be charged, and so should the people that done that. But unfortunately, our system doesn't allow for that, because the state governments are protected. They're protected within themselves. And as a Commonwealth government, we've seen they're not fit to look after our children. And this has happened, whether it's Banksia, Ashley, Cleveland, Dondale, all these prisons are unfit places for our kids to be. We know that prevention, we don't talk about prevention like having Aboriginal-led programs to keep kids out of these places. the $1 billion we spend on locking kids up compared to the pittance that we spend on trying to prevent them from being locked up shows that we're fair dinkum about wanting to lock these people up. So that's all that's my start of how I feel.
Yeah. Ms. Mehta?
Yeah, I think it's absolutely heartbreaking that children as young as 10 are being caged in most jurisdictions across this country. I think the stories that Satara powerfully relayed are not entirely new to members of this committee or to the government or to previous governments for that matter. These stories and the recommendations that you'll be hearing again and again are not new to anyone, and it's the issue is not a lack of evidence of what works and what children need. It's a lack of political will, which is extremely distressing given that we're talking about children's lives that are at stake.
It's more than a lack of will, though, isn't it? It's like politicians actively doing this. It's not even passive for a lot of the time. It's an active, intentional harming of children for political advantage. That's actually, describing it as a lack of political will in many ways lets the politicians out, because it's conscious, active harm towards kids, making it harsher and meaner and nastier for kids for political advantage. I think, yeah, do you think it's really a lack of political will, or in fact it's actually something worse than that from politics, isn't it?
It's an important correction, Senator, and I would agree with you. I think that state and territory governments are brazenly violating children's rights on the federal government's watch. The federal government appears to have adopted the mantra that youth justice is a matter for states and territories, while Australian states and territories are violating people's rights, children's rights, with effective impunity and very little, if any, access to remedy for affected children to enforce their rights. While the federal government might act like their hands are tied, we've heard evidence that their hands are not tied, and leadership obviously also starts at the top. So the Albanese government has itself rejected the majority of recommendations made during the 4-yearly UN Human Rights Review, known as the Universal Periodic Review. That included calls to raise the age of criminal responsibility. Those were rejected, as were calls to legislate the National Human Rights Act and implement the UN Declaration on the Rights of Indigenous Peoples.
Satara, thanks for your opening address, as disturbing as it was. You travelled around the country. Did you see Northern Territory kids and South Australian kids and New South Wales kids and WA kids, or did you see Australian kids with a very common set of or issues is the politest description I'll give? What were you seeing as you were travelling around the country?
I definitely saw Australian kids. I saw children who are just children and who have grown up with the love that they show towards the country that raised them. But what was different was the way that the states and territories treated them. So it was really interesting, for example, going into a place like Queensland and seeing the way that young people were treated compared to, say, in New South Wales or in Victoria, where it was just so vastly different based on a kind of an arbitrary border that we've drawn up. And it's ridiculous. And I think what's also interesting to note is that a lot of youth crime does also happen across borders. So you've got kids who maybe were imprisoned in WA who are now imprisoned in New South Wales or now imprisoned in Victoria because they've moved, and they can see the discrepancies for themselves. Like, they say things to me like, I wish I was back at Cobham, or I wish I was back in this place because I was treated so much better there. So they see those distinctions.
Well, we had evidence from a First Nations Commissioner yesterday saying that actually there have been some reforms in the ACT that are child-focused, moving towards raising the age, but saying that actually, well, kids in the ACT, especially First Nations kids, need to be warned that if you cross the border from the ACT to Queanbeyan, you might face a vastly harsher, more punitive set of laws, like actually being warned about going and catching up with their family in Queanbeyan. That seems to me to be a kind of intolerable situation, at least from a federal perspective.
Yeah, it's bizarre. And I also think that if we think about who we're talking about teenagers and children who will have to cross borders to do things like visit their family, or particularly in places like the ACT, have to travel to school, have to travel to work. Like, it's something that they need to do. And so it's quite unfair to have to, put that in place for them to be warned about.
When you're sitting in one of these detention centres and you spoke about little 10-year-old with legs swinging, what are they saying to you about what they're feeling? You know, the whole theory about putting them in this situation. They've been handcuffed, arrested, held in cages, put into those detention centres. The theory behind it, the state theory behind it, is the punishment will somehow be good for society. But what are the little 10-year-olds saying and thinking about what's happening to them?
Perhaps I can answer this with an example of one of the 10-year-olds I met. And one of the things we discussed was the crime that he had committed, which was to rob a car. But he had done that with his father. And so when we were talking about the reasons behind why he committed that crime, that what he literally told me was, I just did it because it was something I wanted to do with my dad. My dad was doing it, I wanted to do it with him. And to me, I kind of think instantly, well, growing up in a privileged environment, hanging out with my dad meant going to a restaurant, going to a movie, like going to the theatre. But for this child to hang out with his father meant taking part in a crime that was happening that was not directed by him, was directed by someone else. This was a 10-year-old who was crying out for a family that he didn't have. And I think instead of actually giving him that family and giving him that love, the state decided to imprison him instead and actually take him away from the only family he had. I mean, that to me seems pretty heartless.
And it must be incredibly confusing for a 10-year-old to have all of this happen because they chose to spend time with their dad. It must be so incredibly confusing for them.
It absolutely is. And again, we're talking about 10-year-olds whose minds have not developed yet to understand really the distinction between right and wrong and really put a reason to why they're being locked up as you know, I want to hang out with my dad or I did something wrong. They just see it happen. And as I said in my opening statement, the point is you put children into this system at 10 years old. They're still in that system by the time that they're an adult and they go into the adult prison system. That's what happens. It's a system that you set up. You take away that humanity from that child from a very early age. You don't tell them why they're in there. They're just in there. They become acclimatised to the environment and therefore are more likely to start committing more crimes. And I think that's why we see really bad rates of reoffending. You know, you put someone in there from an early age, that's how they develop their mind, that's the people they start hanging around. And you're kind of setting up society for failure.
Uncle Rodney, if you had a magic wand and you could put up a different system for that 10-year-old, you know, what would it look like from your perspective?
I think from an Aboriginal perspective, it's having Aboriginal-run programs to keep the kid within the community where they come from. Those community programs, we've seen programs like the one that was at Halls Creek, where we had elders and we had young people walking the streets of a night, keeping the kids safe. These kids are vulnerable and they need to be kept safe in their own community. If that kid hadn't been in Halls Creek, safer with their people, they would have been down in Banksia, which is, be close to 2,000 kilometres away from where they are. And we heard previously people talk about having places close to where they are if kids need to be helped address the issues that they've got, whether it's medical or physical, that they are addressed in their own area, not a long way away. So having Indigenous-led programs, and we've been told this all around the country by every Aboriginal organisation, the problem we have with it is that some are funded every now and then. They're periodically funded. They don't get funded constantly, and as soon as they get it up and going, it falls over because of the lack of funding. So we've seen some programs get up and work like that, but we need to, it's a highway, isn't it? It's out-of-home care, juvenile detention and then prison. So we've got a main highway and we're not addressing that highway because it's a political thing that people get votes on saying it will lock up more people, like you said before. So, and it's not a thing that we feel like it's let down. It's institutionalised towards us.
I've got to apologise for my question because actually what's not needed here is a magic wand. What's actually needed here are politicians who care about kids and listen to the evidence and want this country to be safer and better. That's actually not asking for a magic wand. That's just asking for politicians to do their job, isn't it?
To be reasonable. And we've seen We've seen in the last 20 years it go downhill because politicians can come out openly now and say, we'll lock more kids up, we'll make this place safer. There's no evidence to prove anywhere you go that locking kids up makes the place safer. Locking the kids up makes them worse. Having programs to address the issues makes it safer. Prevention makes it safer, not prisons.
Yeah, thanks, Uncle. Thanks, Shane.
Thank you very much. Senator Cox, did you have...
Yes, I do. Thank you, Chair.
Excellent.
Thank you for appearing today. Can I start with Sitara? You've, based on some of the conversations that you've had with young people that have told you what we've needed, what sort of upstream and sort of more community-based programs should the Commonwealth Government fund or be looking into?
So as Mr Dillon said, I think a lot of Aboriginal organisations that already exist on the ground, like particularly in the Northern Territory, which are run actually by ex-offenders, if we can put that term on them. They're people that have gone through the system and understand what it's like to empathise with a child that is currently going through that. But one of the things that I hear over and over again, it's short-term funding models, it's bending to the political will of whoever's in government at the time. They're really, really unsustainable, and that's not actually how you prevent a child from re-entering the justice system. So more of those community grassroots funding structures would be really good. But maybe whilst I have the mic, I also kind of want to mention that none of these issues exist in a silo, as has been said. These are systems that need to be fixed around, around the country. And I think one of the biggest things is because governmental departments operate in such silos, a child is forced to recount their trauma again and again to separate departments. And I just quickly want to share the story of a young person I met in Alice Springs. And I think this story really perfectly illustrates where all these systems have kind of fractured and therefore have led this child into the youth justice space. So this child is the primary caregiver for their elderly grandmother. Firstly, the family's prepaid power card runs out because the electricity is cut, and right away we encounter the first system, which is a failure of our basic infrastructure and social safety nets. And then because the power is off, he can no longer refrigerate his grandmother's essential medication. So he's left as a child basically trying to manage a medical crisis entirely on his own. Again, now we see a profound failure of our healthcare system to support vulnerable patients and their young carers. Despite that, he tries to do the right thing, he tries to go to school, but because there's no family car and no regional public buses, he has to walk miles just to get to school. Encounter the third system, a failure of regional transport and community infrastructure. Finally arrives at school, he's exhausted, he's hungry, unsurprisingly, he falls behind, but the school doesn't see him as someone in crisis who needs wraparound support. In fact, it sees a behavioural problem, so he's pushed out of school. Fourth system, an education system that's ill-equipped to look past those symptoms. And finally, because he's out of school, he's on the streets and he has to do what he has to do to survive. There's no third spaces, again, infrastructure, no youth hubs for young people to safely congregate. Police drive by, pick him up, he's in a cell for 3 days. That's the justice system. So you can see the way that these systems operating in silos are compounded to actually put this person in an unsafe position. So it's really about government working together in different spaces to make sure that child, despite being attached to 15 different services, is not having to deal with a very fragmented social system.
Thank you. That's really helpful. This committee has heard quite a lot of evidence that supports exactly what you've just said. I also know from both my own experience around young people's first experience with police, and I'm wondering whether you could tell us what you heard from young people around how their first contact with police may have been a different experience had they have been in stable housing or had different levels of support. Whether they were still in the education system, things like that also speak to your evidence you've just given around some of the fracturing of those systems.
Absolutely. So again, as I kind of said in my opening statement, one of the experiences a young person who I talked to had with the police was literally to be searched in a cell. Just them, a male police officer, they're 14 years old, without any warning, no care, no instruction, just strip searched. I mean, that is a form, I think, of torture to a child and a big form of psychological torture. The other thing to say is I think the way that police also treat young people with disabilities in this space is really appalling. I spoke to a young deaf family where the young man couldn't physically hear a command from or a directive from a police officer behind him, and the police then tackled him to the floor. And it's only because a young man's sister, who spoke sign language, was nearby that she could actually translate what was going on. That is just a fundamental... I mean, how does that happen in a civilised nation? How is it that you're deaf and you cannot hear something, but that's licensed for a violent person with, weapons to come and tackle you? That's extremely traumatising. So I think much more sensitive care needs to be taken by our frontline responders, and obviously cognizant that police do have to deal with a lot, but ultimately at the end of the day, if you are a 10-year-old child, if you're a 14-year-old child and someone is coming at you with a weapon, that is an extremely stressful situation. I think it's really important, or one thing that young people were telling me is that they would like more psychologists, more social workers, more medical workers actually on site with police as well, so that they're doing it in tandem and they understand. But again, I'm sure this committee has heard a lot about things like racial profiling, where you are based on your, area of town. If you're in a place like Penrith in Sydney, you're more likely to get picked up than you are on the North Shore. It's very, very obvious kind of discriminating factors like that. If you're going to school, if you're in a school uniform versus if you're not, those are things that police will discriminate based on. The other thing I also want to mention is bringing it back to what I was saying earlier about third spaces and a lack of those safe places for young people to be. I was speaking to a lot of people in regional parts of Australia who say there's only one library that's open. We're going there because it's safe, it's warm, it's lit, there are people around, but the police will so often come on and try and move us along because we're seen as a threat to other people just for existing, maybe looking a little bit more dishevelled than others. Like that to me feels like a form of discrimination. And what do? You push them onto the streets, they'll get picked up again. I think it's, again, all about this wraparound support, having more third spaces, having more places for young people to go so they don't have to resort to being on the streets and being picked up by the justice system.
Thank you. I'm going to move to Uncle Rodney. In this submission from Amnesty International, it mentions the sort of growing reliance in Queensland in particular around adult watch houses. Can you help explain to the committee why these are such, I suppose, for young people, vulnerable young people, what puts them at risk by being and having an over-reliance on adult watch houses, what that does for a young person?
Look, I think that there's many things that it does for a young person. The fear of going into an adult watch house for a start, the fear of while they're in there, they're on alert 24 hours of the day, they're not sleeping, people are yelling at them and screaming at them. These kids are scared in this place, a place where they should never have been. Nowhere else in the world do they lock kids up in adult watch houses. This is the only place in the world that does that. And I just see these kids, we've spoke to these kids when they've come out of there, and they're terrified. And it's about stacking them. We're stacking kids in adult watch houses in Queensland and in Northern Territory as well. It's no place for our kids to be. And at the end of the day, the other kids that are a bit older, I've been in a police watch house. What more can they do to me? How much more can we do to the kids that have got the most vulnerable kids in this place? How much more can we do to those kids but put them into an adult watch house? Yeah. There's not much more than we can do than that, is there? So I think that the fear, the scaredness, the yelling and the screaming at our people, their lack of sleep, the lights are on 24 hours a day, and these kids come out of there terrified of this place. So I think there's a lot that goes into our kids in this system.
Absolutely. Also, you've spoken at length, I know, and even within this submission, talking about the intersection of out-of-home care and youth justice. If you'd like to elaborate for the committee, but also what is the other support that's needed for kids in the out-of-home care system?
We need the Aboriginal community that's in that area to have a better relationship and to be funded to work with these kids rather than having them in out-of-home care. We've seen out-of-home care not work for so long. Why don't we've seen all the Care Bears about the place that we've got, all the religious groups that have taken our children continuously. We've still got these places. You go into an out-of-home care place, you see a packet of cornflakes, a toaster and some Vegemite on the bench, and that's what care is, out-of-home care is for our kids. These are not out-of-home care. Then you go and have a look we was at Halls Creek and we was at Fitzroy Crossing, and they had a place there for the kids. Oh, Mr. Green was taking the kids out onto country and talking about this country, you belong to this, your blood's in this country, and you've got responsibility to your family to stay on this country and look after it and repair this country from the damage that's been done to it, compared to a kid in an out-of-home care where there's a packet of Kellogg's and Vegemite and toast. Two completely different scenarios of kids being treated in two different places. The kids come away from where they was with old Mr. Green. They've got responsibility to their country. They've got culture. They've got language. They understand their food system and they understand who they are and where they come from. Out-of-home care doesn't do any of that to our kids.
And that's the Euroman program, is that correct?
Yeah.
Uncle Rod, yeah.
Yeah.
Great program, and I think somebody already mentioned it in their evidence previously. Are there any
There's another case. There's another one that was in Queensland at Mount Isa called the Mona program. It was a horseman's program that they had there, taking kids out onto country and teaching them how to ride horses and how to look after horses and look after the horse and look after himself. But they defunded that, and they've tried to start that one back up, just up from Tennant Creek again, a lady called Angela Salmon, but no funding to do it. But there's funding to lock the kids up in out-of-home care.
I was just about to ask if there are any other programs that are Indigenous-led and that do provide, and the equine therapy stuff is something that I know also operating in the Kimberley. But if there's any, and I'm happy for you to take this on notice if you wanted to give it to the committee later on.
There is the ones, there's a couple in Northern Territory in Darwin, and also the Land Council taking the rangers out, taking kids out as young rangers. These are programs that divert kids away from there. When they go back to their country, they're doing burning, they're doing ceremony, they're doing everything that their old people done, changes the kids completely. So I think that there's many programs that have worked around, but we could give you plenty of those programs, I think, on notification.
Be great. Thank you very much. That's all for me, Chair.
Thank you very much for that. And we are sort of spot on time. I will use the last couple of minutes, if that's okay. And I guess we have heard a lot of evidence over the course of this inquiry so far. And I think you've spoken a bit about the early interventions, all of the different things that we can do for young people. If there was, I guess, one recommendation that you would say to us, you cannot not have this in your report, what would it be? And if I can just get each one of you to tell us what your wish list would be of that one thing.
It's not a wish list, it's something that should be done.
Yep.
It's the $1 billion we spend on locking kids up with no results.
Yep.
We want results for that $1 billion, and we want half of that money put into prevention.
Okay. That's an excellent... Are there any others?
I'll let...
I would say that rather than a wish, it's the absolute bare minimum. It's to stop investing in solutions that don't work. I think the ask is to end the incarceration of children. No child belongs in prison, and it's to commit to an action plan for ending that incarceration. I think that starts with two things: raising the minimum age of criminal responsibility to at least 14 years old without exception, without the introduction of new police powers, and raising the minimum age of detention to 16.
Excellent, thank you.
Yeah, very finally, I'll just say fund the community. It takes a village to raise a child, and if that village is fragmented and left without resources, it cannot do that. And where we've seen governments step back and not actually provide the duty of care that they owe to children across Australia, we've seen the communities across this country so amazingly step in, but they are underfunded, they don't have resources, they operate on short-term funding models. So it's really important to build the grassroots movements and communities that actually support these kids and are the ones that these children trust enough not to, reoffend or go into prison in the first place. So yeah, go into the heart of Australia, see who needs the funding and direct it there.
Excellent. Thank you.
Can I have this? Can I have another one as well?
Of course.
The other one was Amnesty. Amnesty has had 200 people sign a petition to raise the minimum age to 14 to meet our international standards that we're supposed to be meeting in the first place. It's not a wish, it's a recommendation.
Yeah, excellent. Thank you very much, and thank you all for taking the time to give evidence and the work that you're doing with young people in the community. Incredibly challenging stuff, but I think we've sort of all got a picture of hope from this. There are so many incredible people out there doing amazing work for young people in Australia, and we're very grateful for that. So thank you very much. With that, you are released, and we will suspend until 10:45.
Thank you.
Thank you, Chair. Thank you.
I now welcome representatives from the Australian Child Rights Task Force and the Australian Research Alliance for Children and Youth. Thank you for taking the time to come and speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could I get you each to please state your full name and the capacity in which you appear? And we might start with Mr. McDougall. Have we got Mr. McDougall? We might come back to him. Dr. Kinner?
Hi, Professor Stuart Kinner, Head of the Justice Health Group at Curtin University and Murdoch Children's Research Institute, and also a member of the Australian Child Rights Task Force.
Thank you. And Mr. Valvasori?
Hi, my name's Adam Valvasori. I'm the Advocacy Lead at RACI, Australia's Research Alliance for Children and Youth.
And then Mr. McDougall, do we have you there? It doesn't seem like we do. Do either of you have opening statements that you would like to make before we move into questions?
I do.
You do? Did you say?
Yeah.
Yes, please, commence.
Yeah, hi. My name's Adam from RACI. I'd just like to say that every child arrives in this world ready to thrive. No child is born bad. Crime is a symptom, and it is a sign that systems meant to support them have failed. That failure is the root disease, and we need to diagnose it, treat it, not just punish the symptom. We see this in what we call the pathway to justice contact, where a child is pushed out of school, a young person is cycled through out-of-home care, and too often the next stop is the justice system. This is not about who they are, it is about earlier systems that let them down. Experts call the answer to this proportional or progressive universalism, and it is a true public health approach to prevention. RACI created a systems reform agenda since our submission, which is on our website, and I invite the committee to have a look at. And it includes a tool that we presented at the recent JRI conference that uses a public health framework combined with the NEST, which is Australia's most widely used and evidence-based child wellbeing framework that RACI developed 10 years ago. It already maps the conditions every child needs to thrive, and governments trust it. It helped shape the Australian government's early years strategy, released in 2024. Different states and territories and local governments use it as well. It's NGOs, and it's where justice must start to in the earliest years of a child's life. Early screening, so problems are caught before they take hold, maternal and child health nurses, visiting homes for the first 2 years of a baby's life. It's not a soft option, it's how we build safety in communities. We're asking for a Cabinet Minister for Children with real oversight across every portfolio that touches a child's life. One clear line of accountability, so there are no kids caught in gaps. National Cabinet already shows this cooperation is possible. It's brought every government together behind a national plan to end violence against women and children. That same standing responsibility is needed now for children in detention. However, right now, children in other youth prisons are being strip searched. The New South Wales Ombudsman has called these searches oppressive and disproportionate to any risk. We cannot claim to be ending violence against children in one system while allowing it in another. We're asking National Cabinet to treat child safety and wellbeing as a standing national responsibility in every portfolio in every state. First Nations communities must lead the design of what comes next, backed and trusted by government. And children and young people and their families with lived experience too must be given a seat at the table to shape what comes next. We ask this committee to back RACI's recommendations and use the NEST as a blueprint for real reform. Thanks.
Thank you very much. Mr. McDougall, I can see you're back on the screen again. Are you able to speak? No? Okay. We will move straight into questioning, and I might start with Senator Shoebridge.
Thanks very much, and thanks for your submissions. The NEST approach has been raised in a number of different submissions as a kind of thematic structure for the Commonwealth to adopt and maybe force states and territories to adopt. Do you want to take us through where it comes from and maybe examples of it working?
Yeah, thank you. It was developed in 2014 through exhaustive consultations with child development experts, thousands of interviews and surveys with children and young people, peak bodies, including First Nations peaks, were consulted, and what was developed was these 6 domains of wellbeing. They are valued, loved and safe, healthy, learning, positive identity and culture, and material basics. And the idea is that they're all interconnected and influence each other. And we need to make sure that all of them are being addressed for children to thrive. And it's a good way of, I guess, scanning. And Aracy has used it in local government context, as well as as mentioned, the early years strategy to kind of create that framework to make sure that there's no gaps. And we think that this could be a really good tool to ensure that when we're looking upstream, where the gaps lie. Participating is another one, where, we need to provide pro-social opportunities for children. Local councils, for example, create playgrounds by the dozens that unfortunately age out after the kid reaches 10 years old. What happens for the young person or child after that? So kind of spotting those gaps across the domains and using that as a structure. And we're happy to give the committee our systems reform agenda, which sort of goes into more detail how at every primary, secondary, tertiary level of intervention, we've kind of mapped some suggestions that are already existing in Australia that can be used.
I think that would be terrific if you could provide that on notice. I'd really appreciate that, Mr. Valvasori. Yep. Now, I think Mr. McDougall is back with us. In terms of the NEST approach, do either Mr. McDougall or Dr. Kinner, do you have any view about that, and maybe how it relates to some of the examples we've heard evidence about from Hawaii, Scotland, and even places like New York? Do either of you want to contribute to that? We might go first to you, Mr. McDougall, and see if sound's working.
If I may, I would say that
Kinner,
I don't have anything to add to the NEST model except to say that it seems very sensible to me, but the one reiterating the submission we made to the original inquiry, it's really important that we don't make the mistake of framing these issues in an either-or way. In other words, prevention absolutely, but not instead of investing in care for children who end up in detention.
Well, do you want to talk through that with a little more sort of granularity? Because, of course, I doubt we're going to abolish child prisons overnight. So actually doing those two things together seems to me essential. But do you want to speak to that in more detail, Ms. Kinner?
Sure, very briefly. So, I mean, essentially it's saying that we can and must walk and chew gum at the same time. So clearly keeping children out of detention as much as we possibly can should be the top priority. But there's no reason why that should be in any way at the expense of investment in the care and circumstances for children who do move through detention. Now, I can talk from a health perspective primarily. James, I'm sure, is trying to get his audio sorted out, and we'll talk more broadly from a child rights perspective. But, for example, we have no national standards for healthcare for children in youth detention. Our group is currently doing work reviewing the legislation, and I can tell you that the only jurisdiction that legislates equivalent care for children in youth detention in Australia is the ACT, and some jurisdictions have absolutely no legislative basis for providing any adequate care for children in youth detention. So if we can't get the legislation right, that's not a good place to start. Above and beyond that, there are no meaningful guidelines or standards for the provision of healthcare, and that includes conditions to promote health for children in youth detention. And then there is no investment of any sort at this stage in monitoring against any standards, even if they were to exist. So it's essentially a complete black box, and we're flying completely blind. Now, that's not to say that any particular jurisdiction is doing well or badly, but Amber claims that any evidence, I would argue, are insufficient.
Well, we heard from Ms. Uthaya Kumaran from the UN Youth about girls in detention asking for medication, asking for medical assistance and being refused or ignored. Should we treat that as a sort of unusual anecdote, or is that evidence of a more systemic problem?
Look, I would suggest I'm a researcher and I come from the place of evidence, and I think the problem is everybody can give you an opinion, but nobody can tell you for sure. What we need, and it's not rocket science, what we need is routine, rigorous, comprehensive and independent monitoring and public reporting of conditions in youth detention. It shouldn't be a matter of different people giving their opinion.
Well, doesn't that start with the Commonwealth enforcing our OPCAT obligations, and particularly on the three largest states who just seem to be, recalcitrant, refusing to put in place OPCAT monitoring mechanisms?
Look, absolutely. Our OPCAT obligations are a terrific place to start. My understanding is that meeting those OPCAT obligations is, from a health perspective at least, not sufficient in that there's not enough granularity in those. So these are children often, in fact nearly always, with very complex health and psychosocial needs. If they were in any other setting, like out-of-home care, for example, or any other institutional setting where we purport to provide care for children, there would be clear and comprehensive clinical guidelines to ensure that we're caring for them in an optimal way. So OPCAT absolutely in all 8 states and territories should be the start, but it's not the entirety of the solution.
In the absence of states and territories moving, one of the other options would be for the Commonwealth to simply legislate that any child in detention is entitled to the same level of health care that they would receive outside of detention, and legislate that right. That doesn't seem to me to be... I doubt the pillars of the Federation would fall if we legislated to that.
And I will defer to James, who hopefully has his audio now, from a legal perspective on that one.
My apologies.
That's okay, James.
I think... Are we working?
We are. We can hear you.
Oh, thank God. So sorry about that. And I'm sorry, I haven't heard any of the conversation so far.
Mr. Kinner was telling us about the fact that only one jurisdiction in the country, which is the ACT, legislates an equivalent standard of healthcare inside youth detention as happens in the community. And my question was, well, if states and territories are unwilling to even legislate that basic standard, the Commonwealth, one of the options would be the Commonwealth could legislate it as an obligation across the country. I was asking your opinion on that.
Well, we would support that. That's the main thrust of our evidence to this inquiry, that at this stage the case for reform has been made. There needs to be some response. It is the federal government's responsibility. both in implementing its international human rights obligations and also in terms of the lack of attention to best practice on the part of state and territory governments. So there has to be some mechanism that the federal government takes responsibility for.
Dr. Kinner, I'm sorry for stripping your doctorate off you in how I addressed you. There is such resistance, though, to the Commonwealth even doing these basic measures. Like, there is such widespread political resistance, and I would have thought it's hard to work out what the kind of principled opposition would be to the Commonwealth legislating to say no state or territory can torture children, and every state and territory needs to provide medical care and assistance for children. But those propositions, I think if I took it to the floor of the Parliament, would be voted down en masse by with political resistance. How do we explain that, and how do we overcome it? Dr. Kinner?
I'm not sure if it's appropriate to put a Zoom hand up in the Senate.
No, it works really well. It works really well. Yeah.
I guess, again, I'm not a lawyer, but the observation I would make that where I see these things fall down is failure to distinguish between the what and the how. So detention settings, all custodial settings, are qualitatively different, and so implementation of equivalence is complex in those settings. And so I would suggest that, a legislative obligation to provide equivalent care is great, but then there needs to be some very informed discussion about exactly what that means in practice. So, for example, it's a nurse-led model in custodial settings. So, there's differences around information systems, a diversity of things that mean equivalent doesn't mean the same. And therefore, where does the legislation stop and where does the interpretation of the legislation to ensure equivalence begin?
Legislate and validate. That's required. Yeah.
And if I may, use whatever existing measures and whatever existing initiatives there are to start to develop the intent to move towards that. And by that, it could be having another go at implementing OPCAT more comprehensively. Mm-hmm. It could be looking at child-safe standards and how they might provide an overarching covering piece that the state and territory governments have already committed to. And then it is what we've also recognised in previous evidence, that there are levers, financial and otherwise, that the federal government can do to engage state and territory governments in an ongoing basis. And we'd argue that could be done and should be done in this space.
Extend OPCAT to also be opt-care almost. Like look at what current institutions are in the field, and rather than create entirely new bodies if we want to move from here.
And in fact, child-safe standards are based upon child rights principles. Yeah. They use a public health model, they use child rights principles. They've already been committed to. It's about monitoring the effective implementation of child-safe standards across all functions, including functions of government, which includes youth justice systems.
Yeah, Mr. Valvasori?
I was just going to say, you touched on the political risk, I think, that's apparent at the moment, that there's this perception of not wanting to be soft on crime, and we agree that community safety is really important, but child wellbeing is the answer to that, and addressing upstream drivers is the real sustainable solution, and the narrative and the framing politically needs to move that way. We believe, and I was working with the CEO of Yili Apinya, Aboriginal community-controlled organisation in Queensland that works on brain health and the connection between brain health and culture last week. And she says that the first time that a kid is kicked out of the classroom is their first sentence, right? So how do we close these pipelines? And politically, where is there the green space to move our attention, close those pipelines from child protection to youth justice, or from school suspension and expulsion and focus on those. I mean, it just makes sense.
Yeah, and you know, even if what the Commonwealth did was put a fund in place, a national fund in place, so that councils could keep their libraries open for longer. Their libraries open and staffed for longer. So libraries are open till 10 p.m. on a Friday night. Like a fund like that,
yeah,
given, you know, what would be, from a Commonwealth perspective, a really modest amount of money, would create all of these safe spaces for kids to engage in and to be safe, to be learning. Sorry, Dr. Kinner?
Look, just to add to that, I'm really pleased that the conversation is going this way to what we do and what we invest in the community for young people who may be at risk of ending up in the youth justice system. I would just add that we equally need to think about what's available in the community for those young children when they come out the other side. I mean, the median time in youth detention in Australia is 6 days. So it's a blip in the lives of children experience chronic marginalisation. And so just unfortunately, it's the only thing that catches them and they don't have a choice. You know, they can be disengaged from school, they can flee from out-of-home care. The only place where they go, where they don't have a choice anymore, is youth detention for 6 days. So investments in community supports to support young people's well-being are important, both for preventing them ending up in detention and for the 4,700 a year at the moment who do go there, to make sure they're not dying after detention, as we've shown they do at more than 6 times the rate of other children.
And that is a deeply disturbing figure, by the way, Dr. Gunn. But the evidence we heard yesterday from Children's Commissioners and First Nations Commissioners was that one of the things young people are saying to them is, well, you took me from a chaotic situation where the offending happened. I spent a time in detention and then you put me right back into the same circumstances. How did you expect that to work? And looking at the environment we're returning children back into has got to be a part of it, doesn't it? Yeah. Mr. McDougall, and then I think I'm out of time.
Okay, yes. Sorry, just picking up that point, and it may have been made previously, that this is something that needs to go beyond justice. It needs to be, and there are contributions and there are avenues in which this can happen. So to pick up Adam's point, there needs to be work done with child protection systems, health systems, education systems. Federal government has levers in those spaces. There needs to be some intergovernmental but also interdepartmental coordination at the federal level, and then start the conversations at a state and territory level in those spaces as well. That's why, for better or worse, the Child Safe Framework offers perhaps the broadest existing consensus that could be worked on. Monitoring remains a critical issue, and I'm hoping Stuart has had the opportunity to talk to you about some of the importance of that, but also the better data that sits alongside that. So moving from youth justice, we make the connections between the systems. We see youth justice as the endpoint that we want to avoid, and we improve systems across the board.
Yeah, thanks, Chair.
Fantastic. Thank you, Senator Shoebridge. Senator Stewart.
Thank you. I'm not sure if Dr. Kinner was actually going to make a contribution to that bit before the chair rotated the call. Looked like you wanted to say something.
If I may, just very quickly, and thanks, James, for flagging it, what gets counted gets done. So again, no matter how good our standards are, if there's no monitoring against those standards, it allows a perpetuation of what I see all the time in Australia, which is jurisdictions making terrific claims about the quality of their care without any evidence one way or the other. The AHW is piloting a mechanism for doing that, but with precisely $0 based on data that we produce for them with NHMRC funding. So while we're spending, 1.2, whatever the average is now across the country, million per year incarcerating children, we can't find $100,000 to develop a world-first system for monitoring the care for children in youth detention. It's quite remarkable. Second and last thing, the Productivity Commission report on government services is obviously a critical source for information about conditions. If you have not yet looked at their indicator framework, it's disappointingly thin, and to the very limited extent to which they talk about care for children and conditions and health status of children, those few indicators are under development. My group with the ASW made a submission to them saying we can help you with that, and to the best of my knowledge, there's not yet been any interest in the Productivity Commission in doing that. And I would offer to the committee that that's an instance of the soft bigotry of low expectations.
Thank you, and that does actually lead perfectly into my first question, which was asking about data. So very nice segue there for me, because there is data captured by places like the Productivity Commission, and the Oz Institute for Criminology. What I'm keen, because you kind of talked about there being gaps or it's thin. What are the things that you think that we're missing in the data captured to allow us to monitor it effectively?
Again, I'm coming from a health perspective. The short answer is nearly everything. If you have a look at the ASW, they have a very comprehensive report on the health of adults who are incarcerated, on the health services available for those people. In youth detention, there is none of that. There is deaths in detention, no monitoring of deaths after detention, as there is for adults. There is an aspirational indicator on self-harm, which is currently under development because it relies on states disclosing their own internal records for that, which are inadequate even if they do disclose them. And there is nothing else, no information on the scope of services in those settings at all. And furthermore, whereas the ROG's Corrective Services chapter used to report on healthcare expenditure in corrections, since 2018 they've sought to exclude them. The Youth Justice chapter is silent on that, so we don't even know whether the expenditure on youth justice in Australia is inclusive of healthcare costs or not, and it's most certainly not disaggregated so we can assess it.
Mike, I keep getting these email notifications up the top right of my computer. It's really annoying. I don't know if you can hear the beeping too. I'm hoping if I put my...
Senator, could I jump in, picking up one point that Stuart made and an example of something that the federal government could do, create a national child death register. There is currently no national collation of information about child deaths, the most serious outcome for children. There is an initiative that the federal government could pick up that would expand our data collection, share it across state and territories, and be effective in identifying the precautionary and preventative measures that could be introduced across the board.
And is this specifically for kids who have been in contact with the justice system, or is it thinking broader than that?
More broader than that. There is no national child death register. It's done in different ways in different states, but the information could be collated. It's going to assist your child protection system. It's going to assist your disability care system, and it's going to assist, unfortunately, now your youth justice systems as well.
And how do you see that would assist the work of governments?
Assist the work of government?
Yeah. Or
the federal government.
Yeah.
Well, it's going to be publicly available. It's going to inform research. It's going to allow for a lot of the work that is done at the state and territory level at looking at the circumstances of child deaths and looking at across the board. We like to think every state and territory is different, but some of those lessons are going to be common across the country.
Yeah, and there are, as you said, there are places where some of this is already captured, like kids who are in contact with the child protection system. That's captured.
Yeah, there is so much information out there. It's just we don't have the coordination mechanisms, we don't have the information sharing mechanisms, and we don't have the levers that federal government could do to promote better practice across the board consistently across the country.
Yeah, and the levers are information sharing that kind of allows...
That's the start, and hopefully there's a common cause in wanting to prevent child deaths. In youth justice, we struggle to do that, but if we look at the measures where those opportunities exist, pick them up and use them. But it does require a level of coordination at a federal level, and ideally some independent monitoring and oversight across the systems to drive it.
Yeah. And what would the independent monitoring do? Or that it's real?
Yeah, well, once again, I mean, in an ideal situation, we would look at something, the children's commissioners would have proper funding in order to be able to collect and collate this information. Okay, we can't get there straight away. There are existing systems, as Stuart's point out. There is data being collected, but it's not necessary. There is no national responsibility taken for the collection of that data and sharing it back to state and territories. Ultimately, it would mean, hopefully, far less duplication of work across jurisdictions. And it's a fairly light touch, relatively affordable measure that the federal government could do that's going to improve the lives of children and communities across the board. I'm pretty sure there would be significant support for it in Aboriginal communities. We need to think about how we do it most sensitively and use Aboriginal communities' own data collection systems, but they feed in and you address a whole range of inefficiencies or barriers that exist because you have a number of agencies and governments all committing to collecting information, with the national government also taking responsibility for ensuring the data is consistent. And not leaving it up to the Productivity Commission to try and sort through these inconsistent data sets and try and work out what is actually the nationally consistent data. And that's the problem, once again, in child protection and education. And I'm not an expert, but I expect it happens in health as well.
It is, I mean, it's certainly, we've had the Closing the Gap agreement for a little while now, and we still don't have a nationally consistent way to capture family violence. And so, I suppose I say that to point to the challenge that we have in coming up with something that where every state and territory can agree on what it is that we're measuring or capturing. Even is not a simple task. Even if it sounds simple, and I'm not suggesting that you're saying that it is. I want to move to the restorative justice models that you talk about in your submission. I suppose I'm interested in what evidence you're drawing on for the restorative to say that the restorative justice models are working well in Australia. And I suppose, and not only, but I'm interested in, I suppose, the kind of more serious end of offending as well. Like what's the evidence to say that they work well in those instances too?
Should I answer this, or Adam, have you got something on restorative justice? Okay. So the evidence is largely international. The database around restorative justice programs exists. It's not comprehensive. It's not coordinated. I'm not sure. I thought the Attorney General's Department was actually looking at that issue. I could be wrong about this, but there have been restorative justice programs that have funded through Attorney Generals. And my understanding is there is going to be increasing efforts to ensure that some of that, getting the findings and ensure how they apply. To your point about serious crime, I think that is a significant question, and I think the international evidence says, understandably, you have to be a whole lot more careful about applying restorative justice programs to serious crime settings. But at the same time, youth justice spaces are often the chance to do that because you have better prospect of turning things around for young people as offenders. And that is, once again, an international principle, and one that's reasonably well understood in Australia as well. But it's, once again, getting beyond the alarmist community safety debate to having a proper community safety debate about what works and what doesn't, and that's your question. And there is international evidence, there is some Australian evidence, but we could have a whole lot more.
Yeah, there is a lot of alarmist conversations that happen around youth justice.
You dig deeper into youth justice systems at a state and territory level, and they will have their own evidence about this. They know this as well. It's just often the political imperatives override their ability to promote that good practice in their own jurisdictions.
And it is, anyway, like, I suppose what I reflect on is that people have, real concerns about their sense of safety in their own suburbs or streets or whatever that might be. But the answer isn't necessarily then to put them into a justice system that does more harm and leads to more youth offending and crime and more unsafe communities.
And just very briefly, my experience some time ago working in restorative justice for the New South Wales government was often you have the opportunity to have those conversations at a local level, and you find victims who say, oh, okay, so I wasn't being targeted. I now understand what's happened. Okay, we've got to do something to help these kids. So at a really individual level and at the community level, if you create the space for those conversations, they can be a whole lot more constructive than the media would lead us to believe.
Thank you. I've got a couple of questions for Aracy. I think you point to in a submission that Australia's spending $22.3 billion on late intervention. What would it cost to fund the primary prevention approach your submission recommends instead?
I'm not sure. I can take that on notice. I don't have the figure on hand at the moment.
That's completely fine. Yeah.
But I think what you're talking to is the cost of late intervention report that was put out by the Front Project last year.
Oh yeah.
And it says that $15.2 billion is spent every year on late intervention, which equates to $607 for every Australian every year. And that youth crime is the biggest, or second biggest, 2.7 billion, child protection 5.9 billion cost there. So there's a big dollars. And to your earlier point on restorative justice, there are international examples that exist. We have local First Nations communities that have answers as well. That it's not a knowing problem, it's a doing problem. Where's the pilots? Where are the, away from prying eyes that can actually prove that that restorative justice works, and then scaling it up, showing that it's an effective model for a community. Those place-based solutions are the way to go to get it right. Yeah.
Yeah, and I don't disagree that place-based solutions are absolutely a part of the answer here. Your response in the couple of minutes that I have left, your submission cites a Banksy Hill study finding 36% of detained young people have FASD and 89% have at least one domain of severe neurodevelopmental impairment.
Yeah.
Is there an existing program in Australia or overseas that Aracy considers a model for diverting neurodevelopmentally impaired children out of the justice system rather than just identifying them with it?
Yeah, it's just so staggering that these conditions are being picked up at such a late stage. How many different systems have they fallen through? From paediatrics and health to school, for it to be picked up at such a late stage. I mean, we talk about the primary, secondary, tertiary health interventions, and we imagine the primary health intervention as the fence at the top of the cliff that stops the child from falling off the cliff. It's the easiest, most cost-effective, most humane way of going about it. It's available for everybody. And if by some weird circumstance a child still manages to fall off the cliff, they should be caught by a net. Those early interventions, and not by this, and not let through to fall to the ambulance at the bottom of the cliff, which is very expensive to maintain, not really effective, I can't give you the cost of the reverse that you asked for, but I can go and find it for you and treat that as a question of notice.
Thank you. Appreciate that. And that does bring us very close to 11:30, which is the time we have with you. So I'll conclude my questions there. Thank you very much for your time and the evidence you've given to us this morning. Appreciate it.
Thank you very much, Senator Stewart, and thank you for helping us to stay on time. Thank you very much for taking the time to speak with the committee today. I know there was one question that was taken on notice, which if you could get back to the Secretariat within 2 weeks, that would be very helpful for us, and we would appreciate that. Also, if there is anything that you think you would like to add, or you think I should have said this, or this is a better response to a question you've had, please don't hesitate to email the Secretariat. We'd be happy to also consider that. But we very much appreciate you taking the time to speak with us, and very grateful for the work that you are doing for young people in our community. So thank you. With that, you are released. Thanks very much.
Thank you.
So I now welcome representatives from the Salvation Army, Your Town and UNICEF Australia. Thank you for taking the time to speak with the... we got...
We're here.
Okay, sorry. No, that's okay, sorry, we're welcoming... I will correct the Hansard with that. I'm now welcoming representatives from the Australian Indigenous Doctors Association, the Royal Australasian College of Physicians and the Royal Australian College of General Practitioners. Thank you for taking the time to speak with the committee today. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, if I could please get you each to state your full name and the capacity in which you appear. And we might start with Dr. Malouf.
Hi everyone, it's Dr. Peter Malouf. I'm the Chief Executive Officer for the Australian Indigenous Doctors Association.
Fantastic, thank you. Dr. Kennedy.
Thank you. My name is Niroshini Kennedy. I'm a paediatrician and I'm here as President of the Paediatrics and Child Health Division of the Royal Australasian College of Physicians.
Okay. Dr. Fleetwood.
Hi, I'm Dr. Jacqueline Fleetwood. Please call me Jackie, and I am an emergency paediatrician and here representing the Royal Australian College of Physicians as well.
Thank you. Dr. Jones.
Hello, everyone. I'm Dr. Tim Jones. I'm a GP. I'm here as the Chair of Specific Interests in Child and Young Persons Health with the Royal Australian College of GPs.
And then Dr. Jennings.
Hello, my name is Kirsty Jennings and I'm here on behalf of the RACGP Aboriginal and Torres Strait Islander Health Council today.
Thank you very much. Did any of you have an opening statement you wanted to make before we proceed into questions?
Yes, I do.
You do? Please proceed.
Right. Thank you. Look, thank you, Chair, and thank you for the committee for the opportunity to appear today for this inquiry. But first, I'd just like to acknowledge the traditional owners of the land on which we meet and pay respect to elders past, present and emerging. And I also would like to acknowledge the Aboriginal and Torres Strait Islander children and young people and their families, communities and elders who continue to carry the consequences of the systems that too often respond late, punish early and then call that justice. The Australian Indigenous Doctors Association is a peak body that represents Aboriginal and Torres Strait Islander doctors and medical students with the purpose of growing ethical and professional Aboriginal and Torres Strait Islander doctors that will lead and drive equitable health outcomes for our people. And I'm here today to, from a public health and cultural perspective. I guess the question for this committee should not be whether children who cause harm require a response. Of course they do. Community safety is important and victims are important and accountability is important. But if the response to a child in crisis is detention, then the system has already missed several early opportunities to intervene. The safest communities are not built by placing children in prisons. They are built when children have safe housing, school connections, healthcare, and social support and cultural connections, and a meaningful pathway back to community. In health, we would never accept the logic that currently governs youth justice. If a child presents to hospital with serious infection, we do not wait until the infection spreads, then blame the child for being sick. We assess early, we diagnose, we ask what has been missed, and we will bring in the right specialists. We treat the cause and not only the symptoms. Yet in youth justice, too often we often see the opposite. We wait until a child distress becomes behaviour, we wait until trauma becomes offending, and we wait until disability becomes non-compliant, and we wait until poverty, racism, family stresses, and social exclusion becomes police contact. And then we ask the child to carry that consequences of the system that failed to act earlier. That is not the accountability, that is a system failure. The Productivity Commission of Closing the Gap data tells us that the Target 11 requires Australia to reduce the rate of Aboriginal and Torres Strait Islander young people aged 10 to 17 in detention by 30% by 2031. Yet, nationally, in 24-25, the Aboriginal and Torres Strait Islander young people were detained at a rate of 25.7 per 10,000 young people. The national trend shows no change from that baseline. This is not a marginal implementation problem. It tells us that the system is reproducing harm through new strategies, new committees, new reporting frameworks without delivering the structural change required. Australia has had inquiries, it has had royal commissions, it has had reviews, strategies, action plans and recommendations. The Royal Commission into Aboriginal Deaths in Custody had made 339 recommendations in 91. The Bringing Home report had made 54 recommendations in 97, and the Australian Law Reform Commission Pathways to Justice report had made 35 recommendations in 2017 to reduce the incarcerations of Aboriginal and Torres Strait Islander peoples and improve community safety. So the uncomfortable question is, will this inquiry have impact, or will it become another document received by government, acknowledged by government, and then quietly shelved by government? That is a government question, it is a public integrity question, and it is a child safety question. It is deeply concerning that the federal government has rejected key United Nations recommendations to raise the age of criminal responsibility, legislate a National Human Rights Act, and better protect the rights of Aboriginal and Torres Strait Islander people. This matters because these are not abstract international obligations. They go directly to the safety, liberty, and health and well-being of Aboriginal and Torres Strait Islander children. If government can create national principles in child safety organisations, then these principles must apply most strongly where the state has greatest control over the child's life. In detention, the state controls the child's movement, healthcare, education, and cultural connection. If youth detention does not promote well-being, uphold rights, listen to children, and protection connections to family, kin, and culture and community, then we cannot call itself a child safe. A health first model would start before criminalisation, and it would require appropriate screening for disability and neurodevelopment concerns and mental health and social emotional wellbeing and cultural disconnection. It would require Aboriginal and Torres Strait Islander led services to be funded as essential infrastructure and not discretionary programs, and it would place elders and community at the centre of the response. A health first response does not mean doing nothing when harm occurs. It means doing what is more likely to prevent harm from happening again. And restorative accountability, early intervention, and cultural connection. They are evidence-informed and fiscally responsible and ethically necessary. A punishment first model allows government to say that a child has failed without asking whether child protection, health, education, or the system in general has failed them first. It also avoids asking whether racism has shaped the pathway into custody and whether government failed to listen when communities repeatedly told them time and time again what is needed. This committee should recommend a national health first legislative framework for youth justice. Before the states criminalise a child, it should require and demonstrate a child's health development, family, cultural and social needs have been properly assessed and responded to. The Commonwealth should lead a national consistent framework by raising the minimum age for criminal responsibility to 14, aligning the youth justice reform to the Close the Gap target 11, as well as embedding the priority reforms around strengthening Aboriginal community controlled. But there is one more issue the community must confront, and where are the voices of children and young people in this debate? We speak about them, government legislates for them, police process them, courts sentence them, and departments detain them, and systems assess them. Inquiries examine them, but how often do we privilege their voices? If this country is serious about reform, then it must be useful to actually listen to children and young people with lived reality in this space, not as a token consultation, not as a case study, and not as a paragraph in a report, but as people with knowledge, rights, experience, and solution. Give them a voice to this Parliament. A real mechanism should allow children and young people, particularly Aboriginal and Torres Strait Islander people, to speak directly what safety means to them, what support is missing for them, and what would have helped them earlier, and what governments still refuse to hear. Because we don't do what, if we do not do that, we lose another generation. We do not want to lose another generation of Aboriginal and Torres Strait Islander children removed from families and disconnected from culture and processed through the courts, placed in cells because governments had the evidence but lacked the courage to act. This committee has a choice. It can repeat the pattern of inquiry, acknowledgement or delay, or recommend structural changes that treat Aboriginal children first as children, not as offenders. And the evidence has been heard before, and the question is now is whether this Parliament is finally prepared to listen. Thank you.
Thank you very much for that. Did anyone else have an opening statement before we move into questions? Yes, certainly. Please proceed. Sorry, Dr. Kennedy. Yep.
Thank you, Senator. The Royal Australasian College of Physicians welcomes the opportunity to appear before the committee to provide expert advice into Australia's youth justice and incarceration system. The RACP represents more than 34,000 physicians and trainees across 33 medical specialties in Australia and New Zealand. We are the sole accredited provider of specialist training, paediatric training in Australia and Aotearoa, New Zealand. Many of our members work directly with children and young people at risk or involved with care and protection services and the youth justice system. My name is Dr. Niroshini Kennedy. I'm a general paediatrician specialising in developmental paediatrics, and I am president of the Paediatrics and Child Health Division at the RACP. I am also a paediatrician working at the Royal Children's Hospital in Melbourne and for the last decade at the Victorian Aboriginal Health Service in Melbourne. At that service, over 60% of the children that I see are in statutory out-of-home care, and that clinical work has informed my policy and research work into providing better models of care for children involved in the child protection, out-of-home care and youth justice systems. I'm joined by Dr. Jackie Fleetwood, a member of the RACP's Aboriginal and Torres Strait Islander Committee of the RACP. She is an experienced paediatric emergency physician. The RACP strongly supports this inquiry. We recognise that incarcerating children and young people has significant and lasting impacts on their health, development and well-being. Evidence shows that the current system is failing vulnerable children, particularly First Nations children. Children and young people in the youth justice system have very high rates of neurodevelopmental impairment, trauma and mental health conditions. often alongside disability and complex social needs. Many have experienced family violence, poverty, homelessness, and involvement with the child protection system. As a paediatrician, I see firsthand how this early disadvantage shapes lifelong outcomes. Contact with the youth justice system should be a critical opportunity for intervention, including the opportunity for comprehensive health and developmental assessments, early treatment, and coordinated multidisciplinary care. However, as we know, access to appropriate healthcare in these settings is often limited, inconsistent, and delayed, and this exacerbates existing inequities. The reform that we must promote must ensure that all children entering the system receive timely, comprehensive health assessments and ongoing care that's delivered by appropriately trained clinicians and supported by integrated multidisciplinary teams. The RACP emphasises that youth justice is not solely a justice issue. Sustainable reform requires coordinated action across health, mental health, education, housing, child protection and social services. A multidisciplinary, integrated and preventative approach that's grounded in strong interagency collaboration and supported by continuous care and case coordination is essential in breaking cycles of disadvantage and improving long-term outcomes. Programs must be designed in partnership with children, young people and communities to ensure that services are person-centred, culturally safe and responsive to need. The RACP strongly supports raising the age of criminal responsibility to at least 14 years, with no exceptions, consistent across all jurisdictions. We see value in a nationally consistent approach and strongly support investment in this. Children aged 10 to 13 should simply not be in the justice system. They require therapeutic, health-led and family-focused interventions, not criminalisation. Paediatricians and adolescent and young adult medicine physicians are uniquely placed to provide care and expert advice to support appropriate reforms. The RACP is also concerned about the continued use of harmful practices within youth detention. Children must never be detained in adult facilities, and detention, where it occurs, must only take place in purpose-designed, trauma-informed and culturally safe environments that provide access to healthcare, education and developmental supports. Critically, detention itself should be a measure of last resort, with greater investment in prevention, diversion and community-based alternatives, which we understand are more effective in improving outcomes and reducing reoffending. I would now like to hand over to Dr. Jackie Fleetwood.
Thank you, Dr. Kennedy. So, hi everyone, I'm Jackie and I'm an emergency paediatrician and I'm currently working in Queensland Children's Hospital Emergency Department where sadly we're seeing more and more vulnerable youth in crisis every single day. I'm lucky where I work, we've got a Mob ED model of care which aims to achieve health equity by providing a culturally safe care pathway for our Aboriginal and Torres Strait Islander children and their families. The scale of inequity facing Aboriginal and Torres Strait Islander children in our youth justice system is enormous. These children are vastly overrepresented, and this reflects deep systemic failures. Although they comprise just 6% of the total population of kids aged 10 to 17, they represent 56% of those under child protection supervision and 60% of those in detention. This reflects the cumulative impacts of colonisation, intergenerational trauma, systemic racism and inequities across all of health, education and social systems. First Nations leadership must be at the centre of this reform. Services must be culturally safe, community-led and grounded in self-determination, with greater investment in Aboriginal-controlled community health organisations and a First Nations workforce. If we are actually serious about reducing these disparities, we must invest in early intervention culturally safe healthcare and community-led solutions that address the underlying determinants of health that are leading our kids to be involved in the justice system in the first place. I feel the key question before this committee now is how we actually build an alternative system that meets the needs of children and young people, because we are failing our most vulnerable people if we don't make this a priority. The RACP recommends that reform be guided by principles underpinning our medical specialist access framework, designed to increase access to specialists for Aboriginal and Torres Strait Islander people. Its principles include Indigenous leadership, cultural safety, person-centred and family-orientated care, integration, as well as continuity of care and strong accountability frameworks. Self-determination must be a core principle, ensuring that children, young people and communities have a genuine voice in the design of the services that actually affect them. And there should be strong interagency collaboration to ensure that there's sustainable case management for these children and clear pathways between health, disability, education and all justice systems, because when they break down, this is when the worst outcomes happen. We must ensure that the outcomes are clearly defined, measured and reported, including improvements in health, wellbeing, education and participation, not just in the justice metrics. If we are to create meaningful change, we must move away from a punitive model towards a system that helps support children to thrive. This means investing in prevention, early support, culturally safe care and evidence-based alternatives to detention. We thank you for the opportunity to talk to the committee and are happy to take any questions.
Fantastic, thank you. Were there any other opening statements? If not, we will move... One more. If I could ask you, Dr Jennings, to keep it brief, because I am conscious we are getting to the end of the time with this panel.
Yeah, absolutely. I'll try my best. Good morning, everyone, again. So, again, my name is Kirsty Jennings. I'm a Birrapah woman from the mid-north coast of New South Wales. I'm a social worker, a general practitioner, and the Deputy Chair for the Aboriginal and Torres Strait Islander Health Council for RACGP, and I'm here with my colleague Tim Jones today to talk about the RACGP's position. And listening to my colleagues here, we're coming from a health-first perspective from general practice. We acknowledge that Aboriginal and Torres Strait Islander children are at a disproportionate rate within custodial settings, and I acknowledge that we see this as a health issue, a human rights issue, and not a justice issue. We support the Raising the Age agenda. We acknowledge that by raising the age, we need to have wraparound services that are funded, resourced, and led by community and engage with community, and that these settings are available to everyone. There's accessibility, and acknowledge that inequity in access in more rural areas has led to increased rates of incarceration for younger children. Part of my role is as a staff specialist in a maximum security adult facility. And what I've seen there is the majority of the children who are incarcerated become broken adults in an adult system. These are missed opportunities we could have addressed in childhood by acknowledging complex health needs, the social determinants of health, children's interactions with racism, whether it be systemic, interpersonal, or even sometimes that internalised racism that we have when communities are stigmatised as being criminalised, as children are being told that they are defined as rather than expressing a health need that is being unmet by people around them. So every day I'm seeing these unmet needs in adults. And we are not changing how we are interacting with those. What we do is entrenching trauma, we're entrenching disadvantage, unmet health need, and I see it every day in the bodies of the people that I'm seeing in their chronic, complex health needs. And we're passing that on to another generation. So RACGP would love to see this as a health issue. Children have complex needs. We need to see children in a holistic manner. We need to see them for who they are, address those health needs, and we need to be making sure that we're reducing those numbers by using diversion programs, by making sure that we're involving community mentoring, and this should be Aboriginal and Torres Strait Islander led and assessed, and we as GPs are more than happy to support that program. We see children at the very beginning of issues at the beginning. So we're seeing children when parents aren't coping, when there's an unmet health need. So we're seeing them beginning, but what we need are those pathways, referral pathways to be strengthened, to work collaboratively with paediatricians, with emergency, to make sure that we're meeting the needs of the children. So we're not getting to this end where I'm seeing men who are broken by a system that does not support them or see them for who they are and passing that on to another generation. We need to stop that now by looking at this as a health issue, not as a criminal justice issue.
Fantastic. Thank you very much. If there are no further opening statements, we might move into questions, and I will give the call to Senator Cox.
Thank you, and thank you all for appearing before the committee today. Can I just ask, and I don't think it was captured in your opening statements, but how your organisation supports young people specifically in youth detention? So is there any arrangements across any of the jurisdictions that you currently have?
So working in emergency department, we as a senior medical group keep an eye out for frequent presenters, because these are often our children who are most vulnerable. They don't have one consistent adult in their corner advocating for their needs. There's often been a breakdown in the community coordination of care between housing, child safety, community health providers, and when that happens, if they're often brought in by the police or are incarcerated already. When that happens, we group together as a senior medical group, and we create care plans that essentially help streamline how we support and manage these children in their journey through emergency. But it feels very like we don't have oversight of community, and that's where the problem lies. Like, these kids are coming to us in crisis when they've got no other option, and they're not having their care needs met in community. And so we're trying our hardest from an emergency department, but it really does extend beyond the scope of emergency core business, but still we're doing it because we're feeling that there's just such a breakdown between all the key stakeholders for these vulnerable kids. But aside from having care management plans that clearly delineate what we should and shouldn't do in an emergency, that's really beyond our scope. We're also lucky, up in Queensland, we've got an organisation called MobLink, who, for our Indigenous patients, actually help break it. They're trying to increase the social determinants of health and make sure that we help these vulnerable youths have access to transport, regular like getting them to school, getting them linked in with a GP and a paediatrician. So that's really the approach that we have. But we still feel that every day we're seeing more and more youths, and it's not working, and we need more buy-in from the government.
Thank you. That's very helpful. To us, this committee's heard a range of issues that and evidence that young people don't have adequate access to healthcare. I'm from Western Australia, so FASD, particularly within Banksia Hill, has been a big focus, as well as I think someone touched on in their opening statement, mental health more broadly. But are there any other specific medical issues that you would be concerned about, that our children are not getting access to, both treatment but also, almost the through care model of ensuring that they have access to ongoing health plans and that continuation of care from your medical perspective?
I'm happy to answer that, Senator Cox, and thank you for the question. The RACP represents 34,000 physicians and trainees across a range of medical specialties, but also paediatricians, and it's a sole training provider for paediatricians. Across paediatric training, we have subspecialty areas in young adult and adolescent health, as well as developmental paediatrics, and that encompasses a number of the conditions that you've mentioned today, including intellectual disabilities, FASD, and other conditions that can affect, I suppose, it can intersect with a child's behaviour and offending. So many of our members work directly with children and young people who are at risk or involved with the care and protection services. But what our members are telling us, that quite often we see children far too late. when they have made contact with the criminal justice system, perhaps when they're getting kicked out of school, or for, in many cases, children in the child protection or out-of-home care system, when their placement has broken down. And what we know about these children is that many of these children have actually got undiagnosed health, neurodevelopmental, so FASD, ADHD, intellectual disabilities, or emotional and mental health conditions. And what we know is that they've often missed out on treatment and early intervention. So often when we hear the reason for not raising the age of criminal responsibility is that we don't have alternatives to manage children outside of the criminal justice system. But the reality is most of these children, these incarcerated children, have crossed over from the statutory care system. And what we know is that most of them have missed out on preventative health checks and early intervention. Data from a few years ago showed that the National Clinical Assessment Framework, which makes recommendations for health checks for children in out-of-home care, only 1% of Australian children were receiving health checks in accordance with those national guidelines. And we know that about 53% of children under youth justice supervision had contact with child protection within the previous 5 years. And that number raises to 64% when we're talking about Aboriginal and Torres Strait Islander. So one of the answers here from a health-focused lens is simply implementing the government's own framework that children involved with the child protection and out-of-home care system have comprehensive, preventative and holistic health checks.
Thank you. And that's a good segue, Dr. Kennedy, into my next question, which was what needs to change in relation to the screening processes of young people that are entering into the youth justice system for certain medical conditions. So from your perspective, what does that look like?
We have a good framework for the sort of health assessment, Senator, that these children need to have. And that framework is a Commonwealth framework called the National Clinical Assessment Framework for Health Assessments for Children in Out-of-Home Care. It was drawn up in 2011, but it still stands up very well. And it goes through an initial health check within the first few weeks of a child entering out-of-home care for a screening assessment with a general practitioner, and then a much more thorough assessment within 3 months with a paediatrician and a mental health professional and a speech pathologist. Now, that is a framework that should be implemented when a child enters the out-of-home care system. But as we've mentioned, that only 1% of children in Australia are currently getting compliant health assessments. That's a huge lost opportunity. And in my practice, many of the children who fall through the cracks are the children who haven't had the opportunity to have preventative health checks that might, for example, Senator Cox, identify that a child who is falling asleep at school and constantly late to school might actually have an undiagnosed sleep apnea and actually need surgical treatment for tonsils and adenoids. Or a child who may be supposedly not paying attention in class, they might actually have they have glue ear, may have undiagnosed glue ear and a hearing impairment that requires surgery. Or the child who might be, constantly on edge in class and perhaps a little bit difficult. Well, that might be a child who's living in a family that is experiencing family violence. And this is a heightened and traumatised child who actually needs trauma-focused therapy. And I could go on. There are the young people who haven't had learning disabilities, who are said to be failing school. They've never had the opportunity to have screening for dyslexia or ADHD and appropriate treatment in place. So the opportunity for prevention starts much earlier. And that opportunity is a missed opportunity in Australia because, as I said, while we have national clinical assessment frameworks, we don't mandate those health checks, and the responsibility, the accountability for that lies with the states. And because that is not as well measured as, in my opinion, it should be, that remains invisible and neglected. So one intervention would be simply, in my opinion, for the government to more strongly bring accountability to its own guidelines and frameworks and mandate those health assessments, measure them and report on them, particularly for Aboriginal and Torres Strait Islander children.
Thank you, Dr. Kennedy. That's helpful. I'm not sure. I'm just conscious of time that I will have to share the call in a minute. But I wanted to give the opportunity for any of your colleagues if they wanted to add to that.
Dr. Jones.
Thank you, Senator. I might jump in from the RACGP if that's okay. Just to share another element that we feel is relevant to this. In our submission, we presented that AIHW data from June of last year showed that 72% of young people in detention are unsentenced. And we really want to highlight that that is continuing a cycle of neglect of young people, but that it also represents an opportunity for providing some of that early recognition of unmet need, unidentified developmental vulnerabilities that is so key in providing proactive and nurturing support. As the RACGP, we provide accredited standards for health services for Australian prisons, but they are not involved in the accreditation of the prisons themselves. They are merely documents for the doctors and other health practitioners who work within those facilities to use as references. And hence we would call for mandatory accreditation of Australian justice facilities to be accredited against those standards to make sure that that quality care is delivered at a timely place in a young person's journey.
That's great. Thank you very much.
Thank you very much, Senator Cox. Senator Shoebridge.
Thanks, everyone, for your ongoing engagement and the work I know you all do, not just in this inquiry. Pretty much every medical practitioner, I think all of your submissions say we should raise the age, that 10-year-olds shouldn't be in jail. Can I ask you from a medical perspective, what's going on in a 10-year-old's mind when they're in a jail cell by themselves, they've been handcuffed, taken from their family, and they're there sitting by themselves in a concrete cell with no one to talk to, no one to love them? What's going on with a 10-year-old medically at that point?
I might start, Senator, but I welcome my colleagues to join me in this one because I think this is an area we feel particularly passionate about. A healthy 10-year-old is meant to be egocentric. They are meant to see themselves at the centre of the world that exists around them. For them to be surrounded in that environment of neglect, of violence, of potentially exposure to abuse and trauma in new ways, they are reinforcing in their minds that they must have the problem and that the issue that will be inherent in their life ongoing is a feeling that they are creating the situation to which they are now engaging in. The challenge we have for that young person is they are so dynamic. A well-placed conversation at that point to say, this is not your fault. You have opportunities to change. We are going to identify and support the needs that you have. That 10-year-old can end up on a vastly different developmental journey, but currently they suffer in silence.
Does anyone else want to contribute on that? No?
Thank you, Senator. It's really clear from what my colleague Dr. Tim Jones said that prison is not the right place for a 10-year-old. And I think the focus needs to be on understanding what has happened in a young person's life that at age 10 they have had contact with the criminal justice system. And I think that's where we as paediatricians have really tried to advocate for a health-focused understanding of this. And as I've illustrated, many of these children have undiagnosed neurodevelopmental disabilities. Many of them have intellectual disabilities. Some have fetal alcohol spectrum disorder. Many have experienced quite extraordinary amounts of developmental trauma and have experienced adverse childhood experiences which have affected the way they behave and communicate. Some have lived in unsafe environments and their behaviour needs to be in context of a failure of society to provide them with a safe childhood. So I think when we talk about what they might be experiencing what a normal 10-year-old would feel like in another unsafe environment, and it's a lost opportunity that we need to avoid at all costs.
Yeah, I mean, Dr. Fleetwood, if you had a traumatised 10-year-old come into your hospital, and maybe they'd been involved in a terrifying incident, deeply shaken, might have sort of low verbal responses because of how traumatised they were. What would your response be, and how would that differ from putting them in a prison cell by themselves through a criminal justice system? What actually would, from a medical point of view, what do kids need at that moment?
It's a really good question, and I've got like a de-identified sort of example. We often have 10, 11-year-old boys coming in heightened, brought in by the police. They've got 4 security guards on them to keep them safe, keep the rest of my department safe. They're taken to our safe room, which is a windowless room with a beanbag so that they can't hurt themselves or others. And their nurses are drawing up and the doctors are ordering the chemical sedation to keep this kid safe. But if you're able to get control of the situation, talk calmly, connect with the child and talk like a human and a mother. I'm a mum of 2. It is just crazy to watch that transformation in this 11-year-old boy or girl who is violent and aggressive and needing 4 burly security guards to keep them safe. Suddenly, they become a child again and they cry and they tell you their finger hurts, and you get them a sandwich and an ice block, and they're just that vulnerable 11-year-old child who's got the same needs as every other 11-year-old child, but hasn't had their other needs met. And that's that human connection, that feeling of safety. Their frontal cortex, what we know about neurodevelopment is that the frontal cortex, look, depending which theorist you read, doesn't reach maturity until 21, 25 years of age. So how are we expecting children who are being exposed to family violence, intergenerational trauma, then their frontal cortex is constantly heightened from all the cortisol in their system, and they're making poor choices because their frontal cortex isn't mature enough to do so, and it just self-perpetuates. But you can break the cycle. You need to give them somebody constantly in their corner, somebody who's looking out for their entire well-being, whether that's their emotional, physical, mental health, housing, education, like going into youth justice, they get it. It's everything falls apart. And I think just connecting with these children and being a human is what they need in that moment.
And Dr. Fleetwood, when you do that, like a young traumatised child's been brought in, surrounded by that cloud of police and security, you're able to make that connection and calm them down and begin helping them in the hospital. But then in practice, what happens after that? You calm them down, you do the medical intervention. I mean, what happens to that child? Yeah.
Well, look, I mentioned in one of my earlier responses that for the frequent presenters or the children who are known to our child protection services, we often have care plans and teams, but the breakdown and the communication between these teams is terrible. And these children stay in our emergency departments for hours. As a general rule, we want to see and sort patients in 4 hours. These kids are staying with us for 12, 24 hours even sometimes because we can't find a safe place for them to go back to. So they're in a clinical environment at risk of heightening again because there's buzzers going, there's other sort of dramas happening. They've got no one person who sort of comes in and says, hey, you're mine and I love you and I want to take you home and support you. You're sort of fighting child safety, the community teams, you're trying to advocate for this child, and it's really hard to get all of the agencies to communicate and get on the same page because, they don't have one continuous carer. You get cancer, you've got an oncologist who's got oversight of your whole cancer journey, but these children from 8 or 9 or however long it is, they've got no one person sort of overseeing their journey because they can't see a paediatrician. There's not enough paediatricians, there's not enough GPs, the wait lists are too long, and then they end up in ED for hours and hours while we try and find somewhere safe and sustainable for them to go.
If someone catches a disease or they're diagnosed with cancer, they get an oncologist. But maybe if young kids are catching the justice system, maybe someone should be appointed there to help with what is obviously going to be an incredibly endangering part of their life. And
Yeah, absolutely.
you know, we had some real evidence yesterday from some of the children's commissioners in saying young kids, when they go into detention, they can be spat out and nobody can be there to meet them, or they go back out into the same harmful conditions. And what is missing is somebody to be there, obviously in their corner, with a hot meal, to take them to a safe home. And really, you know, imagine if we provided resources to that instead of the jail and the court and the 4 security guards and the bevy of police. As a doctor, if you were releasing kids to a social worker who is taking them to a safe place and a hot meal, how much better would you feel at the end of the day?
Oh, so much better. Like, it would be game changing if we had better supports to get these kids back into community, because our emergency departments are not the place for them.
It can't be beyond the Commonwealth Government to make sure kids have a hot meal and a safe home, can it? That can't be beyond our reach. Thanks.
I would hope not.
Yeah.
Basic human right.
Thanks, Sue.
Thank you very much. And thank you all for giving evidence to the committee today. I just have one question, and I'm conscious we're sort of coming up to time. Talking about the early intervention, and that is something that we have heard across the country in terms of the learning outcomes, the prospects of children coming into contact with the juvenile justice system, all seems to come to this early health intervention. And I know that you mentioned that there are a lot of children who aren't undergoing health screenings here in Australia, Dr. Kennedy. What are some of the barriers to parents not, or children not being presented to have those, I guess, assessments done without it being mandated?
Thank you. That's a wonderful question. We have jurisdictional challenges. So we have Commonwealth frameworks and guidelines and recommendations, Senator, and they are then operationalised in state-based frameworks, so state-based child protection, justice, youth justice and health frameworks. The second issue is that the youth justice and child protection and health systems don't always work together as well as they should. And so the operationalisation of a young person, like Dr. Fleetwood mentioned, who is being brought by the youth justice system, the connection between that system and the health system doesn't always work as well as it does. So health is sometimes not on the agenda as it should be.
Okay.
The third issue is that children involved with the child protection system and in out-of-home care, that in many states the case management, the day-to-day operational case management is outsourced to community service organisations. And so the accountability for that can be a little bit difficult to track, in my view. And so even though they are tasked with ensuring that children have, so children who are moved into an out-of-home care placement under whatever that particular state has as a child protection out-of-home care order, and they vary state on state. Operationally, that can look quite different, Senator. So one child might be taken to a local GP. Another child might be taken to a specialised service. The second issue is that this care is very specialised care, as you can see from what everyone has said, to provide proactive, trauma-informed assessment and treatment. This requires a specialist workforce, and we simply don't have that at scale in Australia. So leaning on from my clinical work at the Victorian Aboriginal Health Service, where 60% of the children that I was seeing were in out-of-home care, I undertook a Churchill Fellowship in 2019, looking at what was best practice internationally in terms of the design of health services and the health programs to do exactly what you are proposing in terms of addressing those health needs and providing the sort of early intervention that was evidence-based and best practice. There are good models internationally for that, but that requires policy changes, legislative changes, and system changes. In 2023, the RACP...
Can I stop you just there for a second? A jurisdiction where you do think it works well as part of your fellowship?
Oh, right. There are, while the US has many failings to its health system, under the Obama administration, they made quite considerable gains in the child welfare area, particularly under the leadership of Brian Samuels, who was the chief child welfare administrator in the federal government. And they managed with their reforms, they managed to reduce the number of children within the out-of-home care system and improve outcomes. And there are details on this in the RACP's position statement from 2023, the healthcare of children in care and protection services, and also in 2 reports that I produced following my Churchill Fellowship, which I can provide the committee if it's of interest.
That would be incredibly helpful to us if we could trouble you to do that. Thank you very much for that. And I guess just going on to that, if we take a step even earlier than that, so even before these children may be removed from home or even touch the youth justice system, and you've touched on workforce and having quite a skilled workforce, which we have a shortage here. If you were going to put this type of screening, say, into a school program in the same way that there are dentist programs that run where kids get popped onto a bus and taken to a dentist and they have their teeth looked at when they're about 5, if you did a similar thing like that in terms of healthcare, do you think that you would be able to advance screen and potentially divert children away from touching on the youth justice system?
I think that this does need a health lens, and the models of care that were most successful of the ones that certainly that I visited and in my research embedded primary care doctors as well as specialist doctors as well as social workers, allied health, nurse practitioners in a model with a very clear clinical pathway. What that meant was on entry to care there was a very clear set of screening questions that were asked and with clear pathways for referral. And much of this detail is actually contained in our position statement, Senator, and in the National Clinical Assessment Framework, which again is the Commonwealth Government's framework for screening for children in the out-of-home care system.
It's not so much it's where you put that screening. So would it work within the education system? And what we have is we have silos of systems, and you've described partly how those silos work when children are part of the justice system. If they're part of social services, it's not necessarily talking to health, and I think education is another piece of that puzzle. But looking at where you can put these things, because it's all very well and good to, and you can see it sits in the framework now, it's not happening. But it's looking at ways that you can start integrating and having the silos actually be less like silos.
Senator, I think it definitely takes a team, and it definitely does require educators to be on board. But in my opinion, this does need to sit with specialist health staff, because you're looking at a child.
I don't mean for educators to be doing the screening. I just mean for the schools to be the place that we can send the health professionals to. Yeah.
Certainly, and a number of the models that I saw operated in these sort of outreach models, and absolutely, Senator, I'm very much in support of this happening in the community settings. So yes, my apologies for
No.
Senator Cox, can I just say one thing? Sorry, in one of my other roles, I work for the Institute of Urban Indigenous Health up in Queensland as well, and we've actually increased our health checks across the organisation by getting on board with football and sporting teams. They've got, you might see my beautiful shirt I'm wearing here, a Deadly Choices T-shirt. So actually all of the children and adults who come in every year to see their GP to get a health check get a free footy shirt, and they're seasonal, they're up every year. And we've gone, I can send you the actual statistics because I'm quoting this from memory, but they've increased the uptake of the annual health checks by something crazy like 40, 50%. So I really think, and we need to lean in for our Indigenous populations and they need to tell us what we want, what they want. This came from them, and that's why it's really important in any solution design that we talk to our Indigenous health leaders and see what they think we can do to help, so that we can all lean in and increase uptake of health checks, which is such an essential part of screening health assessments for children.
Fantastic, thank you. We would very much appreciate if you could send that through to us. That would be very helpful. Thank you. I am conscious we are now running over time, so thank you very much for giving evidence to the committee today. For those of you that now have homework to go and do, we would be very grateful if you could provide that to the Secretariat within the next 2 weeks. If you think of anything and you think, I wish I'd let them know this, please feel free to email that through to the Secretariat as well. But otherwise, we are most grateful for you taking the time and for the work that you're doing in the community. So thank you very much. And with that, you are released.
Thanks all.
Thank you.
After lunch.
Yes. Oh, easy. Okay. And we might suspend I now welcome representatives from the Salvation Army, Your Town and UNICEF Australia. Thank you for taking the time to speak with the committee today. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could I please ask that you each state your full name and the capacity in which you appear? And we might start with Miss Kirk-Oldie. Thank you.
Jennifer Kirk-Oldie, General Manager of Policy and Advocacy at the Salvation Army.
Fantastic.
Stephanie Jandal in the capacity of National Youth Specialist, Salvation Army.
Excellent, thank you. Is there Ms Keeling?
Yes, Jo Allen Keeling, Chief Service and Impact Officer at Your Town.
Fantastic. Mr Pook?
Benjamin Pook, Advocacy and Government Relations Manager for Your Town.
Mr Brunker?
Yeah, Dean Brunker, Aboriginal and Torres Strait Islander Initiatives Manager at Your Town.
And then a Miss Yaskawa?
That's it.
Sorry,
Hi,
did I get that right?
You did. It's Louisa Yasukawa, Advocacy and Policy Manager at UNICEF Australia.
Fantastic. Thank you all. Do any of you have an opening statement you would like to provide? So we may start in the room. Ms Kirk-Oldie, if you'd like to commence.
Thank you so much for the opportunity to appear before the committee. I'd like to begin by acknowledging the traditional owners of the lands on which we're meeting, the Ngunnawal and Ngambri people, pay my respects to elders, past, present and future, and reaffirm the Salvation Army's commitment to working alongside First Nations peoples to pursue justice, reconciliation and mutual flourishing. The Salvation Army works in communities in every state and territory in Australia. We're supporting children, young people and families experiencing some of the most complex disadvantage. We provide some services specifically to support young people who've interacted with the criminal justice system, but we also provide a wide range of youth and adult homelessness and housing services, alcohol and other drug services, and family and domestic violence services. Our interest in this inquiry is informed by the impact of young people interacting with the criminal justice system that we see across all of our services. Criminal justice responses that entrench trauma, increase reoffending and limit a young person's future, increase disadvantage and increase the likelihood of them needing support from people like us. Every person deserves to be safe in their community. And our experience is that we cannot separate community safety from community wellbeing. This is why our focus, like so many other witnesses, is on prevention, early intervention and diversion. Prevention and early intervention work to address the drivers of crime holistically by interrupting cycles of disadvantage. This reduces recidivism and increases community safety. Effective diversion can support the young person to explore both the causes and the consequences of their actions, promotes a flexible response to offending and positive behaviour change. Children and young people who come into contact with the justice system are children and young people, and our responses should reflect everything we know about development at different stages of life. The best responses will address all areas of a child or young person's life, promoting not only reduced contact with the criminal justice system, but also setting up each young person for success. The best responses prioritise physical and emotional safety, they support rehabilitation, and they promote positive community connection. We're particularly heartened by the work of this committee because this issue is often considered a state matter, but the Commonwealth has an important leadership role to play. In particular, we would like to see the Commonwealth work with state and territorial jurisdictions to raise the minimum age of criminal responsibility to 14 years without exception, to develop minimal standards for the treatment and protection of children and young people who encounter criminal justice responses, and to establish formal and informal mechanisms for direct engagement of young people and children so that their lived experience is embedded in policy matters that impact them. Thank you again for the opportunity to appear. We look forward to being of assistance.
Thank you very much. Are there any other opening statements? Yes. Sorry. So if you'd like to go ahead.
Great, thank you. We would also like to acknowledge the traditional owners of the land and pay respects to Elders past, present and emerging. Your town welcomes this inquiry and the focus it brings to Australia's youth justice and incarceration system. It's an opportunity to assess whether current approaches are delivering improved outcomes for young people and safer communities. We believe that the system's not delivering the outcomes that it is intended to. Too many young people continue to cycle through detention and supervision without the underlying drivers of offending being addressed. We continue to see reliance on detention despite strong and consistent evidence that it does not reduce reoffending or improve long-term outcomes. At your town, we work alongside young people every day who are dealing with significant and overlapping challenges. These include trauma, family instability, disengagement from education, unemployment, housing insecurity, poor mental health and disability. These are not secondary issues. They are primary factors that sit behind youth offending. If these issues are not addressed early and consistently, young people are far more likely to enter and remain in the justice system. And there are five main points that we want to emphasise today. Firstly, that detention should be a genuine last resort. It disrupts education, compounds trauma and increases the likelihood of reoffending. That is not consistent with a system focused on long-term community safety. Secondly, we know which interventions reduce reoffending and they're not being applied at scale. Early intervention, sustained engagement in education and training, and access to community-based and therapeutic supports all reduce offending and improve outcomes. These approaches are also more cost-effective than incarceration. We know that when young people are connected to education, training and employment pathways, they are more likely to achieve long-term stability and less likely to return to the justice system. Thirdly, we need to place a much stronger focus on families. Many young people in the justice system are navigating significant family instability, trauma and unmet support needs. Working with only the young person is not enough. Family-centred, wraparound approaches that provide support to parents, siblings and the home environment are critical to address the root causes of offending and creating long-term stability. Fourthly, young people need real and visible pathways, access to education, including alternate education pathways, vocational training, employment and safe and stable housing will play a critical role. These are not peripheral supports. They are some of the strongest protective factors against future offending. And finally, reform needs to be grounded in lived experience. Young people consistently tell us that current systems are not designed with them in mind. Embedding co-design and ensuring culturally appropriate community-led responses, particularly for Aboriginal and Torres Strait Islander young people, is essential if reform is to be effective. Our submission sets out a practical pathway forward. We're calling for stronger investment in early intervention, a national focus on keeping young people engaged in education and employment, expansion of community-based alternatives, and greater commitment to family-centred and culturally led responses. Thank you, and we welcome your questions.
Thank you very much. And Ms. Yasukawa.
Thank you, and it's my pleasure to be joining today from Guy-Migal country, and I pay my respects to the traditional custodians of this land. Across more than 190 countries and territories, UNICEF, the United Nations Children's Fund, works to uphold the rights of every child. Our work is grounded in a simple principle. Every child has rights, and societies are stronger when those rights are realised. Now, let me start by saying that we recognise the very real concerns communities have about youth offending in Australia at the moment. Victims deserve justice, communities deserve safety, and children who offend should be held accountable for their actions in a way that respects their rights. These are not competing goals. Yet the rights of children in our youth justice system are being compromised by approaches to youth offending that preference punishment over rehabilitation. These approaches harm children, fail to make communities safer, and do little to break cycles of offending, with around 85% of children returning to sentence supervision within a year. Put simply, we are prioritising a system of youth punishment over youth justice. That's why UNICEF Australia is calling for, firstly, nationally enforceable minimum standards for youth justice in Australia. Secondly, greater investment in prevention, early intervention, and community-led responses. And thirdly, stronger national leadership to coordinate urgent reform. Now, in terms of the standards, we believe that the minimum enforceable standards should set the floor below which no child can fall, not the ceiling for reform. Grounded in the UN Convention on the Rights of the Child, they should establish a range of national requirements, including access to education, healthcare, and legal assistance in justice settings, well-trained, culturally safe, trauma-informed workforces, the prohibition of harmful practices such as solitary confinement and spit hoods, a minimum age of criminal responsibility of at least 14, the use of detention as a last resort, and robust data collection, monitoring, and accountability mechanisms. These standards should form the foundation of a 10-year National Youth Justice Roadmap, supported by a National Youth Justice Task Force, a dedicated Cabinet Minister for Children, and a Ministerial Council to drive coordination across jurisdictions. Second, as we've already heard by colleagues on this panel, we need to invest in what works. Evidence from Australia and overseas consistently shows that restorative justice, justice reinvestment, and community-led early intervention reduce offending while supporting victims and strengthening communities. Australian evaluation of these interventions have produced strong results. Queensland's Restorative Justice Group conferencing program has been shown to deliver a substantial reduction in both the frequency and seriousness of reoffending. And the Burke Justice Reinvestment Project has produced a nearly 40% reduction in the 5 most common youth offences. For Australia, we think the answer is to be tougher on the causes of crime. Poverty and entrenched disadvantage, family violence, homelessness, disengagement from education, mental health, trauma, and racism are the social determinants of offending behaviour that we need to address. And the time for national leadership is now. The recommendations this committee has heard are not new. They have been made repeatedly by the UN Committee on the Rights of the Child, countless Australian inquiries, civil society organisations who work directly with young offenders, and of course, children and young people themselves. We've seen that the Commonwealth can exercise national leadership when children face unacceptable harm in other settings, like childcare. Now, we recognise this reform isn't easy, but we know it is possible, and the imperative to act is clear. We thank the committee for the opportunity to be part of this important conversation and are happy to answer any further questions.
Fantastic. Thank you all very much for those opening statements. We will move now into questions, and I give the call to Senator Stewart.
Thank you, and thank you for taking the time to appear before the committee this afternoon. I've got some questions for your town in the first instance. I'm interested in your co-design approaches with young people and why you took that approach and what difference you think it can make for young people.
We've been on a co-design journey at your town for probably the last 5 or 6 years. Young people have told us that unless they're involved in helping understand the problem and generating solutions, it's actually hard to deliver services in a way that really meet their needs. I'll throw to Ben as well, because not only have we been co-designing our services, but we routinely go out to young people across Australia and ask them what's really important to them to be able to elevate their voice.
Does that include in youth justice settings?
No, so we sit adjacent to the youth justice system in providing a range of employment, education and mental health supports, Kids Helpline and other employment services.
So you see them at either end, you're checking with them to see what works. Yeah, okay.
Yes, yeah.
Thank you very much for the question, Senator, and Joe, for your response. So last year, Senator, we completed a national series of consultations called Your Voice. That involved over 4,500 young people, a number of which who have come into initial contact with the youth justice sector, whether that's through contact with police or the courts, or have been in detention themselves and have been released. I don't have the exact number of those on me, but I can review the data and provide that response. One of the themes that did come up in those consultations and the subsequent recommendations that the young people put together was that disengagement from education and disengagement from community really led to connection and a direction towards involvement in the youth justice sector. And they identified that alternative education options are essential, whether that is alternatives within the actual current school system or alternatives outside of the school system, whether that is through things like your Y schools, vocational education and training, or just wellbeing programs, such as those that used to be offered under the federal government's Youth Connections program. I know that was a while ago, but that was a very effective program that your town used to run. So what young people are really saying who've been in contact is we need help earlier in terms of engagement with education and staying connected to those sectors, that sector and systems.
Thank you, and appreciate any additional information you want to provide the committee on notice. You've got the Kids Helpline at School program, is that right? Yep, nodding.
Yes.
Can you share evidence of the outcomes of school-based programs, particularly in terms of keeping kids and young people engaged in education? We've heard consistently through the committee how important education is and staying connected to education. So I'm keen to understand this program.
Yes, so we deliver a range of programs that kind of address that issue. So Kids Helpline at School is where a Kids Helpline counsellor is beaming into a classroom and doing universal type education around a variety of issues, whether that be bullying, cyber safety, those kind of things. So it's a really interactive, fast-paced, engaging session done with classrooms at a time. And we also deliver through our range of employment programs. We engage with a lot of young people who are disengaged with education, are feeling like they don't have structure and know what to do and support them in providing wraparound care to be able to either engage in employment or education pathways. So we try and tackle it from a number of different perspectives, from a virtual and also face-to-face component.
And how do you decide for the beaming into schools or even the employment stuff? How do you decide what to put on the agenda or program? Is that like a set thing, or do you work with schools to tailor specific kind of things to whatever that classroom might need? Or
so it's a free service for primary school and high schools. Teachers and schools can reach out to us and book in for sessions, and we always have contact with teachers prior to delivering the sessions to understand what's going on in the classroom, what are the particular pain points that they're encountering, and how might we tailor a session that's fit for purpose for their young people.
Okay, and then are parents engaged at any point in this work?
There is parental consent to engage in the program, but no, it's direct counsellor to classrooms of young people.
The only reason I ask that, because I think obviously school's kind of one environment where these kids are, and then importantly, like the home is where you want to make sure that what's happening in the classroom is consistent with what's happening at home. So I'm wondering how you kind of get some of those, how you get that consistency across a child's life so it doesn't feel so fragmented, I suppose. Does that happen, or is it just a consent form that parents sign and they trust that, or do, I genuinely just interested. How do you kind of make sure those things line up?
I can add a little bit more to that, Senator. So with some schools, there are situations where we have had parents want to be engaged with sessions prior. So I'm very aware of a number of schools in Melbourne where the counsellors have actually delivered sessions to the parents prior to them agreeing to have the young people involved. I also am aware and know that our counsellors work very closely with a number of Indigenous communities, particularly in North Queensland, where they do engage with the elders and communities prior to delivering those sessions. And some of our sessions are also available online for parents to view the post or pre-young people being involved in those sessions. As a sister service to Kids Helpline, your town also runs Parent Line in Queensland and Northern Territory. And we share a lot of resources, which includes not only the web-based resources, but also the counsellors who work on Kids Helpline to actually ensure that those same messages and same support is available to the parents as well. What we're aware with Parent Line, though, is that not every state and territory has a counselling and early intervention focus with their Parent Line. It is more of a health response in other areas. And we would certainly say that a counselling and wellbeing focused approach to Parent Line would be really beneficial at a national level for parents who are struggling to manage the behaviours or the outcomes that their children or their young people in their lives are achieving.
Yeah, thank you. And I'm a therapist, family therapist by trade, so that's why I'm interested in kind of how you, all those things for me, I think one of the challenges we've got in the system is it's so siloed and individual focused. And actually, this young person who might end up getting themselves into a bit of trouble actually needs everyone around them to be on the same page and kind of all rowing in the same direction. I really like the sound of that program in school. So,
and if I could add another insight that young people spoke to us very strongly about in our Your Voice survey and process was the need for coordinated responses in the wellbeing sector. That this was required not just once a young person disengaged from school or had a complex health issue or experienced domestic and family violence. It actually needed to be available as early as possible. So it was true early intervention once some of these risks actually started to appear. So when they first started having some wellbeing concerns or first disengaged with education in any way, rather than waiting until they're in contact with the justice system, they're in hospital or their homes.
And so, I mean, I've got a question here about your recommendation around embedding family-centred intervention. Have you found that doing the kids' helpline work and maybe the education stuff too has given you the opportunity, either yourself or for other services, to kind of get in early and help? Have you've been able to pick up some of the things that might not be going quite right in this child's life? Or is it just it's not used in that way? Yeah.
Yeah, I mean, our Kids Helpline service, for example, is a universal safety net for all young people. So we get a number of young people calling us in crisis, but we also get young people reaching out early for help. And many of our young people call us consistently and engage with the same counsellor over a period of time. We are able to provide that kind of case management support and work with other members of the family. So it's a far more holistic service offering.
I would say where more we see that is in our employment programs. So we run a number of different programs, including social enterprises, Get Set for Work, Queensland Transition to Work for the federal government, and also Get Back in the Game for the New South Wales government. And we do find that intervening at that point, so supporting young people and their families as well, at that point is really, really effective, because we know that a number of the young people, and our staff would say the majority, are at significant risk or are in contact with the police and the justice system. And having managed some of those programs previously, I would definitely support that view from our managers and staff. And that provides an essential stage for us to engage with young people and provide them with the support, whether that's through case management, engaging in employment, furthering their education, or connecting them with family supports. And I know, Dean, you've got a lot of experience in that space as well, particularly with our First Nations cohort. So I might let you respond.
And I am interested, before Dean responds, I am interested in the difference it makes connecting young people to employment. I feel like I can probably guess the difference that it might make. But lots of the evidence that we've heard is about the impact of poverty and what that means for a child's trajectory into the youth justice system. Does employment and the employment programs put a blocker on that?
I mean, I think we know.
Way to describe it, but
I mean, I think we know that education and employment are some of the strongest protective factors in this space. Like, when a young person's engaged in school, training or employment, they have structure, they have purpose, positive relationships and a sense of future. So we think this is a critical piece in this whole story, in scaling more of those programs that really provide that wraparound intensive support. So addressing the vocational and the non-vocational barriers to get young people engaged.
Yeah, and is there a role, where I suppose your kind of mainstream traditional kind of education system doesn't work for kids? Is there a role for places like Free TAFE to give kids the skills to be able to get into the workforce? Are those things useful in terms of the work that the federal government is doing?
Yes, would be the very simple and direct answer. We know that approximately 50% of all young people who engage with youth justice are either disengaged from education or employment. So it's a really big risk factor and a significant indicator that someone will become involved with the youth justice sector and the justice sector as a whole. So anything that provides an opportunity for a young person to come back into that system is really, really effective. And I think in terms of Free TAFE, that's very, very helpful, because what we hear from young people and families is that, and through the support that we provide in the programs, is access to education is actually becoming more and more expensive. So it's expensive not just due to the fees, but other impacts like transport, and we're talking here as well around coming into employment initially, but the costs associated with transport, with the initial equipment to actually get into a job, organising lunches as food when you first get a job is expensive. So these are all costs that can be offset by things like free TAFE, 50-cent fares in Queensland. So these type of actions from the government to reduce those barriers as much as possible is really, really important. And the other thing I would say here around reducing costs with alternative education is many alternative education providers they're almost isolated. There is a lot of travel involved for young people to get to those activities or those centres, which does create a barrier and also disconnects them from local supports. And so what we need to do is try and keep young people engaged with the community that they're part of, so that they actually want to be in their community, they belong to the community, and when they need assistance, it's localised rather than them becoming further isolated from their community and family supports.
Thank you. And I will go, I will throw to Dean now. It does feel slightly disrespectful to call you Dean, so I might just call you Uncle instead.
No, that's okay. Thank you, Senator. I really appreciate the opportunity. Look, through my role at Yorktown, if I want to go into the aspect of employment, and we're talking about youth offending, I've been part of the community justice group through work in the Murray Court in Queensland for about 16 years. Through my role there, what we do and what we try to do is link a lot of our young offenders and our offenders coming through, adults as well, into employment. We find that majority, about 80 to 90% of the people coming through the community justice system in the Murray Court are actually unemployed. They've got mild or small offending issues, but they're homeless. And so what we try to do is link them up. So we've linked up with certain employers, especially Aboriginal operated and owned employers, who we can actually link the young people up where they're going to get a wraparound service, not just from your town, but also from the community, from the justice group. And that's what we try to do. And the magistrates are quite open for us to look at employment as part of their probationary period while they're coming through the Murray Court. And they could come through the Murray Court for 6 to 12 months. And we find that's very effective. One, they're earning money, and it's keeping them out of the system and keeping them working and occupied. But we loose up. But in general, it's quite a good fit for us to place young people coming through in employment to keep them out of the system, and that's what we try to do through the community justice system.
Do you, and you might not have it handy right now, but maybe on notice, if you've got any of the data or statistics in terms of the rate at which people who are, supported into employment, and maybe this is your town, across the range of employment programs you've got too, but I assume the Murray Court's like the Koori Court in Victoria.
It's very similar, Senator. That's correct. Yeah, it is.
I've got plenty of family members involved in the but yeah, I'm interested in kind of how does it reduce the recidivism, I suppose, is what I'm interested in, and any data that you've got to demonstrate that. Notwithstanding, of course, there's always going to be some people who we don't capture, but yeah, I think Senator, for me, kind of supported into work and giving people some financial independence, some economic independence is really important. I think
100%. We can give you, we can give you the stats from your town perspective. And I know there was some work done in 2023, I think between 2021 and 2023 with the community justice groups and the Murray Court in Queensland. So I can get that information and get that sent through to you.
Thank you very much. And maybe just one final one for UNICEF. You talk about a national youth justice task force to coordinate and monitor. What are you envisaging would be monitored, and what's the benefit of a task force as opposed to other forms of or structures of doing this work?
Thanks, Senator. When we're talking about what to monitor in the youth justice system, I think it's really important to consider the youth justice as a continuum, as the colleagues today have said. So that's spanning prevention and early intervention through to diversion, rehabilitation, detention, and reintegration into the community after release. And the reason why we think a National Youth Justice Task Force would be the vehicle to really build momentum and start putting these recommendations in practice is because we, like many in civil society, are calling for a truly national approach. As I flagged in the opening statement, we know that reform isn't easy, but it is possible. And as has been made clear today, talking about the relevance of looking at education systems, earlier we heard about the importance of the health perspective to youth justice. So a national task force that can bring in those different perspectives is essential. As I mentioned, complementing that task force would be a dedicated Cabinet Minister for Children. And that's really because we see there is a strong need to elevate the rights of children to a national level, and that Cabinet oversight is necessary to make sure that it is prioritised. I also mentioned there's a need for a ministerial council to drive coordinated action across jurisdictions. And again, that's because this is a cross-portfolio issue. And so having those different perspectives will ensure that we coordinate responses and make a more consistent approach across the systems. In terms of the task force, we, as I said at the beginning, really advocate strongly for the prioritisation of minimum standards for youth justice. That really is the key place that we need to start, because we are seeing that children's rights are being violated, and the standards would provide that floor that no children are able to fall below. And I'm happy to answer more questions about what the standards could look like and how we could enforce them.
Thank you very much. Just noting on time, I would really appreciate anything on notice in terms of the national minimum standards too. So if you haven't already provided that, certainly welcome more additional information. And have you provided what the makeup? The Ministerial Council, I can see who would be on that. The dedicated Minister for Children, very clear. Who do you think would be on the task force?
Well, I know that the task force was one of the key recommendations coming out of Anne Holland's Help Way Earlier report. I believe she is giving evidence later today, so I think those questions around the specific nuances of the composition of the task force would be well placed directed to Anne, given she did do such deep thinking about it when she prepared that report.
Thank you. I will absolutely do that. And I have taken us just a couple of minutes over, but thank you so much for your time and all the work that you do as well. Appreciate it.
Thank you.
Thank you very much, Senator Stewart, and thank you to each of the witnesses for providing those answers. And normally I would ask questions, but Senator Stewart has asked all of the questions that I had, so she's been very efficient in helping with that. If there is anything that you have taken on notice, if you can please provide it to the Secretariat within 2 weeks, we would be very grateful. If you think of anything after this hearing and you think, I wish I'd said this, or I wish I'd had an opportunity to add this, please also send that through to the Secretariat. We would be very grateful. But thank you very much for appearing today and for all of the work that you're doing within the community. And with that, we will suspend until 1:30. I now welcome representatives from the Queensland Aboriginal and Torres Strait Islander Child Protection Peak, the Create Foundation, Emerge Women and Children's Support Network and Peak Care Queensland. Thank you all for taking the time to speak with the committee today. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, if I could please get you each to state your full name and the capacity in which you appear. And we might start with Mr. Brooks.
Thank you, and thank you to the committee. Philip Brooks, I'm the Chief Executive Officer of the Queensland Aboriginal and Torres Strait Islander Child Protection Peak and Youth Justice Peak in Queensland.
And then Miss Edison.
Hi, I'm Imogen Edison, Chief Executive Officer of the Create Foundation.
Mr. Yen.
Hello, my name is Kelvin Yen and I'm a part of the Create Foundation as a young consultant
Ms. Marshall.
in South Australia.
I'm Claire Marshall and I'm the Chief Executive Officer of Emerge Women and Children's Support Network.
And Ms. Jebb.
Hello, Kelly Jebb, Chief Executive Officer, Peak Care Queensland.
Fantastic. Thank you all very much. Now, does anyone have an opening statement that they want to start with?
And we,
yes. So
we would love to have some time for questions too, so we keep that in mind. Yep.
Yes, we can keep them brief. So what we might do then, Ms. Job, you got your hand up first if you'd like to start, and then we'll go to Ms. Marshall.
Thanks so much, Chair and members of the committee. I'd just like to acknowledge the traditional custodians in the lands of which we all meet, pay my respects to Elders past and present, and extend that respect to First Nations colleagues on the call. Peak Care is the peak body for Queensland's child and family sector, and children and young people are at the heart of everything we do, with a commitment to lifelong safety and wellbeing. Many of our members deliver both child protection and youth justice services, giving us a unique line of sight across the continuum of children's experiences. This enables us to hear directly from people on the ground about how early adversity, trauma and system responses influence later involvement in the youth justice system. We share the goal of safer communities. Communities deserve to feel safe, as do victims, and government has a responsibility to support safety. But every dollar invested in youth justice should contribute to making communities safer. And we need to ask, does it reduce offending? Does it reduce future victims? Peak Care believes it's essential that children's voices inform reform, and we welcome the committee's engagement with children and young people with lived experience in the youth justice system. In preparing our submission, we spoke directly with young people in Queensland's youth detention centres, and they spoke about wanting the basics that everyone wants: stable housing, employment, education, cultural connection, and supportive adults in their lives. They described the uncertainty of prolonged remand, extended periods without programs due to staffing shortages, and the difficulty of successfully reintegrating to their communities after release. These conversations reinforce the importance of designing a system that is both accountable and genuinely rehabilitative. We believe there's an opportunity for governments to strengthen community safety by adhering the following principles. First, children and young people should only be detained as a last resort and for the shortest possible time, consistent with the UN Convention on the Rights of the Child. 10-year-olds are still in primary school. They're still developing socially, emotionally, and neurologically. They should not be in detention. Investment should focus on earlier intervention and therapeutic responses, including as part of diversionary programs or within detention. And that investment must extend to Aboriginal and Torres Strait Islander community-controlled responses. 3, diversionary programs should be evidence-based, trauma-informed, culturally responsive, and independently monitored and evaluated. And 4, children must receive ongoing coordinated support as they transition back into their communities from rehabilitative programs or last resort detention. These reforms are not alternatives to community safety, they are critical to achieving it. And if we're serious about reducing youth crime, we must focus not only on responding to offending after it occurs, but also on preventing it by addressing its underlying causes. The Queensland Government has recently tabled the Child Safety Commission of Inquiry final report. Unsurprisingly, there's a strong intersect between child protection and youth justice systems, as many of the same children move between them. But it's time we stop talking about them as two separate systems. Young offenders were often younger victims. At what point did they stop needing protection? If children are to be held accountable for their past, governments should be accountable for whether they have a better future. Thank you.
Thank you very much. Ms Marshall.
Thank you, committee members, and I'd also like to acknowledge that we are in the lands of the Ngunnawal people and also acknowledge the Bunurong and Wurundjeri people back in Victoria, where I've come from today, and pay my respects to elders in the meeting and in the community. So Emerge is a not-for-profit specialist family violence service based in Victoria. We provide 24/7 secure refuge, crisis accommodation, case management, outreach support, and therapeutic programs, including early intervention in a child-centred and trauma-informed human rights model for practice. We deliver therapeutic early intervention for primary-aged children who are demonstrating challenging and aggressive behaviours because of family violence. Our early intervention models were created because of the pipeline between our system and the youth justice system. We are seeing kids again and again come through our system and go on to use violence as young people and teenagers. It is clear on the evidence base that there is a strong link between experiences of family violence and young people who offend. And we are seeing behaviours that the evidence tells us that a kid is at high risk of ending up in the justice system in children as young as 5. These are the young children that our specialist system sees every day. Traumatised children who are hurting their siblings, their mums and their peers in classroom. Without support when these kids are young, the interventions available are more likely to be punitive justice responses. We deliver early intervention to avoid this trajectory and to ensure that we are giving these kids, their families and their communities the opportunities they deserve to have safe and healthy lives, free from violence. A lot of the levers for youth justice are at the state level. The National Plan to End Violence Against Women and Children provides a concrete mechanism for addressing the cycles of violence and the justice pipeline for vulnerable kids at the federal level.
Thank you very much. And I'll just double check. Oh, we've got a hand up. And sorry, I didn't bring my glasses in with me. It's Imogen. If you've got an opening statement, please.
Thanks so much for having us today. I'd also like to acknowledge I'm joining from Bundjalung country and want to pay deepest respects to elders, knowledge holders and community leaders and honour their cultural authority and extending that respect to First Nations people present. Create Foundation is the Australian consumer body representing children and young people with lived experience of out-of-home care. And as a systems advocate, our role is to listen to the voices of young people in safe, meaningful and empowering ways and support them to shape the conditions and policies impacting their lives. So in this context, Create brings the direct testimony of young people with lived experience of both out-of-home care and youth justice systems and see their voices as a really important source of evidence. I'm appearing today with Kelvin Yen, a Create Young consultant and youth advocate with lived expertise of these systems and how they overlap. I know that youth justice is an issue that can be really divisive, but as community members and decision makers, I think we need to be honest with ourselves that locking up children, many of whom have endured trauma and adversity, actually harms them more. It's a case of adults harming children, and we know that contact with criminal justice systems is a life experience that disproportionately affects young people with experiences of childhood trauma, including abuse, First Nations children and young people with unmet disability needs and young people in out-of-home care. And in fact, contact with youth justice can be a direct consequence of their statutory care experience. The care to custody pipeline is strongly reflected in data and in the real life experiences we hear from children and young people who tell us they experience stigma growing up in care, resulting in criminalisation, especially for those living in residential care. And there's a continuing cost of that stigma with criminal records following them into adulthood and creating barriers to housing and employment. They tell us that behaviours resulting from trauma and unmet needs are resulting in police call-outs to care settings rather than being managed through proportionate and de-escalating responses, as would happen in a family home. And they tell us police are called as a way to control, discipline and reprimand them. in care settings. And we also know that young people in care are at higher risk of exploitation of numerous kinds, and some of those can lead to criminalisation. So by the time a young person shows up in youth justice, they can sometimes have experienced many failures of systems, services, and the adults around them to keep them safe, support their healing from trauma, and provide them with opportunities for learning, connection, and other developmental needs. So locking up children is not only a failure to comply with their rights and international legal obligations. We also know that it doesn't work. Evidence demonstrates that it doesn't reduce reoffending, and time in detention doesn't work to correct behaviour or set young people on positive life courses. And it doesn't provide therapeutic care and settings. And we know some of the practices used in detention, like isolation, are profoundly unsafe and harmful. It also doesn't work to keep the community safer with cycles of reoffending set in train. And we also see it as a really expensive use of public resources that could be directed to things of social value. So governments are continuing to invest in approaches that fail. Young people tell us at Create that what they need is not isolation, confinement and punishment. What they need is a sense of care and belonging, support to address their trauma and challenges, hope for a future and a community that sees their potential and capacity to contribute meaningfully to civic life with the right supports and opportunities. So, we have Kelvin in the room, who is also in a position to share some insights and direct experiences and expertise of these systems. Thank you. Thank you
very much. So we might go to Kelvin first if we can, just so that we stay with the same grouping. So if you've got a very short, and I will again just say we have got limited time for questions, so if we can keep it brief, that would be incredible. Thank you.
Greetings, Chair and members of the committee. My name is Kelvin Yen. I'm 20 years old. I entered residential care from age 12. I spent 5 years in residential care to 17. I'm a former Air Force cadet and completed my year 12 as an adult learner. I'm currently as a barista and serve as a young consultant with the Create Foundation, contributing lived experience insight to policy reform. Over the years, my path across almost every part of the system: child protection, health, education, youth homelessness, and youth justice, giving me a view of how these departments connect and where they don't. By the time I was 17, I was essentially homeless. There was no longer a place for me within the child protection system because I had essentially aged out. And I tried to return to my mother with limited support, and the environment was unsustainable because of deep-rooted family dynamics. It was in this context I behaved in trauma response ways that resulted in contact with the police, then youth justice, because there was nowhere to house me. Pending charges against me were dropped, but I still had nowhere to go. The judge said, "Best of luck to you," and I was left with a caseworker, no home, all to figure it out myself. Youth justice was not my destination, but the system's last resort. My experience is one of criminalisation of trauma stemming from family violence, and when I was removed, gaps in the system that I needed to navigate from the age of 12. In detention, I met another young person from rural South Australia who told me there's nothing to do but crime for fun. That single sentence captures more than just frustration. It reflects community deficit, boredom, disconnect, and lack of structured opportunities. What I witnessed in detention was absence of early family support, absence of role models, absence of emotional literacy. Many of the young people I met came from families where violence had been present for generations. This wasn't because they were bad families, but because no one had ever interrupted the pattern. Like my family, a family experiencing domestic violence draws on police resources, then housing crisis support, mental health services, then child protection, and eventually youth justice. Each intervention addresses a symptom, but none breaks the cycle. It didn't break the cycle for me. Thank you, Chair and Committee.
Thank you very much, Mr Yen. Mr Brooks.
Thank you, Senator. I'm a Bidjara man, just like to acknowledge others who've acknowledged country also, and my colleagues online. Just people they don't know, I've been in this role 7 months, 25 years in government, started as a Queensland Police Officer, Deputy Director General Education, Youth Justice, and also the Commissioner at the Queensland Family Child Commission. Under WhatsApp, we have both the Youth Justice and the Aboriginal and Torres Strait Child Protection peak. What that means is around 140 CEO-led organisations that we provide a service to. In short, I'm really keen today to discuss support for the national standard. Thank you, Senator.
Thank you very much, Mr Brooks. With that, we will move into questions, and I'll give the call to Senator Stewart.
Thank you very much, Chair. Before I go into my questions, I just want to say thank you very much to Calvin for coming and sharing your experiences with this committee. The lived experience of people who have been through the system is really invaluable. And I think it takes a lot of guts to come and share some of the really toughest times in your life in a really public way in a forum like this. So thank you very much for doing that for this committee. I've got a couple of questions for Emerge in the first instance. You have spoken about a gap in terms of programs for kids aged 5 to 7, which address impacts of maltreatment, trauma and family violence on children. Can you explain what the gap is as you see it, and how what you do helps kids in the gap?
Thank you for the question, Senator. So there are 2 critical gaps in the specialist family violence system across Australia that I would like to point the committee to. The first is a system-wide recognition of children as victim survivors in their own right. The second is evidence-based support to address the impact of trauma on children, and this gap is the critical one to break the cycles of violence. In our submission, we address the profound effects of trauma from family violence on a child's development, health, behaviour and well-being, and we identify that exposure to family violence is the most common form of maltreatment experienced by Australian children. And children start demonstrating the impact of this trauma in their behaviour when they're young, often with big, challenging physical behaviours. Some of these behaviours mirror the violence that they've experienced. These are the children that are far more likely to be suspended or expelled from school. These children intersect with child protection, out-of-home care, and other children who are far more likely to end up in our youth justice system. And they're the children who are the most likely to grow up to use violence as teenagers and adults. To break the cycles of violence, we can support these kids in early intervention work that is embedded within the family violence system. Responses must be embedded into service responses and work in a whole-of-family model with a kid's safe caregiver. The outcomes from the pilot year of our work demonstrate that with evidence-based early intervention, children can be supported to recover from trauma, participate safely in school, and develop the capacity to have safe, healthy relationships free from violence and out of the justice system. Thank you.
So what does that work look like in the programs that you run?
Sure, of course. I'll speak a little bit to that and talk to the results from an independent evaluation by the RMIT Centre for Innovative Justice in a team led by Elena Campbell. So these are kids that are coming through the specialist family violence system and have often had an intersection with refuge and, as I've said, child protection, out-of-home care and police, and have often intergenerational experiences of family violence. The kids that we work with all present with challenging behaviours that are linked to trauma. Many are having trouble at school and, as I've said, have CP involvement. And many mums report that they try to find help for these kids and they can't get it. Meanwhile, the trauma behaviours are escalating, all while the family are also trying to navigate the other consequences of family violence, including homelessness, economic insecurity and disconnection from community, particularly while they're within a refuge response. The children go through a semester-long program, often with their siblings and a safe caregiver, with an evidence-based early intervention model for care that involves not just the family but the school, because school is a protective factor for these children. On the outcomes of the pilot program, every child who participated demonstrated a significant de-escalation in the unsafe behaviours, or they completely stopped. They attended school, the safe caregivers reported safer homes, improved attachment, improved parenting confidence, and critically, hope for a better future with their families after family violence. The evidence is showing us that child-centred, evidence-based early intervention can support traumatised children to regulate their emotions, have safe relationships, and significantly decrease or stop using violent or aggressive behaviours that contribute to a journey into youth justice. It shows us that a whole-of-family program model embeds a core principle that each child is a victim survivor and a person in their own right, and that model of care is crucial for long-term recovery.
And so are you saying the problem is that kids aren't seen as a victim in their own right in lots of the work that that governments do or organisations might do, that they're seen as a part of a family system, but they're not necessarily, there's not that kind of individual work on them?
Yeah, that's correct, Senator. The model is designed around the family unit with the safe caregiver adult at the head, and across a lot of the system, the child is considered as a data point rather than a person, and the model and the funding is built around an understanding of one family unit rather than individuals within it. And within this system design and this funding model, the child is often lost, and programs and services don't respond to their individual needs, which can be different to their mums and their siblings. So core to system design and system reform needs to be that recognition that a child is a person, an individual with their own rights.
Doesn't seem that radical.
No, it's not.
And you've got a program called Back on Track, is that right?
Yeah, that's correct. Yes, that's the program I'm talking to.
Want to tell us about that?
Yep, so that's the model for early intervention for 5 to 12-year-olds. That's embedded within a service response for children who come through refuge and through the specialist family violence system. That was the evaluation that I was speaking to.
Oh, so this is the program you were talking about.
Pardon me.
I didn't have the name for it yet. Okay,
sorry.
No, that's completely fine. Sorry, I don't want you to have to double up
no
on,
worries at all.
I might go to Kelvin before I have to share the call. I'm just wondering if some of that evidence from Emerge resonates with some of your experiences through the system as well.
I would like to acknowledge that, yes, Senator, a lot of it does resonate with my experiences, especially how it is important emphasis on preventative measures, as well as having that individualised, tailored support.
Yeah. And if there was one thing that overnight we could, flick a switch and change that would have made a difference for you, I know that this is a big question, but if there was one thing that could have, really changed for you overnight that we could do, what would it be?
I would say having the autonomy and the options available to me, not just having that one option that leads me into entering the youth detention centre, having that therapeutic approach and be able to work through it with the guidance and advocacy necessary to not end up in the last resort place. From a standpoint of view of behaviours that stem from trauma responses.
So you think, at some of the, trickiest parts in your life, someone actually just chatting to you about what you needed to get back on track would have been really useful, and putting you in the driver's seat for what you needed to.
Yes, 100%. And I was fortunate enough to have people within my circle, indirectly or formally, to be able to give me that approach after youth detention, such as an agency, or especially importantly in education. I had a high school year coordinator leader who was specialised in vocational training, and he got me back on track with my education, even though I couldn't formally complete year 12, but I was able to get a certification in being a barista. And then I had another agency to support me in housing infrastructure, and I having a safe place to complete my vocational training to be where I am as of today, Senator.
And this will be my last question before I share the call. It's interesting you talk about that person in high school, education support officer. For lots of I'm First Nation, so for lots of career kids, we've got a career education support officer in schools. And I often reflect on the difference that he made for me in my high school years to get me through to year 12 when the stuff at home was a bit tricky. Do you think we need more of those types of supports in schools for kids?
100%, because what we don't know as of now is what the outcome would be. So the better informed we are, especially through a strong role model leader or someone who's able to provide you the option where you have the autonomy to choose out and build your infrastructure for your life, really comes a long way and makes a meaningful difference, how it pivots the trajectory significantly and builds that compound interest over time from us children who are human beings to transition into adults. So it's essentially not just child focused, but a human focus where this child will transition into an adult and best tailoring that support so they can contribute meaningfully to society and community.
Yeah. How do we set them up for that transition well from being a child to an adult? From my experience, it was having key people and key agency and key bodies to advocate on their behalf and help best support me to build my confidence in choosing the right pathways to better myself, such as having that person in high school who really helped build insight and signed me up to do the barista training course, which I've completed and qualified in as of that. So you're saying you're good for a good coffee. That's what I hear.
100%. Thanks to that one person that helped me out in school and the people that also helped me up with the infrastructure so I can best complete my education.
Thanks,
and not fall through the gap.
Yeah. Thanks, Calvin. I really appreciate it. Thanks, Chair.
Thank you very much. And before I hand the call to Senator Shoebridge, if I can just ask you, and we're talking about that transition from the sort of being a child to adulthood, and we have heard evidence in this inquiry that even 18 is too young, and there are some programs that are looking at supporting young people through to as late as, I think, 26 years of age. Do you have a view of that? Would that have been more helpful to have helped you, I guess, from sort of 17, if it had helped you a bit longer than just getting to that arbitrary age of, you age out of the system?
100%. Having that post-care support to continue onwards after 18, because the real adulthood, from my perspective, doesn't necessarily start from 18. It feels like more like 20, where you're actually experiencing the real first years of adulthood and having that necessary village model support network to best prop yourself up towards the age of 26 makes a significant change in trajectory for the better.
Excellent, thank you. Did anyone else have a view on that? Feel free to jump in, otherwise I'll hand the call to Senator Shoebridge. Yes, please go ahead.
Yeah, just affirming what Kelvin already shared from a personal perspective. We hear that a lot at Create Foundation, that the transition from care into independence can be really difficult for young people, and it's highly variable, the transition supports that they receive across different jurisdictions. It can be a time when young people feel really alone and they have to navigate very complex systems, and often there's disadvantage and lack of opportunities that they're experiencing as a result of their care experience. And I think in the general community, we know that young people do these days require a lot of family support to transition to independence. I just also wanted to say, it struck me, Kelvin talking, it's pretty basic what young people are calling for. Like one person can make such a profound difference in their trajectories and their life outcomes. They need someone to listen and show up and support them to have agency and choice and be set on a course towards their aspirations and goals. And it's pretty basic what they need: a place to live, something to do, and someone to love. And sometimes the children and young people growing up in out-of-home care, unfortunately, haven't got access to some of those basic human needs.
Excellent. Thank you very much. It's very helpful for us, I think. Senator Shoebridge.
Thanks all for your evidence. Kelvin, now you think back on it, the first time you got sort of sucked into the system or brought into the system, if you were to come back and sort of tell us about what that experience was like for you, as I think you were 12, were you? Can you tell us from memory what that was like? And I doubt at the age of 12 you had any idea what the system was going to do with you for the next 5 years. But, yeah, can you shed some light on that for us?
Yes, I'd like to acknowledge your question, Senator Shoebridge. So as you perfectly captured, as at the age of 12, you don't necessarily know what 100% was going on. Only the fact that you've been told you're no longer going back to your caregiver / parent, and the reason behind it isn't really necessarily said, but the actions that you witness as a young person builds an image on why. And from my story is I was on 1 year orders, and then I would go back to my parent, but we still have that deep-rooted problems, family dynamics, where then I just continuously would go back into care, and then a reattempt would occur, but I'll still end up in care. Eventually, where all options become exhausted, where then I'll be in contact with the police and the youth justice system.
Yeah, and if you were to think about the number of different officials that you came into contact with in child protection, police, youth justice, school, how many different officials do you think would have sort of had some involvement in your life over that time?
There was plenty of people that came and go within my lifetime. As you said, whether it be in education, health, police, many hands were involved, many people come and go. Perfect analogy would be as if I'm on a train and people come off onto train stations and come back on throughout my whole journey from when I was 12 or even before to when I was to now.
But then there was one person who got on the train who kind of made a connection with you. And is that really that's kind of where things started sort of going on a pathway towards where you are now? Just happens to be one person who got on the train with you who made that connection?
Yeah, 100%. Even that one key pillar person. So there will be many people that would be a pillar in my life. But this one person within the education space, he saw me from year 8 in high school all the way to year 11/12, and he's seen my progression, and he's fully aware that I come from a care experience background, And when I reached to the senior years of high school, his best emphasis on the truth, where would you like to go, considering that you are from a care experience? And then when I entered youth justice, he sat down with me and said, your circumstances really has affected your schooling, but I'm here to still support you through this. And these are the scenarios that, with consideration to your circumstances, to best support you into the near future, transitioning to an adulthood, which was vocational education. And he said you definitely can go back to formal education once you're in a better headspace and environment.
And was it at that moment when you'd gone into the youth justice system, it must have been pretty frightening, having someone who knew you, who was loyal to you, who was in your corner, must have been pretty important.
Yes, 100%. So going into the youth justice space is the same thing with going into child protection. You don't know what's 100% happening and what not. And you're in an environment that is unpredictable and have different certain dynamics. For in my case, I had pending charges, but essentially I was housed in youth detention because the child protection space wouldn't take me back because I essentially aged out by the age of 17. And there was very limited infrastructure and other supports that were willing to take me on board. So with the information I had at the time, the outcome was that I'd stay in youth detention until things were resolved.
Yeah. Claire, when you're thinking about families and kids who are coming into your programs and you hear Kelvin's story, how does your program change that story?
So our program is designed to intervene during primary age while a child and their safe caregiver have an early interaction with the specialist family violence system. So as the committee would know, tens of thousands of children and families come through that system across Australia every year. They are provided with refuge response, case management and other specialist supports, but often it's a crisis-based model, so you're not getting that early intervention and behavioural support for trauma. So listening to Kelvin's story, and thank you for your courage, Kelvin. I'm really touched by your story and your amazing recovery. You're a very strong person. Thinking about keeping families together early when the kids are young, I think is a critical missing lever within the system, particularly supporting often mum to recover from the trauma and work with a whole of family model, because mum is impacted by the trauma too. And I think we're hearing this across the system. The ability to be a safe, attuned, regulated caregiver and develop safe and healthy attachment in home is critical, but trauma impacts mum's ability to model that for the child. And so you've got a whole family unit that requires a support that's embedded when they interact with the system.
You see, Kelvin's story, Kelvin, you start telling your story from when you're 12, which is when you started getting involved with the system, right? But imagine if instead of the system engaging with you and your family when you were 12, what if they'd been there when you were 5 and been trying to work with your mum and work with your home and work with your family? How different do you think that might have been, Kelvin?
It would have made a significant change, considering that there's ample enough amount of time to work with the families, to know the dynamics in history and the cultural lens, most importantly, and work with the families on how to best approach using the education and knowledge to better parent and better be a better caregiver. And if things don't work, then you escalate to other options involving extended family or kinship, for example, opposed to having the fallout with the family and ending up in residential care.
Kelly, some of this sounds like help way earlier. How much does this come back to help way earlier from your perspective?
Thank you. Yes, it is It's so fascinating hearing Calvin's story, and thank you for sharing. I think it just points to that evidence that every child deserves and needs two non-parental adults to support their well-being. For me, the help earlier aspect and to the point from Emerge earlier about the gap in systems support, we know that investment tends to focus on birth to 5 years or then adolescents already offending, usually from 12 and above, and the gap for us is in that sort of 8 to 12 years space. And actually that's where we start to see really obvious signs like school disengagement and the influences of peers strengthen and behavioural problems escalate because children aren't getting the basic sort of regulation and emotional support that they need. And that's often where offending pathways emerge. So for me, that's the real gap in the earlier system investment.
Yeah, from 0 to 7, you're a child who needs help. From 12 plus, you're an adolescent who should be put in jail. And from 8 to 11, you're kind of invisible in some ways.
Yes, and I'm nodding, but the bit that, you know, children should be in jail is
no, it's horrible. I'm not. That whole construct is broken. Let me be very clear.
Yeah. Look, for me, I've got an early childhood background, and the first thing we learn is that all behaviour is communication. And I think that, you know, when we think about it that way, these children are asking for help in the only ways that they've learned how, in the way that is often modelled in their home environments. And so that's the early point, right, where we provide the supports and that wraparound supports to prevent a pathway into youth justice. But that same approach should be for those children who do end up in the youth justice system, that we still treat that behaviour as communication, and then we address the support and the help that they need rather than just a deprivation of liberty.
Now, Philip, you've been in the system, right, which has been delivering these results we've been hearing about. When you hear this, you hear Kelvin, you hear Claire, you hear Kelly, you hear Imogen, and you hear the evidence that we've had. From within inside the kind of system perspective, how do you see a way forward?
Yeah, thank you, Senator, for your question. And it's a really interesting thing. I think what I implore the committee to think about is how to actually make the complex simple. So two things. I know our Commission of Inquiry went to proximate causes and it unfortunately ignored structural causes. Yeah. Which is something that I'll talk about in a sec. But the complex simple, there's two parts to it. That if I go to the proximate causes, how we do that, it's really simple. The evidence is really clear. There's three things that make a young person turn their back on crime. And of course, I'm making a simple statement out of a complex issue. But that's empathy, focus on the young person's education, and a focus on a young person's supervision. So supervision doesn't mean a security guard over there. It means love, support, somebody currently in their life, someone who cares about them, someone, you know, who's going to be there when times are down. So those three things are around the proximate causes. On the other side, the structural, and I think this, Senator, you and yourselves would be great to consider, is the national minimum standards. And some of those things that you could look at those minimum standards is the primary focus on structural causes and just not the proximate causes, such as poverty. One was really interesting when I was in youth justice in Queensland, and it is dated, I understand that, but when you removed all race and just put in poverty, unfortunately, non-Indigenous children were just as overrepresented when they were due to their actual economic backgrounds. So having a look at intergenerational wealth and how we build that for young people who aren't, unfortunately, born into generational wealth, and we can build that over time.
The number of times we've heard about young people offending to get a roof over their head and a warm meal, the number of times we've heard that in this inquiry, I couldn't tell you. And that does kind of speak to this is actually a system to deal with poverty and that kind of economic insecurity, isn't it?
Yeah, or instability in the family home. And I think, Calvin, again, thank you for sharing your story. It's just everything you said today, unfortunately, can be mirrored in so many different other young people experiences across the system. And as you said, the family support at home, and it could be mirrored in a range of different ways: alcohol, drugs, domestic and family violence, all the way through to instability of housing. Unfortunately, the proximate cause then, as a result of that, ends up being, as you said, breaking into homes, houses, etc. Cars, etc.
In fact, the more proximate you get to whatever the behaviour is, as the system gets closer and closer to examining whatever the social behaviour is that's led to someone being drawn to the attention of the system, the less likely you are to actually fix the problem. Because these are kind of entrenched problems that have been happening sometimes, for years. And yet our whole criminal justice system can look at 10 seconds of interaction and then judge you on that 10 seconds of interaction. That seems to me...
Absolutely, and it'd be... Sorry.
No, you go, Philip.
Thank you, Senator. Sorry about that. Yeah, and one of the things I'd really encourage yourselves to have a look at is, unlike child safety, the intake is actually done by a completely different system, and child protection obviously has control somewhat over the intake and how to deal with young people. In this case, it's police and courts. So one thing I'd implore for you to have a look at is the difference regarding the opportunities and discretion that's provided to young people when it comes to the criminal justice system, and what the discrepancies are. I don't know specifically what they are. I can talk anecdotally, but it'd be great for you to have an understanding of what that is.
Yeah, thanks everyone for your evidence today, and Kelvin, you've brewed a perfect cup for us today, so thanks very much.
Thank you very much, and yes, particularly to Kelvin. It's always more challenging, I think, when you're sharing personal stories, and we very much appreciate it, and it is a very valuable part of the evidence that we're collecting. So thank you very much. If there is anything that you will, get home over the weekend and think, gosh, I wish I'd said something else, please send it through to Secretariat. We would be very grateful. But otherwise, thank you for the work that you're doing in the community, and with that, you are released. And we will just suspend for I now welcome representatives from the ACT Council of Social Service. Thank you for taking the time to come and speak with the committee today. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could I please get you to state your full name and the capacity in which you appear?
Dr. Devin Bowles, CEO of the ACT Council of Social Service.
Fantastic. And do you have an opening statement today?
I do not.
You don't? Fantastic. We will jump straight into questions then, I think, and I will give the call to Senator Shoebridge.
Yeah, thanks, Chair. I suppose I wouldn't mind you telling us about what your experience has been, given the reforms that the ACT has put in over the last couple of years about raising the age. Yeah, if you wouldn't mind just sort of sharing with us what's been happening on the ground.
Yeah, great question. And the changes include raising the age of criminal responsibility to 14. And I note that Australia's federated system really is a laboratory of democracy. And so it enables us to see what is working well in some jurisdictions when there is significant difference between jurisdictions in policy or implementation. And regarding the minimum age of criminal responsibility, there is a big difference. And the difference between 10, as it is in some jurisdictions, and 14 is immense. What the evidence predicted is that the 10 to 14-year-olds who were being diverted from the criminal justice system would be having a high level of trauma in their backgrounds, and that they would have a high degree of unmet economic and psychosocial needs. The ACT's experience absolutely bears that out, and the policy or legal change in the ACT is changing the lives of children. What we are seeing is that people aged 10 to 14 who are being diverted from the youth justice system are engaging well with therapeutic supports, that those therapeutic supports are reducing the risk of behaviors which can be considered criminal, that police engagement with those children appears to be reducing and changing in nature, and where there are children of similar backgrounds and perhaps needs of different ages, some of whom got the benefit of the legislative reform and some of whom did not because they were too old. They were 10 to 14 before the legislation, or they were 12 to 14 before the legislation came into place. It's early evidence, but it appears that they are having really different lives and engagement with the criminal justice system. One reason, and maybe the primary reason, that as a society we want to punish people who have committed crimes is to keep the average Australian safer. The evidence from the ACT shows that the way to do that when an offender is between 10 and 14 years old is to divert them from the justice system into a set of supports that is designed to make them less likely to offend and to meet their needs. One important lesson from the ACT is around cost, and I'm sure each of you have a keen eye on the taxpayer dollar, and so do we when we make policy recommendations. We've done some rough calculations and found that over the last 4 years, prior to the reform, on average, the number of children years in the youth detention centre in the ACT was 0.7. At a cost of around $4,000 a day, that meant that the ACT was spending just over $1 million locking up kids aged 10 to 13. Instead, and that, I should note, does not include the significant expenses associated with courts.
Or police.
Pardon?
Or police.
Or police, yes. And so the total cost of the therapeutic support panel and the Safer Youth Response Service, which are the programs that take the place of incarceration, is less than that. It's under $1 million. What's more, they include services to people who are identified as being at risk of offending. So it is affecting a larger set of children. And in the case of the therapeutic support panel, is open to children through 17. So it not only costs less, it's intervening positively in the lives of a much broader cohort of people who are at risk of criminal offence.
And of course, the 0.7 years doesn't include the benefit of keeping young people out of detention when they're 15, 16 and 17, does it?
That's exactly right.
So it's probably even greater cost saving than that.
That's exactly right. So what the evidence from the ACT is not only that this legal change is changing children's lives, but it is saving the taxpayer money, and it is providing service to a much broader range of children and young people, keeping the community therefore much safer. And that calculation that it is less expensive does not include the fact that all the evidence would suggest that a child who has received therapeutic supports designed to make them less likely to engage in criminal behavior is indeed less likely to engage in criminal behavior than someone who is incarcerated.
Do you have any preliminary data on what that's looking like? Because, you know, we know from other national data, recidivism through the youth justice system is at 85%. Do we have any preliminary data about change in behaviour?
It may be that some will be published by the Therapeutic Support Panel in the coming months, but at this stage it is too early for ACTCOS to say much.
And because of the wider net that you're looking at, people at risk of offending, young people at risk of offending, maybe the data sets don't there may be apples and oranges.
Yeah, I think there might be some methodological ways to approach that question. But based on the evidence we already have, we can see that this is a much more cost-effective response.
But it's not an abstract discussion in the ACT now because the system's in place. So what does it mean? Let's pick an example of a 12-year-old who's facing, you know, a deeply troubled home or actually, scrap that. Why don't we pick an example we heard earlier today? 10-year-old kid who their parents, their dad went and stole a car and took the 10-year-old child with them. In another jurisdiction, they've been sentenced to jail. They were put into youth detention as an accessory to theft. And we were hearing about that earlier and about that 10-year-old's experience in jail. What would happen in the ACT to that 10-year-old?
The 10-year-old would not be prosecuted as an accessory to their father's theft of a car. More than that, they almost certainly would be put before a therapeutic support panel that was able to assess their psychosocial needs. Now, what we found in the ACT is absolutely what the evidence predicts, and it is that many of these children and young people have undiagnosed needs, which are, and disabilities, which are not being addressed, and which contribute to the increased risk that they will, at some point in their lives, engage in criminal behavior. And so a child in the ACT under those circumstances would be likely to be screened not just for their social circumstances, and it sounds like this child's social circumstances could certainly be improved, and that child probably has a significant trauma background that would benefit from being addressed, but also that the child may have cognitive or emotional needs which hadn't at that point been diagnosed and which might be.
And if home wasn't safe, would there be a residential care, residential therapeutic facility available? What would?
I'm not sure that there is a specific residential therapeutic facility available, but I think in any jurisdiction, if a child's home is found to be unsafe and that is not able to be remedied, they would be removed.
But if they've come before a panel and the care panel's made an assessment that a number of supports are needed, are those applied? Is there the funding there to supply those supports?
Yeah, that's right. And so my understanding is that child would receive those supports regardless of whether they were put into out-of-home care.
Chair, I see Ms Kippen has joined. So perhaps Ms Kippen, if you might just give your name and where you're from.
Hi, good afternoon, everyone. Yes, Bronwyn Kippen. I'm the Executive Director of Research and Policy at QCOS.
Yeah, and the parliamentary IT can be a little baffling, and we're sorry about that.
No problem.
Yeah, I might ask you my question, which is probably what the chair would have asked you anyhow. Did you have an opening address? Can be my question.
I do have an opening statement.
There we go. Well done. Teamwork.
Yeah.
Please proceed. Yes.
Thank you. I'd just like to begin by acknowledging the traditional custodians on the land on which we gather today. For me, it's the Turrbal and Yagara people here in Meanjin, Brisbane, and pay my respects to elders past and present. And in acknowledging country in this context of this inquiry, I wish to also highlight that most Aboriginal and Torres Strait Islander young people grow up with their families and are safe, healthy and well, and don't interact with the youth justice system. However, the youth justice system in Queensland continues to disproportionately impact on Aboriginal and Torres Strait Islander children, and we do encourage the committee to engage closely with Aboriginal and Torres Strait Islander peoples in connection with the inquiry. So QCOS, we're the Queensland's peak body for social service sector. It's great to be here with ACT COS today. And through our engagement with the community sector organisations across the state, we do see firsthand both the harms caused by the current youth justice system, but also the solutions that can create safer communities and better outcomes for children and families. And in our submissions, we outlined that the youth justice laws and policies can have complementary policy objectives of community safety and upholding rights of families, children and victims. And there is strong evidence that punitive responses do not reduce offending in the long term. Instead, they often deepen trauma, disrupt education in connection to family and community, and increase the likelihood of ongoing involvement in the justice system. And in Queensland, many young people in detention are held on remand rather than serving a sentence, and recidivism rates remain alarmingly high. And particularly concerning is the continued over-incarceration of Aboriginal and Torres Strait Islander children, despite commitments made to the National Agreement on Closing the Gap. And we see that real progress will require governments to invest in Aboriginal and Torres Strait Islander community-controlled organisations and support solutions designed and led by Aboriginal and Torres Strait Islander communities, as well as investing in improving the cultural safety of non-Aboriginal and Torres Strait Islander services. And QCOS, or we are concerned about conditions experienced by children in detention in Queensland. Our 2024 submission highlighted the use of watch houses to hold children, experiences of prolonged isolation and inadequate access to education, health and rehabilitative services. And more recent inspection reports show that the youth detention centres are operating above safe capacity, with children subject to separation practices and facilities that fall below short of what community expectations and human rights standards. And Queensland has recently introduced a range of policies and legislation changes that have moved further away from an evidence-based approach. This includes the adult crime and adult time framework, and we are concerned that these measures will result in more children spending longer periods in detention without addressing other factors that drive offending behaviour. And children who come into contact with the justice system are often the same children experiencing poverty. I think I heard some speakers speaking about that earlier. Housing insecurity, family violence, often children in detention with disability, mental ill health, and in disengaged from education. So we really, from QCOS's policy positions and feedback from our sector, we really want to see investment in addressing the root causes and supporting children and families to thrive. And in our policy submissions, we do outline the important role that the federal government can play, including the development of enforceable national standards, establishing a Federal Human Rights Act, and a strong focus on sustained investment in therapeutic, trauma-informed and culturally safe community-led services. And yeah, thank you for allowing me the time to make this statement.
Thank you.
Thank you very much. Did you? I will share the call with Senator Cox.
Thank you very much. I just want to ask you specifically, your report from 2022 has some really concerning trends in it. In particular, there were 8,200 kids in adult watch houses, and those watch house admissions had risen by 450%. Can you talk us through what you think might be the drivers of some of those changes?
We did see, I guess we see increasing overall from a community's perspective. We have seen an increase in family stress and impact on wellbeing, and that is flowing through to increase children interacting with the youth justice system, but also, I guess, increased kind of policing of public spaces and looking or responding to incidents in a more punitive way rather than in a therapeutic way. In terms of those specific numbers, I would have to, I couldn't point exactly to the specific reason for the increase, but overall across the sector, that's what we've seen across several years now, is that increased focus on more punitive approaches rather than therapeutic responses. And an overall pressure also on families and children in terms of capacity to maintain the wellbeing, maintain housing, and obviously that flows through to impacts on a child and a family's ability to stay engaged with school, stay engaged with services, and have those supports around them that they need.
Is there a formal mechanism that you use to gather some of that data, like consultations, surveys? How does that happen?
That particular data comes from the Children's Court report, annual report, so it comes from court interactions.
Okay, great, thank you. And a question for both of you, I suppose, is a lot of the focus that we've heard, particularly today, but across the whole of this inquiry, has really been around information sharing and, I suppose, Mr. Bowles, your commentary at the start of this, the lab of the Federation, is what's working well in different places may not be working so great in others. Is there an information sharing portal mechanism that the councils of social services across Australia use? And what does that look like? And is there an ability to strengthen that, increase its visibility? What does that look like?
So the councils of social service have a few mechanisms to share information, including regular meetings of the CEOs, but we don't deliver services directly, so we're not sharing information about specific clients. What we have shared information on is how different policy changes in different jurisdictions have occurred. And this does point to, an increasing division within states and territories, where in, for instance, the ACT, we see movement in line with the evidence, and in some other jurisdictions, perhaps most notably the NT, but also Queensland, we see movement against the evidence. I think it's worth noting that two of the drivers of criminal behavior in 10 to 14-year-olds are deprivation, so poverty, and having unmet or undiagnosed psychosocial needs. I think it is notable that child poverty is increasing. Poverty rose from 12.4% in 2020-21 to 14.2% in 22-23, so 102,000 more children in poverty. I think that trend would, in general, be continuing as the cost of living measures or cost of living problems continue to bite. And then not having disabilities responded to appropriately, and the changes to the NDIS system are likely, even if long-term states and territories are able to put in place an equivalent or better set of care to what was previously offered under the NDIS, there will likely be teething issues with that. And so we've got some large-scale drivers which we can anticipate will make this problem more acute. I think, as my colleague has noted, there are some really important things that the federal government can do in this space, and that when we think of the Federation as a laboratory of democracy, obviously constitutional constraints of the powers of different levels of government apply, but I think there's often a role for the federal government, once the results are in from the laboratory of democracy, to incentivize all jurisdictions to make use of that data. And I think the contrast of the ACT and, say, the Northern Territory is pretty acute, and there really is a need for the federal government to intervene.
Thank you. I don't know if Skipper wanted to add to that.
Yeah, I think it's just, I would agree that we see the very different approaches across the jurisdictions, so having a national minimum and mechanisms in place to encourage and require the states to meet those minimum standards would be really beneficial. We are seeing some investment in evidence-based programs in Queensland recently. There's been increased investment in some additional youth programs, but there are still, a lot of the legislative changes, for instance, and approaches are not haven't been evidence-based, and we'd like to see anything implemented aligning with the human rights principles and the evidence around what will create the best outcomes for the young people and their families.
Just as a follow-up to that, we did have some earlier witnesses talk to us a little bit about justice reinvestment and some of the, I suppose, effectiveness of that and improvements that can be made at, Do we have either of the jurisdictions that you represent, some of the projects operating within those, and how are they tracking from your point of view, and other improvements that you could recommend to the committee?
We point to, from feedback from our members in the research, we point to programs that look at the young person with the family. So, for instance, we have family wellbeing programs here in Queensland that are managed and delivered by Aboriginal and Torres Strait Islander organisations that look at the young person holistically and look at how flexible and have wraparound support in the context of their family and children. So their families and communities. So they have been demonstrated to be really effective programs, and we think and encourage greater investment in programs that really focus on the child and their family around housing, health and education. So we did some recent research that showed that our universal systems here in Queensland are fundamentally good, but for families and children that experience disadvantage, connecting in with those mainstream and universal programs can be difficult. So we really have seen some successful stories around things like health hubs embedded in schools, alternative school programs, flexi schools. So we really, really want to kind of focus on that support before kids are interacting so much with the youth justice system or having those types of programs there to support them more broadly in the community and their households. So we do have, research that shows those programs can be successful, but they do tend to be like pilots or on small scale. So what we really would like to see is those programs expanded and investing in that rather than in the kind of youth justice focused programs that are kind of tend to be later in the child's life.
Okay, great.
Maybe the clearest example in the ACT is having raised the age, the minimum age of criminal responsibility. And what that has done has shifted all children in a cohort to that reinvestment. And the evidence I provided earlier shows that that is much better investment from a taxpayer dollar perspective and from the perspective of the life outcomes of the affected children.
Thank you. That's it from me, Chair.
Thank you. Did you have any further questions?
I like cheaper and better.
Yeah.
But I'd be more than happy, given we're dealing with kids' lives, I'd be fine with more expensive and better too. I mean, the main thing here is better. And it seems to me what's happening in the ACT is better. And, as soon as we can get some compelling data out about how much better, that would be terrific. And you think a couple of months, is that right, Doctor?
I'm hopeful that the data from the therapeutic support panel, when it does its next annual report, it'll have some good evidence there.
And when we're talking about cheaper or whatever, this week the federal government has announced there was $29 billion in cost blowouts on 12 defence projects. And imagine if there was $29 billion to spend on all the kids we've been talking about. We wouldn't know what to do with the social workers and the support and the homes and their care. And I just look at the way this government, this parliament delivers priorities. And when I hear evidence like we've heard today, I've got to tell you, something's wrong and we need to fix it.
Well, it's interesting that you should mention cost blowouts because the ACT originally budgeted more money for the therapeutic support panel and Safer Youth response than it ended up spending. So as it happens, it was the opposite of a cost blowout. Mm-hmm. It was a surprise savings. So it's, again, from a budget perspective, other jurisdictions looking to what's happened in the ACT should take note of the fact that delivery ended up being less expensive than was originally forecast.
Yeah, being decent has all sorts of positive benefits, doesn't it?
Yeah.
Yeah. Thanks, Chair.
Fantastic. Thank you both very much for providing evidence to the committee today. Any additional information that you may have that may be useful for us as we pull our report together, we would be very grateful to receive. But thank you again and for the work that you're doing. With that, you are released, and we will now suspend until 3:15.
Great.
I now welcome the ACT National Preventative Mechanism. Thank you for taking the time to come and speak with the committee today. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could I please get you each to state your full name and the capacity in which you are appearing today? We can start here.
Rebecca Minty, ACT Inspector of Custodial Services as part of the ACT National Preventive Mechanism.
Ian Anderson, Commonwealth and ACT Ombudsman, appearing as part of the ACT National Preventive Mechanism.
Penny Matthew, President and Human Rights Commissioner of the ACT Human Rights Commission, appearing as part of the ACT National Preventive Mechanism.
Fantastic. And do you have an opening statement that you would like to make?
I have some very short opening comments.
Certainly, please.
Detaining children doesn't make the community safer. Detention should absolutely be the last resort. If children are going to be detained, they need to be provided with meaningful activity and education. They need to be better supported. They need not to be kept in isolation, particularly for extended periods. There needs to be better health and mental health support as well. There are far too many children who are in detention unsentenced, and that should be reduced. Robust data should be kept and published about the children being kept in detention. The minimum age of criminal responsibility should be raised by all jurisdictions, in our view, to 14. There needs to be more diversionary options to keep children out of detention and better support for children outside detention. Detention needs oversight, and we note that Australia's three most populous jurisdictions, New South Wales and Victoria and Queensland, have not nominated bodies to be national preventive mechanisms, so to provide the oversight that the optional protocol to the Convention Against Torture brings to people who are being held in detention. And finally, therapeutic models of care for children in detention deliver better outcomes and should be considered more.
Excellent, thank you. That was short. Usually people say that and it never is. Thank you very much for that. So we will now move into questions if there are no further statements to start off with, and I will give the call to Senator Stewart.
Thank you, Chair, and thank you for giving up your time this afternoon. I understand you've inspected the Bimbri Youth Detention Centre. You can see some nod. How was that inspection, and what concerns were raised for you?
Thank you for the question. I might take that one, and then if my colleagues have more to add. So as custodial inspector, I have responsibility under my legislation to review the Bimbri Youth Justice Centre every 3 years, and this is a comprehensive review, every aspect of treatment and care. And we inspect against independent standards, which we have published on our website. When we last did that review in 2024, we noted some real concerns at systems level, and I guess we came up with 15 recommendations of that review. First and foremost really was around the strategic vision of the youth of the centre and the model of care, and we found that there had not really been a clear direction from ACT government that really set the priorities for the centre. And so what we saw, this was really apparent when we went round talking to staff, because some staff talked to us about their approach to youth detention really being, a therapeutic one to help support young people and get them what they need so that they don't come back into detention. But on the other hand, we also heard from some staff that saw the centre really as a place to safely contain young people until their next date in court. And so they're two very different strategic objectives, and that led to the recommendation of a need for an overarching strategic vision that defines what we want from youth detention, because otherwise we see things like a drift towards containing young people to more security focus. And in different reviews, in an isolation review that my office did in 2023, we actually saw a really stark example of that. This was a time we were past COVID isolation restrictions in the community. There was no longer sort of a high risk lens for detention settings. And yet when my team went in, we discovered that young people were still being isolated on admission for up to 5 to 7 days to be cleared of COVID. This was at a time there's no restrictions in the community. So that contrast was really stark. And I think various groups have given evidence about the harmful impact of isolation. So it was very concerning to us that here in youth detention, 8 months after restrictions are lifted elsewhere, where young people were facing isolation on admission. And so I think isolation is a big concern, and it can be called, time out, it can be called various things, but it has an incredibly harmful impact. So there's some of the concerns that we've seen in the Bimbra Youth Detention Centre. And I think as well, going to what my colleague said about the value of oversight and OPCAT, I think that's one example that we went in with a preventive lens. We identified a real concern and we raised it as an urgent issue with the ACT government. And to their credit, within 2 weeks, they changed their practices. So for me, that's an example that the value of preventive oversight and OPCAT can bring, and the need for preventive mechanisms across youth justice in Australia.
We might just add and talk about the NPM's visit. So we did a joint visit with heads of agencies. We thought it was important enough to involve all of the heads. So it was Rebecca, Ian, myself and Jodie Griffiths-Cook, who is our Public Advocate and Children and Young People's Commissioner. And the reason the NPM decided to do a visit over and above visits that happen with the Inspector of Custodial Services was that the number of young people was tracking fairly high. So Bimbri can, and Rebecca will contradict me if I'm wrong, but it can comfortably accommodate about 21 young people, and the numbers were tracking into the mid-20s, and on a couple of occasions there were even 30 young people in detention, and we know that's the point when systems can fall apart. When we visited, because the numbers were so high, we were seeing efforts not to have particular cohorts of young people mixing. This was preventing them from accessing the school, which is actually very popular in Bimbri, the Murrumbidgee School. So very concerning for us as the NPM, and particularly me as Human Rights Commissioner, to see young people actually missing out on their right to an education, which of course is protected in the ACT's Human Rights Act on a non-discriminatory basis. We also saw evidence of a number of uses of force that were also concerning, and made a recommendation around body-worn cameras. And I don't know if Ian wants to talk about that recommendation in particular.
I'll simply add to that to say that generally we saw that there was a lack of reflective practice. So there were incidents like use of force, and there wasn't a process of actually saying what could be learnt from different instances and incidents. It was, as Rebecca has said, a focus on security rather than on actually rehabilitating and providing a better environment for the young people.
Thank you. And I suppose one of the things we've heard pretty consistently through the inquiry is the need to hear directly from young people. I understand that some of the work that you've done as well. What are you hearing from young people who have an experience of being in detention? And I'm interested in what they say they needed in terms of support before entering, and then what they needed in support after entering. Because I think, I think we have heard lots of really good evidence from different witnesses about it, but I'm interested what young people are telling you directly too.
Thank you for that question. I think when we do reviews, we prioritise always talking to young people. And in my work as well, we've engaged someone who's got lived experience with being in youth detention as part of our review team to try and, bring that experience when we're doing reviews. But I think, it's a great question, because the experiences of young people should be at the centre of all the work that we're doing. I think in terms of what what the young people wanted to stay out of Bimbury. I think that the family support piece was really crucial. It's probably Jodie Griffiths-Cook as the Children's Commissioner brings a lot of experience as well in that area. But I think, we look at the data around the young people coming in, and we're seeing, like, in the first 6 months of 2024, 90% of young people in Bimbury were on remand, and the median time they were on remand was for one night. So we're seeing, what supports do we need to stop that one night happening? Because a young person might be remanded overnight, and then when they'll appear in court on a Monday, come before a magistrate and be released. So I think it's about looking at those. What supports do families need? What supports do the young people need to avoid that one night? Because we know incarceration is a criminogenic factor that leads to further heightens risk. So that might be things like bail support. In the ACT, there's Aboriginal-led bail support for adults, but not for young people. It might also be a Sunday court sitting. That's something that ACT has tried in the past. There's been a pilot, a successful pilot. So, if a young person could come before a magistrate on that Sunday and avoid that incarceration, that one night, I think that would be really powerful.
So do you think the cost of doing that kind of Sunday sitting would far outweigh the cost of, X number of young people in remand overnight?
I think the challenge with implementing a change like this is the financial cost on paper might look significant, but you need to weigh it against the cost, the human cost for that young person of coming in, and the criminogenic propensity to stay longer or becoming involved in the justice system further down the track. So I think we need to be, as part of that cost-benefit analysis, we need to consider the cost and the impact on the young person coming into custody, and how traumatic it can be, particularly that first few nights in detention. They're often in a cell by themselves, they're in isolation, they're away from family supports. So I think that's really important.
I'd just add to that. I mean, detention in a detention centre is one thing, but there's other forms of detention as well. And so, as ACT Ombudsman, we did a report on the use of force by ACT policing over the last 5 years last year. And one of the things we pointed out was that there's a lack of alternatives to police custody. So young people who might be out late in the evening, if they are causing a disturbance, there's no alternative for the police other than to take them into police custody, because there's simply no other place for those young people to be taken that's a safer place. And so it could be as simple as actually having alternatives to police custody as well.
If I can just add one to answer the second part of your question about what the young people told us when we were doing reviews. One thing is around having supports for when they're out in the community, and so it might be a youth worker who's community-based that they can call when they need, they might need a lift somewhere. They might be thinking about doing something risky, but it's someone that they can call, and that sort of key worker model is something that we heard is quite helpful. And I think what we would like to see to Bimbury is in the ACT is more day release. So young people, we understand that sometimes young people may have to be incarcerated, but what should be done is like connecting them with the community as soon as they come in. What can be done to do community-based activities, finding jobs, getting jobs going, like being released each day to attend work or to attend education. And we see models from overseas, from Spain, from Missouri, elsewhere, that they have where young people do come into custody, their efforts are made right from the get-go to connect them to community during that time.
That has substantial benefits to everybody. Yeah, thank you very much for your time this afternoon. Appreciate it. Thanks, Chair.
Thank you. Senator Shoebridge.
Yeah, thanks very much, Chair. The part of what your evidence is the benefit of these systems being observed. Like that of itself provides a systemic benefit, particularly if the observations can then be made public. Is that some of the lessons that you're sort of trying to convey to us?
Yeah, it is absolutely critical that a light is shone on what goes on in all detention settings. I think it's too easy for the public to ignore the human beings who are on the inside and to not think about the reasons why they're there. So scrutiny is very important, and certainly as part of the NPM, we need to have NPMs in all jurisdictions, and they need to be properly resourced to do that work.
Yeah, I mean, Mr Anderson, you have two hats, don't you, when it comes to NPM? You're currently wearing your ACT hat, is that right?
Yes, correct.
But you also have your Commonwealth hat.
That's right.
How does that work between the ACT and the Commonwealth for you?
So it works very well in that...
Well, you would say that. But no, how does it work structurally?
So structurally, I have people who work on ACT issues and support me as ACT Ombudsman, and I have people who work on Commonwealth issues supporting me as a Commonwealth Ombudsman. But when it comes to a body like the Australian Federal Police, who also provide policing services in the ACT, I will occasionally look at them being both Commonwealth Ombudsman and ACT Ombudsman. So there's no question that I have jurisdiction either way to look at another Commonwealth body providing services in the ACT.
Yeah, I can absolutely understand why that is incredibly useful. I suppose your role as the national NPM, what is your role in relation to the extent that other states and territories have appointed a monitor? What is your role in relation to, say, South Australia?
So I have a third hat, which is I'm the coordinator of the National Preventive Mechanism. So that's the coalition of bodies that have been nominated by their government. And we seek to bring together the different bodies around the country to occasionally make joint statements on particular issues. We do a collective annual report each year, which is one of the requirements for NPMs to do annual reports. We seek to facilitate the sharing of expertise between different NPMs, so that there have sometimes been staff from one entity going and doing a visit to an institution with staff of another institution, so they can learn from each other's experience and expertise. We've swapped standards and other visiting standards and other material, so that a small body, such as in South Australia, a small, very unresourced body, can actually benefit from the work that's been done in a larger, better resourced body, such as the West Australian Office of the Inspector of Custodial Services.
So when you say that, the South Australian one is very under-resourced compared to the WA one, what is the kind of disparity in resourcing?
Well, WA, the Office of the Inspector of Custodial Services was a pre-existing body. I don't believe it got any additional resourcing when it was given the role of being an NPM for WA, but it is a reasonably large body that has a lot of expertise in visiting people in custodial settings. Right. In South Australia, the bodies that were nominated, there's basically it's a collection of official visitors. So you've got the training centre visitor, for example, who has, I think, 3 staff. Then you've got some official visitors who have no staff. And so it's a collection of individuals with statutory roles who've also been told that they're now the NPM for South Australia without any additional resourcing, with very little resourcing in the first place.
But there was no additional resourcing you can point to in WA either.
I don't believe there was. Not that I'm aware of.
So then, were there additional powers given in either of those two jurisdictions?
My recollection is that they were nominated to be NPMs. There may have been some legislation in South Australia. I'm actually not sure whether there was legislation. No,
if so, it was marginal. It wasn't substantive.
It was marginal, I think, yes.
And would that be the same pattern in the NT and Tasmania?
Tasmania's got legislation and has had a small amount of resourcing. The NT has had, I don't think they've had, they got a very small amount of resourcing from the Commonwealth for, I think, 1 financial year, but that has since ceased. I think there might have been some legislation, but around the country it's typically the case that the legislative basis is imperfect and the resourcing is certainly imperfect.
So, and of course in Victoria, New South Wales and Queensland, there is none.
So
there's neither resourcing or office or legislative measures.
Victoria and New South Wales, there's nothing. Queensland hasn't nominated an NPM, but they created a body called the Inspector of Detention Services, and they gave that role to the Queensland Ombudsman. They passed legislation, which is actually good legislation. It's based on OPCAT. It's just they don't call it NPM, and they provide it with resourcing.
So if you were to look around the country, even though it's not officially an NPM, Queensland might well be one of at the sort of more responsible end of the OPCAT.
So they have certainly consciously looked at the requirements of OPCAT, passed legislation which appears to deliver what OPCAT would deliver, and provided resources to a body.
So do you understand what the institutional resistance is from Queensland to name it an NPM?
No, they've made the same comments that New South Wales and Victoria have made about the suggestion that the Commonwealth should provide full funding for all NPMs.
So as we kind of look at, well, what about in the ACT? I mean, you have the sort of tripartite NPM, who's N, who's P and who's M. What was implemented in the ACT?
So there's legislation, which is great. We've each got full suite of powers to visit places of detention in the ACT. Resourcing-wise, my office received funding for one member of staff who acts as a coordinator across the three of us.
And did either of the other officials,
No.
no additional resources?
No. And that is a real issue, because an NPM should be taking regular preventive visits, and some of our offices are very small. So, Rebecca, if I out you as an office of a whole 3 people, my organisation is much larger, but it's got many, many different components to it. So a very large victims of crime component, for example. My staff for the Human Rights Commissioner, again, we're looking at 3 people. We work closely with our Discrimination Commissioner, so there's a little bit more in terms of staff we can draw on from her area as well, and we draw on the Children and Young People's Commissioner, but no additional money, no additional people to do the work.
And same for you,
yeah,
Ms. Minty.
And I think one of the important implications for that is, it's resource intensive to go and do a visit, but it's really important to be following up visits, because recommendations get made, and if they're not actively followed up, then they sit there on a shelf. And in terms of public accountability, the public needs to see whether these recommendations have been implemented or not. So I think that's a real challenge. It's more than just putting out recommendations. It's about that ongoing follow-up.
Well, I don't mean to be too cynical, but there's like an institutional interest to not give you those resources to follow you up and chase executive government to make changes, isn't there? One could
be cynical and say that governments do not feed the hand or the one that bites the hand, the organisation that bites the hand. I think the reality is the ACT is quite a small jurisdiction with lack of resourcing generally, so I'm not sure we can just say it's ill will, but it's not realistic to give us these additional powers without the additional resourcing.
But at the end of the day, though, it's a federal government responsibility under international law.
The federal government enters into treaties.
And
but the federal government doesn't run all the places of detention, which cost billions of dollars for state and territory governments to run annually.
You're pushing against an open door if you're suggesting that if any level of government's got a couple of $1 billion to run a jail and detention system, that they should also, implicit in that, have resources to run an oversight system. I'm not arguing with that. But the problem is this impasse, this national impasse, has led to a really, even where there is a notional NPM, a really patchwork and imperfect national model.
Yes.
And we're here asking, well, what is needed at a federal level to make this work?
So we would say that one of the things that's needed is NPMs for every jurisdiction that have the powers that they need and have the resourcing that they need. And we think that NPMs are there not just to assist and by providing preventive oversight to actually ensure that people aren't being mistreated, but also we actually help the detaining authorities themselves. And a place of detention that's being well run is actually a safer place for the staff as well as for the people who are being detained there.
Yeah, but I mean, if we had that sort of Cook's tour of the different jurisdictions, where would you? There's nowhere you would point to it, from my understanding, and say, well, yep, they've got the powers, they've got the resources, they've got the government buy-in to make it what it should be. Is there anywhere you can point to that would say that?
No.
So again, I hear what the outcome is: resources, leadership, powers. We're here asking, what should the Commonwealth do? And perhaps I'll open it up to all three of you, the N, the P and the M, to say, you've looked at this, you're in the system. What do you think the Commonwealth government should be doing to sort of, even if it's just from an ACT perspective, to drive positive change in the ACT? Dr. Matthew?
Well, I'd be happy to say that there should be resourcing coming from the Commonwealth.
Yeah, but we're not talking obscene levels of resourcing from the Commonwealth. I might come back to you about kind of what sort of numbers we're talking about, but Ms Minty?
Oh, I agree. I think resources and leadership. I mean, the Commonwealth willingly signed on to this treaty, and knowing full well that it involves commitments. It doesn't involve new substantive rights, but it involves commitments, and I think there's leadership required.
Yeah, it does sort of, I'm not going to hold you to it in terms of, a budget submission, but what's the sort of scope of resources you think that would spread across your three offices, give you the resources needed to not only be in and see what's happening, but be able to follow it up and, complete the whole role of the NPN? What's the sort of scale of additional resources? Are we talking, I'll give you an example. There's tens of thousands, there's hundreds of thousands, there's a few million, there's 10 million. Where in that sort of space are we?
So the Tasmanian NPM went through a process of actually costing out what they thought would be required for a fully functioning NPM for Tasmania, and Tasmania is larger than the ACT, for example.
But a not dissimilar population?
Not dissimilar population. And I think that it was something less than $2 million a year.
Yeah. So I mean, from a Commonwealth budget point of view, even in the Attorney General's department, that's kind of a rounding error. That's a accidentally signed consultant's report that happens. And it would make a pretty fundamental difference, that kind of federal leadership, even if it just came out of a federal chequebook, would make a pretty fundamental difference in the ACT, wouldn't it?
It certainly would do. I mean, Rebecca's made the point about the follow-up. So on the back of the NPM visit that we did to Bimbri, we've been working really hard with government on a new model of care. We're very invested in it now, having visited and spoken with every young person who was in the detention centre at the time on trying to make things better. So it does take a lot of time and there are very few of us involved.
But you guys shouldn't have to be running a bake stall in order to pay for the funding to do a really important job. That's kind of where you're at, isn't it?
We have to divert resources away from our other functions, which in Rebecca's case, when she's only got an office of 3 people, there's not a lot of resources to divert in the first place. If we're going to talk about other things, Senator, that could also, the idea of a federation is that if one jurisdiction pilots something, tries something and it works well, other jurisdictions can look at it and say, oh, actually, women's suffrage, that's a good thing, we should all do that. In the youth justice space, what we're actually seeing is a race to the bottom. And so there's a question there about whether there's something that the Commonwealth could potentially do, so that instead of having one jurisdiction saying, actually, we're going to lower the minimum age of criminal responsibility, we're going to reintroduce spit hoods, have another jurisdiction that says, actually, we're going to roll back our Human Rights Act so that we can keep children in police watch houses for extended periods in isolation. Another jurisdiction that's now contemplating rolling back their Human Rights Act so that they can not give people in detention, adult prisoners in detention, 1 hour a day of open air. So there's a real challenge there that jurisdictions are being able to simply choose to roll back existing protections.
The theory behind competitive federalism is competing to be better.
That's
what
right.
we're seeing in the justice space, and especially the youth justice space, is competition to be the meanest.
That's right, and standards being lowered.
Yeah, but this comes down to political leadership. Clearly some politicians think it's in their interest to be mean to children, to punish children for their some political benefit that they get. This is a question of political leadership, isn't it?
It certainly is. And I have to say that in the ACT we are swimming against the tide a bit. I don't speak for government, but we are the one jurisdiction that has raised the minimum age of criminal responsibility, with some exceptions which don't really make sense. I mean, yes, they're very serious offences, but if you don't really have the development to be held culpable for the lesser serious offences, I don't see how you can be held responsible for the more serious offences. So we are swimming against the tide somewhat, but we are a small and fairly under-resourced jurisdiction. That's the reality.
That's okay, because the tide keeps bringing in increased recidivism and increased social harm, increased, lack of community safety. That's what the tide's bringing in all the other states and territories. And, perhaps the data in the ACT could be a powerful political tool.
And one of the challenges is a lack of data that's being kept specifically for youth justice and children in detention.
Ms Mindy?
Oh, I was just going to add to that, but even in this context in the ACT with, good intent in a policy sort of setting, we found in 2023 that young people were not being able to hug family members at visits. And this was, I think, something that it was introduced during COVID times, that they put two tables and a young person there and the family member there, they couldn't touch without reaching. Obviously, there's reasons during COVID times, but once COVID went away, it was kept as a practice on safety and security grounds. So I think closed environments, practices can fester, can take place, and even when there's a good policy setting, you need that transparency and oversight to shed a light on that, which has been fixed now, but it's of great concern to me that can happen.
Yeah, well, I mean, one of the systemic responses to that, to systems that seem to be resistant to having child rights embedded in their practice, is actually to embed child rights in the legislation, to bed the Convention for the Rights of the Child into our systems. We hear from Scotland that they've done that, and it's not without its challenges, but it's with incredibly positive benefits. Did any of you have the opportunity to see some of to meet with some of those international delegations that have been out the last few weeks?
We actually worked very closely with government to bring some of those people to a seminar in Canberra, a round table. It was a video recording on Scotland, but we had David Maguire from Diagramma in the room with us and present on what happened in Spain.
Yeah, so if you had to reflect upon what Mr Maguire said about Spain and Diagramma and the lessons that they've learned over the last few decades of implementing that, and reflected on the differences with the ACT, where's the opportunities to reform in the ACT? When you left that, did you think, well, that's something we should focus on in the ACT?
Well, I think, to give her full credit, the inspector here has been making recommendations around the Diagramma model for some time, and the NPM visit was an opportunity to say, we're here not to just admire problems or criticise or throw rocks, we're here to help as well.
Remove my temporal statement about after seeing Mr Maguire in the last week. What do you think is there to learn from the Spanish model?
I think that it's really inspiring to see it, and I think it's not an overnight solution. It involves a long vision, and I think David himself talks about a 10-year, 15-year process. But in the meantime, I think there's some really concrete low-hanging fruit that can come from looking at the Spanish model. For example, day release for young people. I mean, in 2024, when we did our Healthy Centre review, over that period, financial year 23-24, there were 2 instances of young people being released to do something in the community, and that was one person who was sentenced So
Two. Just two.
Two instances. And so I say low-hanging fruit because, you know, there are plenty of activities in the community that young people can be going out during the day and doing and then returning to Bimbury for. And I think that's not going to cost a heap of resources and it will have great benefits. So, and I mean, David talks about in most of the diorama centres, you know, 60, 70, 80% of the kids are out in the community during the day and then return. You know, they might be playing in sporting teams in the community. They might be doing work, education, etc. So I don't think we need to wait 10 to 15 years, but I think we need to set that vision now and in the meantime look at the little pieces that can help us get there. And I think as well the staffing model is really crucial for me because we're asking youth detention officers to build rapport and work with young people one moment and then potentially turn around and use force on them the next moment. And that is something quite different that the diorama model does not impose.
Yeah. Just on a different front, we had a panel of different medical associations earlier. And one of the things they said was that apart from the ACT, there are no legislative standards for the provision of healthcare in juvenile detention facilities around the country. No minimum standards, no standards at all. Does any of your roles involve oversighting those legislative standards in the ACT for healthcare? Does it feature part of your work?
Well, it is not part of necessarily my work, but my colleague who has the enormous title of being the Discrimination, Health Services, Disability and Community Services Commissioner.
You couldn't fit that on a business card or a working year, but anyhow.
No, and she's actually got 12 areas that she looks at, but she is the Health Services Commissioner. So that's one of the strengths, I think, that our model of an NPM brings, that we have someone who's dealing with the health system all the time.
Do you know if they have the resources or they have the mandate to go into juvenile detention centres to see if those legislative standards are being complied with, if the level of healthcare inside detention centres matches that in the community?
I think so.
Would you mind taking that on notice?
But Beck, you might.
I'll probably add to it in my role of as custodial inspector when I do the Healthy Centre review of youth detention and for adult detention. I'll always have a clinical expert on the team, and we use our standards for detention, which are they're not clinical standards, so they're not looking at the minutiae of, you know, clinical, you know, medication provision, etc., but they're human rights-based standards. So we do look at the access to healthcare. We do look at, you know, young people's access, for example, after use of force, they must always have independent review by a clinical expert. So we do look at health as it fits into the broader system.
But none of you are responsible for looking to see whether the level of healthcare per se is meeting the legislative requirements in the ACT. It's not a criticism, it's just a question.
Yeah, I think if I came across concerns in a review, I would make a referral to the Health Services Commissioner.
Who takes complaints.
As a complaint sort of
but a complaint-based model has proven to be not an effective way of ensuring services are up to scratch.
But when we did our visit as NPM to the Bimbury Youth Detention Centre, we did also, as part of that visit, look at the health services set up there and the ability of the young people and children to access health services, and in particular, was there a correlation between having a much higher number of young people being in detention and their ability to receive the health services that they needed? And we observed...
Was there a correlation?
Well,
my assumption is there would be a negative correlation.
The primary impediment seems to be, as with many things in Bimbury, the overemphasis, or in our view, the overemphasis on security issues, so that sometimes young people are not able to obtain the health or education or other services because there's a perceived security risk with them being able to do that.
But the whole purpose of a legislative standard when it comes to health is to say, well, your rights to health should not be limited because you're in detention. That's the whole purpose of the legislative standard. And if what you're finding is actually, well, security measures are trumping provision of health, well, it sounds to me like it's not working.
Yes.
So my question is, I suppose, to you, particularly from a national perspective, Mr. Anderson, but if you could think about it from an ACT perspective, the three of you, if there was one of the options that was said in that last panel was there should be a a national obligation for detention centres to meet that standard, the same standard in detention as there is in the community. If that was legislated, I personally think that would be good, but then we'd need to resource it, wouldn't we? And we'd come to the same sort of standoff that we have at the moment on the NPM without federal leadership.
Yeah, so if there was a national standard, that would stop individual jurisdictions applying a lesser quality of services, being able to choose to do that.
Yeah, you can see a dentist unless you're a problem. Like, that's not the right to see a dentist.
Yes, that's right. But yes, there would no doubt then be a debate about who, if it's a national standard, then should it be nationally funded and things like that.
Well, it seems to me if it's an international obligation entered into by the Commonwealth, there's a powerful argument there that the Commonwealth also, as the jurisdiction with the greatest access to funds, should be helping out. And if there's a national health standard, well, then there would be an argument for the monitoring to at least to also follow the obligation. But what we can say with some comfort, it appears, after hearing this evidence, is that the Commonwealth entering into an international obligation and then not having a pathway to actually have it implemented nationally, and not having either agreement or coercion to have it delivered nationally, isn't a successful pathway.
That's correct.
Yeah.
You'll get no argument from the international lawyer here that obviously the Commonwealth should be implementing all of its human rights treaty obligations properly. And our Commission has certainly been very supportive of the idea that there should be a National Human Rights Act.
Yes.
It goes without question.
May I just add on the issue of health sort of standards? I think that in my view, that would sit very well with the NPM function with appropriate resourcing, because I think every NPM should, wherever possible, have a clinical member of staff, so that when you can integrate that sort of health expertise when doing reviews.
Yeah, and you think about the kids that are in detention. Overwhelmingly, they have 1, 2, 3 serious health issues. Yeah. And if you're going to really be able to do your job properly, understanding that and how that interacts with the institution they're in seems to me pretty essential anyhow, doesn't it?
Yeah.
Yeah, thanks, Chair.
Thank you very much, and thank you for giving evidence to this committee today. We very much appreciate you taking the time to share, and I think there's certainly some very good learnings to take from the ACT in terms of what's working. While it's smaller than some of the jurisdictions that we're looking at across the country, it's nice to see what potentially small changes that could be made. So if there is anything further that you want to add, if you go away over the weekend and think, there was some more information I would have liked to have shared, please let the Secretariat know. You can email that through. But otherwise, thank you again. Have a lovely weekend, and you are released.
Thank you.
Thank you. We will suspend. Thank you. I now welcome Ms Anne Hollands, former National Children's Commissioner. Thank you for taking the time to come and speak with the committee today. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could I please get you to state your full name and the capacity in which you appear?
Thank you, Chair. And my name is Anne Hollands, and I'm appearing as a private citizen today. But as you note, I was formerly the National Children's Commissioner, and prior to that, have done extensive work in child safety and wellbeing throughout my career.
Fantastic. Thank you. Now, did you have an opening statement you wanted to share with us before?
Yes, I do.
You do? Fantastic.
Thank
Please.
you very much. And thank you for the opportunity. And I'm joining from the lands of the Camaragal people. Chair, I know that your committee has heard remarkably consistent evidence from witnesses throughout this inquiry because I've followed it very closely. Last week, your committee heard from 4 international experts who presented on the different approaches developed in their countries over the past 20 years that have resulted in astonishing reductions in crime and incarceration of children. These different approaches have some common features, which I'll just note briefly. Features such as the fact that political leaders had the courage to try a different approach and to tell the public the truth about what works to prevent crime and make communities safer. These new approaches treat children as children, not as adults. They listen to children and their families in order to understand the unmet needs of vulnerable children, and they acted to make the safety and wellbeing of children a priority through improved health, education and social services, and they implemented evidence-based therapeutic services for rehabilitation and reintegration to the community. What you heard from these 4 different countries last week strongly echoes the recommendations for a practical reform roadmap in my Help Way Earlier report that was tabled in Parliament in 2024 about addressing the drivers of crime based on decades of evidence and the voices of more than 150 children I met in the justice systems. We also published a supplement to the Help Way Earlier report with detailed case studies from around the world called Evidence-Based Approaches to Child Justice. Last week you heard that in the United States, like Australia, the states manage the justice systems. However, the US federal government takes a leadership, oversight and monitoring role, providing funding to the states that can be withheld if states fail to implement evidence-based methods. In a similar way, national funding agreements are used in Australia for reform in other areas of policy, but when it comes to child justice systems, there is no national coordination for reform. In Help Way Earlier, we recommend a national task force be established by the Australian Government to build an evidence-based reform roadmap to assist the states and territories with their work. Help Way Earlier recommends a Cabinet Minister for Children and a Ministerial Council for Child Wellbeing reporting to National Cabinet, as well as legislative accountability for the Convention on the Rights of the Child. Most of the other 20 recommendations in the report are practical, concrete, evidence-based actions that states and territories can take on their own. But it's clear from evidence to this and the previous committee inquiry that states and territories are struggling and they need help. In Australia, our federal government already has skin in the game. There are numerous plans, frameworks and strategies for children's policy in different portfolio silos, but they are fragmented and uncoordinated. There is no one accountable for child safety and wellbeing, and this lack of national leadership and accountability helps to explain the persistent fragmentation and the failure to act on the evidence across the Federation. So we need a nationally coordinated approach. We need funding agreements with the states and territories that can be used as levers for implementation of evidence-based policy and practice reform. Chair, the fact that several other countries have achieved amazing results by having the courage to try a different approach over the past 20 years, and they have now built a strong evidence base, this should give us hope that in Australia we too can choose to follow the evidence and to try something different. Currently, we're making very poor choices, and this is difficult to comprehend given the weight of the evidence. We're wasting massive amounts of taxpayer funds on approaches that don't make communities safer while harming the most vulnerable children in our country, as you have heard again and again from witnesses. So the Helpway Earlier report demonstrates that crime by children is a symptom of their unmet needs and underlying issues that we're failing to address, and crime by children is not a problem that the justice system can fix. Our current approach of harshly punishing children as young as 10 has been shown again and again to lead to more serious crime. So finally, as National Children's Commissioner, I witnessed terrible things that I can't unsee and that I've shared with you at the previous hearing. There is nothing radical in recommendations to use taxpayer funds on evidence-based approaches that have been proven to work. It is a sober and reasonable approach to addressing long-standing problems in the public interest. Thank you.
Thank you very much, Ms Hollands. And I will note now that we have Reserve Magistrate Jennifer Bowles on with us. If I could just ask you, Ms Bowles, to please state your full name and the capacity in which you are appearing.
Jennifer Carolyn Ann Bowles. I'm appearing in my capacity as a Churchill Fellow.
Fantastic, thank you. And did you have an opening statement as well?
I have, and I apologise, I had the wrong link, so I'm sorry.
No, the IT issues, it does get complicated. So, no, we're very, very happy to have you online now. So please proceed.
It is a very short opening statement. I'd like to commence by acknowledging the traditional owners of the land on which I am appearing today, Wurundjeri, Woiwurrung and Bunurong peoples of the Kulin, East Kulin Nations, and I pay my respects to elders past and present and to those emerging. As I've previously indicated when I appeared, I'm a reserve magistrate with 25 and a half years experience as a magistrate, but more than 18 years were spent in the Children's Court of Victoria, presiding over criminal division matters and family division, so child protection matters, including intervention order matters. I am, as I've just indicated, appearing today in my capacity as a Churchill Fellow. I would like to thank you very much for giving me the opportunity to reappear. Since my previous appearance before the inquiry, the following has taken place. 1, I've accepted an invitation and I'm now a member of the Violence Prevention Partnership Collective, consisting of multidisciplinary experts and being an advisory body to the Violence Reduction Unit. The unit was established about 7 months ago by the state government in Victoria to implement a public health response to violence prevention in Victoria. 2, the Victorian Parliamentary Budget Office has prepared costings of an initial What Can Be Done service, which I previously gave evidence about before the committee. I have attached a link to the Parliamentary Budget Office costings and also the brief that was provided to the Parliamentary Budget Office for them to prepare the costings, and that was released only, I think it was last Monday it was published. 3, I've had a 2.5-hour meeting with Dr. David Maguire, the visiting CEO of Diagrama Foundation Spain, who I know appeared before you, and discussed with him both the What Can Be Done model and the proposed youth therapeutic orders that I made in my Churchill report. He expressed full support for our model and agreed that for many, a homely yet secure therapeutic setting is initially necessary. He also agreed that making these orders and giving young people the opportunity to access the therapeutic service before any subsequent consideration of potential sentencing, which is part of my model and which was unique from what I saw overseas, enhances the rehabilitative prospects for young people. 4, on the 30th of June 2026, I attended a seminar hosted by the Violence Reduction Unit, which included a keynote address from Karen McCluskey, CEO of Community Justice Scotland, who I know has also appeared before you. I had an opportunity to speak with her also after her presentation. She noted that she's involved in adult drug rehabilitation facilities, but not youth. And when I raised that with her, she acknowledged that's something that she would need to look at. She saw the need for it as well. And finally, 5, the approaches taken by Spain and Scotland are consistent with the principles of our What Can Be Done model, a health and welfare perspective, the importance of identifying vulnerable young people and implementing early therapeutic interventions, the understanding that the punitive lock-up approach is not the long-term solution for enhancing community safety, and the importance of protective factors such as education and training and support for young people in reconnecting with family and the community. Thank you.
Fantastic. Thank you very much for that. And thank you again for both appearing. I think I'm always reticent to speak on behalf of other committee members, but we did find your evidence earlier on in the hearings incredibly beneficial. So we were quite excited to have you come back as we've got further through our own evidence gathering and I guess in terms of the thought process that we've been going through. What we will do now is go to questions, and I might start with Senator Stewart.
Thank you, Chair, and thank you for returning to give evidence to the committee. I appreciate it. Magistrate Bowles, I might start with you. I am interested in the costings.
Yes.
You got back. If I can just ask you to speak to those. I know you shared a link, but it'd be useful for us if you can just speak to some of that, please.
I have shared a link, and I should have probably asked that my opening statement and also the attachment be tabled, Madam Chair.
We can do that, thank you.
Thank you. In relation to the costings are prepared on the basis of what I've described as the What Can Be Done proposed initial service. So it's effectively establishing a facility. I believe we need them throughout each state and territory, right across Australia. But if there was to be an initial service established, what would that look like? And so the costings are prepared on the basis of that one model. It involves 24 single ensuite rooms. So initially there is a secure facility which would have 8 beds. The proposal is that 6 of those beds would be expected to be used all the time. But as we often find, there are urgent cases where we just can't wait. So there's extra 2 beds would be able to be utilised for those emergency situations. The costings involve full-time clinical staffing, education on site, and would start with an initial secure home, and then there'd be a number of other homes on the same facility, at the same address or the same location. It would be for 14 to 17-year-olds is what's been proposed for the initial service. And I've indicated in my submission that, as I've said in my report, there is a need for First Nations specific facilities, but this is, and this could be applied to a First Nations facility, but there needs to be a separate First Nations facility. So there'd be 6 secure and 2 emergency beds to start with. There'd be 12 male beds, 6 female beds, and the proposal is on the basis that there would be 3 bedroom clusters. So there'd be a number of individual homes on the site. There'd be schooling on the site, training and recreation facilities on the site. The costing that the Parliamentary Budget Office has determined is that to build the facility would be $40.9 million. Their proposal refers to commencing building in 2027. They've said it would take 2.5 years to finish, which obviously I'm pretty devastated at that because, you know, I did my report back in 2012 and there's a whole generation of kids who've now gone through and, in my view, haven't had the benefit of what I'm recommending. But that's their proposal. In terms of the operating costs, what they've indicated that as the way they've described it, that in 2030-31 it would be $13.4 million per year. And on current costings, when you look at inflation, the current costing would be $11.8 million per annum. The costings also involve support for transitioning the young people out of the facility, and as I mentioned last time, that's always a challenge. And it works on the basis that approximately 6 months would be the stay of each young person. But we know that some will go out earlier than that and some will go out later than that. So overall, if I had a perfect world and was drafting legislation, I would want the court to have the capacity to make the orders for a period of up to 12 months and potentially to extend if there was a need for that. When you compare the costings of this therapeutic model with the Productivity Commission report in January 2026, it's just incredible, particularly when you look at Victoria, where we have the highest cost per child. It exceeds $2.6 million per year. So in my view, not only thinking about the effectiveness of the model that I'm proposing, especially compared to detention, but just therapeutically for the young person getting on with their lives, for the safety of the community, it stacks up economically as well. There'd be 1 year of transition, intensive transition, which has been included. I can go into more detail, but I think that gives you the ballpark of what the Parliamentary Budget Office has determined. The Member of Parliament who requested that the costings be done is a person called Rachel Payne, and she said in some discussions that she'd had that one proposal could be for the current Parkville site, which is where the detention centre for young people was initially. It's still being used, but we've now got this massive Cherry Creek, which is miles away. And the proposal was that because I'd indicated one of the important parts of where you determine to locate such a facility is to have access to expert clinicians. And Parkville, I'm not sure if you know Parkville or Melbourne, but it's near the Royal Children's Hospital, it's near Origin Mental Health. There could be young people leaving from Royal Children's Hospital and going in, and if they needed to go back, they could. So that's what she's had to say about the Parliamentary Budget Office costings. I think, as I said, I've given you the details. There would be 24 young people in the facility that they've proposed as an initial facility. And it's very much a clinical medical model that looks at working on the trauma and why young people are using substances, giving them a therapeutic, respectful regime. Their initial assessment is critical because it is a therapeutic model, and we heard overseas that you can't have, say, all kids with ADHD in there or whatever. There has to be a balance. And it won't be suitable for all children. You know, we don't want kids coming in and smashing up the place, but it really represents an additional treatment model that we don't currently have because these young people with the serious substance abuse issues are not engaging voluntarily in treatment, and most of them have started at the very, very young. And very sadly, I've just watched them go through without being able to do anything except choose between detention and putting them back in the community on this fast track to adult prison, and that's really what I want to try and arrest. I hope that was your question.
No, thank you very much. And I'm definitely familiar with Parkville. Had family members work there, and I've unfortunately had family members also involuntarily find themselves there and have managed to turn their lives around. So definitely familiar with it.
And can I just say that there'd be renovations. I'm not talking about it in its current format. It's that is the site that they would look at putting these residences, which are homes, effectively what I saw overseas, not draconian, not bars on windows, concrete walls, a very different model. And one benefit of Parkville is that they already have some recreation facilities there. They have Parkville College, so there's already some infrastructure there that would be helpful.
And I was going to call it a reimagining, but it's not an imagining. There's a plan. Is there a reason that the lowest age is 14?
Look, we just had to select.
I think Victoria in particular. I think that might have changed more recently with the bail law changes, but I don't think there's any kids under the age of 14 in youth justice in Victoria. So I don't know if it's just like to reflect the actual situation currently in Victoria.
Well, part of it is that whenever you talk about a mandatory component, people express a lot of concerns. And the thinking behind it was, we looked at we could have the very young ones or we could have the older ones. And part of my view is if you started with the younger ones, that's very helpful because we want to try and have early intervention. But it was really to try to make it easier for politicians to sell, if you like, that we're going to be locking these 14 to 17-year-olds up in detention, a punitive environment. Why wouldn't you agree to a therapeutic environment? In the ACT, they've introduced my model. Largely, the politicians there relied upon my assistance with drafting, and they've incorporated it on the basis of where they've increased the age of criminal responsibility. So they're looking at the 10 to 14-year-olds in the child protection space rather than the criminal space. My model is applicable to children in child protection just as much as in the criminal justice space. It was just that because of the political climate in Victoria at the moment, we thought that perhaps that's an age group that politicians might be most prepared to agree to legislate for. But the only difference really we found was that you can't mix the really young ones with the older ones, and that overseas there are different models depending upon the stage of development of the children. And the clinical psychiatrists on my What Can Be Done steering committee have made it plain that it has to be tailored to the individual needs of the child, and that also includes their age. So, no, to answer your question in brief, I think it should apply to all children from 10 to 17, which is the jurisdiction. I know we've increased our age of criminal responsibility to 12, but you have children in the child protection space that are very quickly getting into the criminal justice space. So it would depend upon what the political will was as to how they determined it. We just want to start. We want an initial facility to show what can be done, and then I think it will be easier for the legislation to provide for other services that might provide for the younger children, for example.
Yeah, thank you. And I might go to the Ms. Hollands now. And I asked the question of UNICEF earlier, but I wanted to ask about the the task force that in your report you talk about. And because I was saying earlier, Minister for Children makes sense, a ministerial council makes sense, a task force, I mean, it does make sense. So I'm wondering who would be, who are you envisaging would be on a national task force?
Well, it's an interesting question, Senator. Thank you. It's what I had in mind with that recommendation was that actually it would involve all the most senior people from every state and territory. So I'm thinking the ministers that are responsible for youth justice, and they're across the Federation, they are different ministers. There's not a consistent sort of minister. And my understanding is that they don't meet together at all. And so this task force would be set up with those people with the responsibility of working together alongside experts to develop a reform roadmap that is based on evidence, and that this would be part of the National Cabinet mechanism, so that there was an agreement to work across the Federation on this, but it would need to be led by the Commonwealth Government. So this is part of 4 recommendations in Helpway earlier that really are about national coordination and to lift up to a level of accountability that currently does not exist.
Yeah, I was just thinking about some evidence that we got earlier about the invisibility of kids in some of the systems that we have, particularly in family violence, that kind of visibility and accountability.
Yes, and I mean, when you look at the list of key priorities for National Cabinet, the word children does not appear. So I think there is a very clear place where we really need to put child safety, rights and well-being at that cross-federation, level, and to get some kind of oversight of what is going on. The fact that the Commonwealth has historically said it's not our problem and has kind of leant back on it and allowed the states and territories to do their own thing. We have heard from the Children's Commissioners yesterday, as we heard from them in the previous inquiry in February last year, that is not working. And that they want the Commonwealth to become more involved because, these are not problems that the states and territories are able to fix on their own.
Yeah. Thank you. And I am conscious of time, so I'll take the opportunity to share the call. But thank you very much for all of your work, both of you. It's really valuable. Thanks.
Thank you.
Thank you, Senator Stewart. And I only have one quick question before I pass the call to Senator Shoebridge, because a lot of what Senator Stewart has asked is along the same lines as my questioning. In terms of this work, and I guess I'm particularly curious about this sort of therapeutic model for children, because in terms of the, I guess, social licence to go from not incarcerating youth at all to that we are incarcerating youth from 10, there's a long way to go. And I think Scotland, the experience there, it took decades to sort of build that bridge along. 2.5 years sounds like a really long time to get your program up and running at a state level. Do you think with federal support or incentive that could be done quicker?
Absolutely. I don't understand 2.5 years at all, but I'm just advising in fairness, I needed to advise what was in the document that the Parliamentary Budget Office put together. But we saw overseas there were a number of places where they were existing places. They didn't need to be built. They already had, they just needed to be fitted out. So, I'm really not an expert in that whole area, but I was pretty dismayed when I saw that was the time frame that was being proposed.
Can I ask as well whether it would work? Oh, sorry. Did you have something there, Anne? Sorry? No? We heard some evidence from the experts in terms of what they'd done in New York City, where they had these sort of special schools, and it almost sounded like suburban kind of homes where they'd kind of set a very similar idea up, but the kids were then taken out to a special school. Is that something you think could be adapted? Because it sounds similar to what you're suggesting, but you're doing it more with that intensive, it's detox first, the therapy for the kids. I mean, these are kids who are, they're in a pretty bad way.
Yes.
Is that how you kind of see it? Is the different facilities that would be part of it is you start in this very intensive program, and then you slowly sort of go out where there's less and less, I guess, one-on-one support and more that you could go out and you could go to school for the day, but you come back and you're in a safe.
Yes, we based it on what we saw in Sweden and in New Zealand, where there were schools on site, and really England as well and Scotland was all places we saw. But having spoken to Dr. Maguire and listening to what he was saying about Scotland, where the kids do go out to school, I'm not adverse to that. But I think what needs to happen is they need some intensive work done before they go out to the general school system. Most of these children have left school very early, as you would have known and you've heard. And I don't think when we're trying to get them into a therapeutic supportive, it is a therapeutic supportive model, and getting them up to go to school each day and having those kind of skills. Yes, they could go to school outside. I don't have an issue with that ultimately, but I think there needs to be some really good work done on them before they start venturing down that track. And that's ultimately the aim, of course, because we want them to be independent functioning members of our community. So they are going to need to interact with people who are outside this therapeutic bubble, if you like. But because education is so important, it's such a protective factor, and because these kids have been away from school for so long, we need to have there's some containment, because otherwise the risk is they go to school and then they just disappear. They're not having the full benefit of what a therapeutic facility can offer. And I spoke to Dr. Maguire about that, and when I first spoke to him about the part of my model, which is that they won't have been sentenced,
I said if they're on bail, for example, and he thought I was talking about them being on bail and going to school each day, and he said, oh, that won't work. You know, they need containment, they need to be in the facility. So I guess my answer is I think there needs to be on-site facilities that work towards the kids returning outside.
Senator, could I just make a quick comment in support of what Jennifer's talking about in terms of this model, but to also add that I think, you know, I heard in many cases here in Australia that kids are they're not able to get any kind of detox, drug and alcohol help unless they commit a crime. That's the only time, you know, they can actually get any kind of health care. So there is also a role to start much earlier and look at, I think, and this is a recommendation we've made, of an integration of health and education together in local communities. So those two, you know, very big buckets of taxpayer money are not working well together, and so kids are dropping out of school and they are, you know, going down this slide of greater and greater risky behaviour, and that health and education are not well aligned in local communities.
Excellent. Yes, thank you. Senator Shoebridge.
Yeah, thanks both for your ongoing engagement with this and for the work you do in the community. I suppose, I mean, Ms Hollins, you've seen much of the evidence. I think you were present when those international experts gave evidence to the committee in Sydney recently. We can all see the national crisis in plain sight. We've got a really plain, you know, look into the scale of the national crisis in youth justice. The task for us is to recommend changes that would reverse it. And this might be an unfair question to put to you, but I'm going to do it anyhow. If you were thinking about changes that we could implement in the next sitting week of Parliament, changes we could implement over the course of the next year, and changes we should be looking at over the next 4 years, what's in your mind should be the sort of priorities?
Well, you know, I thought about this a lot, and, you know, I just kept going back to the recommendations in the Help Way Earlier report. I mean, with a stroke of a pen, we could create a Cabinet Minister for Children. The reason why that is important is there is no point of accountability right now. It's no one's job to make sure that, you know, we're getting it right for every child, which is what they call it in Scotland. They're making sure that, you know, that children's needs are addressed across all areas of policy. Sorry,
No, that's good. So we don't even have to wait next week. That could be done this afternoon. So
it could be done this afternoon.
And it is hard to work out why we have the resistance for that, given we have ministers for so many other things. And how central children are to our future. But, OK, that's this afternoon. What else? I mean, I'm not asking you to drop anything in Help Way Earlier, but if you're thinking about from the evidence.
Well, look, I think hearing Vincent Schiraldi from New York really had an impact on me when I really understood how involved the federal government is in the US, and that they do have this oversight role, and that they're giving funding and they're withholding funding. You know, so this really says to me that we could do that here. Then that's going to take a bit longer to work out how to set that up and to have some funding partnerships that are beyond what we already have in health and education. We might need to go a bit beyond. But I think that we need some kind of a mechanism whereby everyone is held together to move towards a better place, and that's what the National Task Force is aimed at achieving, that we get everyone at the table saying we are only going to implement what is based on evidence. We're not going to harshly punish children just because that's what you know, we think the public wants. Right? We're actually going to do some proper work here that is responsible. It's not lazy, ineffective policy. It's responsible policy based on evidence. And I think that is something that we can do, and that's a medium-term step.
And to just pause on that for a moment.
Yeah.
What was really fascinating when we heard from Vincent and the experience in New York was that actually that was driven by a very conservative federal government in the US. And it ends up benefiting both children, well, each of children, communities and government budgets. Like it was a pretty extraordinary win-win-win, wasn't it? And driven by conservative politics over there.
So really it's telling us that we have a choice. The Commonwealth government has a choice. The Prime Minister has a choice here about whether to continue to say it's not our problem. It's not about running the justice systems. This is about what is the proper role in a federation of the national government to ensure that there is alignment with evidence and that we are that what we're doing is actually going to protect the public. It is in the public interest to do this, and if we don't have political courage at the local level, we need political courage at another level. Now, I just wanted to also say, also in Help by Earlier, there's a bunch of things that I call the low-hanging fruit that any state or territory government could do in a short space of time. They're all evidence-based. Things like making sport and social activities for kids free. Instead of having, because they can't afford the uniforms, the equipment, the registration, all those barriers that we put in front of poor kids and their families, we need to lean in on those actions, and they could be done very quickly.
Yeah, and this is part of breaking down the silo of thinking about what youth justice means. You know, an answer to youth justice is keeping kids engaged, giving them a sense of belonging, and actually keeping kids engaged and giving a sense of belonging. Often that can be through sport. And you know, if a young kid in a hard home wants to play rugby league on the weekend, well, there should be no barriers to that.
No barriers, and that's what the kids asked for. The things they asked for were no different to what your kids and my kids want. You know, they just don't have access. They're poor kids. They have disadvantage and they have higher levels of need often because of their disabilities and their health issues. And we should be prioritising them in this way with our investments.
Yeah, I asked witnesses earlier about, you know, being a little creative at a federal level with a pool of funding that would, you know, hardly ripple the waters federally, but would make a significant difference nationally. One would be a national fund open to local councils across the country to keep their libraries open longer hours and deliver services for kids. Because we hear time and time again that having safe, welcoming spaces for kids to go to is part of the answer.
Absolutely, and if we agreed on a roadmap for reform that is based on evidence of things like you mentioned, then that kind of gives the states and territories a guidance about where they should be going. Everyone is at a slightly different place, but just like we're doing for domestic violence and other issues, we need everyone moving in the same, better direction.
Part of what struck me when we spoke to those not just advocates, but those people operating the systems in Hawaii, Scotland and New York, was what they said was that there is a massive pool of willing resources in Australia, in communities, in not-for-profits, and you know, I recall specifically the Scottish delegation saying they didn't have that when they started in Scotland. And actually we have got all these resources that actually intelligent principled government could immediately link into.
Correct.
We're actually miles ahead of where Scotland were when they started theirs off.
And also they didn't have the evidence base that back 20 years ago that we know we've got all these benefits of having watched other countries achieve astonishing results, and yet we're still sitting back and we're not making benefit of our own resources and resources from elsewhere. I cannot comprehend why that is. And as you've heard from all your witnesses, everyone's banging on the door of the Commonwealth government saying, please get involved.
Yeah. One witness suggested it was a lack of political will, and maybe that is it at a federal level, a lack of political will at a federal level, and maybe kids just don't have the corporations, the donors, the vested interests that are pushing for outcomes at a federal level. You know, maybe more kids should be billionaires, and maybe they could force this outcome on the federal government. But it's actually at a state and territory level, it's not even a lack of political will. When you look at what's happening, driving this backwards, harming children, consciously harming children with policies, it's worse than a lack of political will. There's almost political malice directed at kids for narrow partisan benefit. You don't have to adopt my formulation of words, but actually we've got, at a federal level, it does seem a lack of political will, but at a state and territory level, it's actually something different from that and kind of meaner.
Well, look, I would put it this way. The politicians at the state level are reacting to the fear of crime in the community. So they think they're doing the right thing, but there is a lack of courage to tell the public the truth, that what will actually prevent crime is the actions that you've heard about in this inquiry. And that's where, if there's a lack of political courage, then that's where they need to work together with the Commonwealth to move this forward.
Well, I might challenge you on the assumption they think they're doing the right thing, because actually what we've heard, and we've heard it in evidence today, that the kids that are copying this, that are in watch houses in Queensland, in a detention centre in Darwin, you know, in an adult facility in WA, the kids overwhelmingly are from low socioeconomic communities, poor communities that just, and politicians are perhaps thinking, when they talk to their friends on the weekend and they talk to their engaged party members, they're thinking, well, I don't mind putting this in place because it won't happen to my kids and it won't happen to my friends' kids. It's just going to happen to those poor kids down there. And I actually think that isn't accidental. I see that as part of the design here.
Maybe, but when I say they think they're doing the right thing, I meant in relation to the fear of the community. So they're reacting to the fear of crime, but it's misguided and not based on evidence, and it's lazy, ineffective policy, in my view.
Can I jump in just to say there, and this is one of the big challenges, is this perception of community safety. So by incarcerating youth that are committing crimes, and there's certainly that if you commit a crime, you should pay the penalty for that. So there is that that aspect. What would you say to those people? How do we change their mind?
Well, this is where I think we need the courage of political leaders to tell them the truth. If they voted in to prevent crime and keep communities safer, then it's their responsibility to implement evidence-based methods, and they're not doing it.
Thank you.
And I think there is, it's interesting in terms of the appetite in the community. There is this idea that horrendous crimes committed, lock these kids up, magistrates keep bailing them, they keep repeating their offending, and they just all need to be locked up. That's the mantra that you often hear people saying. But I think overwhelmingly there is another lot of voices out there that do understand the evidence base, that locking them up is not a solution, that they're going to come back even more alienated, feeling alienated from the community, with low self-esteem, feeling no self-worth, and feeling like, well, why don't I just, hijack a car or break into someone's house? I'm never going to be able to get my own car or my own, property things they want. So I think there's a real responsibility for all governments, that's led by the national government, to educate the public about what really works. And I think that one of the ways to do that, we've got all the statistics, all the percentages, we all know what they are, but it's actually the human life stories that change, I think, people's opinions. So in my submission, I've included the stories of a number of children that are true. And the only change has been anything that might have individualised them so they could be identified. We've left that out. Those stories came from the CEOs of drug and alcohol treatment agencies for young people, for adults, from my experience of sitting on the bench, and from an adolescent child psychiatrist who deals with these young people. And I think the only way we're ever going to change the opinion of the people that are on the side that are saying just lock them all up, that's what they deserve, adult time, adult crime, adult time, is for them to truly understand what the circumstances of these children are. Because what they tend to say is, oh, I don't want to hear another sob story. I'm sick of hearing they've had a sad childhood. You know, I'm just sick of it. And it's very easy to say that, to say, oh, they just make excuses for these kids, but a lot of the kids have got an intellectual disability. Try and explain to someone with a severe intellectual disability consequences. We just hear politicians time and time again in Victoria saying they've got to get the consequences. And when the public hear that, that's what they expect. So I think there's a real need for national leadership to truly explain to people, not that it's an excuse, but there is a reason behind the offending. And if we're ever going to stop that young person offending, we have to address the reasons why. And at the moment, putting them in detention is absolutely the opposite way of ever addressing the reasons for why these kids are committing offences. That's my view. And I suppose what I would say is that a national pool of money will help states and territories if the national government is prepared to, you know, assist in the costs of these programs. But I'd also say that my project, if you like, my lifelong obsession, is so much cheaper than than youth detention. So when you talk about governments having to make economic decisions, the national government could support the state and territory governments, but when they truly understand how expensive the current costs of detention are, it all stacks up. The evidence and the costings are all going one way, but, you know, that's not what we're hearing. And in terms of the questions that were raised by I think it was Senator Shoebridge, I'll just refer to my initial submission that I made to the inquiry. And on page 9, I actually addressed the leadership that the national government, I won't repeat it because I know we're short of time, but having it as a national agenda item on things like the Attorneys General, they meet all the time, and I totally adopt Anne's the recommendations in her report about having a Minister for Children. I think it's outrageous that there's not. I know there are some logistical issues when, you know, it's the Prime Minister who chooses who the minister should be. But if we had a Minister for Children, it would be a lot harder for the next Prime Minister not to have a Minister for Children, I think. And children miss out all the time. We had diversion policies that came into the adult jurisdiction years before the Children's Court had that power. It's adults just seem to have this capacity because they vote to attract the funds, and it's the children that we really need to support.
Thank you both very much for coming back and giving us additional evidence. We've found it incredibly valuable and insightful to be able to hear from you both. Again, with your indulgence, we will stay in touch as we formulate the recommendations for this report. But we are very grateful to you both. So thank you. And with that, you are released to your Friday evening.
Thank you both.
Thank you.
Thank you, Sam.
We'll just
thank you, Chair.
suspend for a couple of minutes. I now welcome representatives from the Attorney-General's Department and the National Indigenous Australians Agency. Thank you for taking the time to speak with the committee today. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. Before we begin this session, I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can I please ask you each to state your full name and the capacity in which you appear? We might start at one end and...
Ali Jenkins, Group Manager for Social Policy at the National Indigenous Australians Agency.
Joshua Smith, Deputy CEO, National Indigenous Australians Agency.
Chris Collett, Acting Deputy Secretary, Justice and Communities, Attorney General's Department.
Cassie Woods, Assistant Secretary for the First Nations Justice Branch at Attorney General's Department.
Kieran O'Brien, Acting Assistant Secretary, Human Rights Branch at the Attorney General's Department.
Luke Brown, Assistant Secretary, Commonwealth Parole Task Force and International Cooperation.
Fantastic. And do you have an opening statement? You do? Yep. Please commence.
Thank you, Chair. I'd like to begin by acknowledging traditional custodians of land we're on today, the Ngunnawal people, and I pay my respects to Elders past and present. I also extend that acknowledgement to all First Peoples in the hearing today and your Elders, particularly Mati Mati and Wamba Wamba Elders and Yamaji Elders, although Senator Cox is not here, but that's in regards to Senators Stewart and Cox. I also acknowledge young people and their families, First Nations and non, that are impacted by justice systems and the trauma that this contact generates.
Mr Smith, I don't mean to interrupt you. Sorry. We do have your written statement, which you're reading from, but we can table that, which might actually... And it is full of some useful information, but we can table it if that's okay.
Fine. Excellent, we will do that. Thank you very much. I am conscious we do have a hard marker of 5:30 this evening. Did the Attorney General's Department?
No, nothing further. Thank you, Chair. We'll here to assist the committee.
We will go straight into questions then, and I will give the call to Senator Stewart.
Thank you, Chair, and thank you to all of you for giving up your Friday evenings to come and appear before the committee. I've got a couple of questions about the justice reinvestment initiatives, and I'm keen to understand if there's, and I appreciate that the justice reinvestment work and investment is for to see changes over the long term, not necessarily in the short term. But I'm wondering if there's anything that you can share about how, any early insights, I suppose, about how some of those programs are working.
Thanks, Senator, for the question. And JR is one of the areas that I'm most passionate about from the work of my branch. So really happy to provide some information. I guess for context, over the course of justice reinvestment, the department has funded 28 justice reinvestment initiatives. 13 of those have a youth focus, so of particular relevance to this committee. I did just do a double check because in previous committees I've provided evidence around sort of some of the really encouraging signs in some of our initiatives, like on Groot Island, which I believe this committee has actually had the pleasure of attending, as well as over in WA for our ALSWA initiative that has a really heavy focus on youth. But I thought I'd take the opportunity to just do a little bit of a dive into some of our other youth-focused initiatives. And so bearing in mind that we really strongly adhere to the principles of free, prior, informed consent, I'm going to not name specific initiatives, but provide some information about them that we have received consent to provide to the committee. So I might start with an initiative that has established a coordinated justice network to strengthen collaboration between stakeholders to improve youth justice outcomes. So that involves cultural leaders, local police, schools, corrections and other support services and government agencies, so a holistic approach to justice reinvestment in this particular community. They've registered with the Elder Visiting Program and coordinate culturally matched mentors to visit clients who are incarcerated. They have sort of a visiting schedule that has been established with those correctional institutions where access in other institutions has been problematic. They do cultural camps and bush trips, which are delivered during dry season. They do filmmaking workshops, gathering elder knowledge and sharing around a campfire, so a real focus on cultural connection for youth in the community. And they support whole of community responses that support reduction of alcohol and substance related harm through including working together with traditional owners and other key agencies to review liquor licensing, permit systems and alcohol management plans to strengthen the policies and reduce alcohol related incidents. That's one initiative. I could go into further, but I am also conscious of the time that the committee has available. This is representative of the kinds of interventions that all of our initiatives are undertaking in the respective communities that are funded. The fact that this is a long-term government commitment, it's not short-term funding that has an endpoint. The fact that it recognises that systemic change takes time, but that these early wins are already happening in a program where first funding went out the door 2 years ago, I think is a sensational reflection of the value of community-led initiatives to respond to youth who need cultural connection, need diversion, need supports, need reintegration with education, need employment pathways, and these local communities are doing that in conjunction with all relevant service providers, local authorities and corrections.
Thank you, Ms Woods. And there really has never been a more important time to be doing the justice reinvestment work, especially with some of the states and territories moving to more tough on crime measures and really punitive bail laws. I'm interested in the what you said about the visiting elders work. We heard some evidence early in the day that talked about the importance of a key person in young people's lives to help get them through to the other side. Is that what that was, like the visiting elder was based on, or is there some other things that went into?
I mean, that is absolutely one component, which is, for any youth having that connection to someone who is an absolute necessity for people navigating justice systems. But I would say it's more than that in the justice reinvestment context and for First Nations communities. We have a different cultural respect for our elders, and that presents a different motivation for First Nations youth who are contacting justice systems. The fact that elders are putting their time into youth in these communities, the fact that those youth are beginning to respect elders and eldership in those communities is another lever that justice reinvestment utilises that is grounded in culture, that retains connection, which is also what all of the evidence points towards when we're talking about cultural connection, not just for First Nations people, but for any cultural background. That connection to culture is a grounding force for children. And so, there's a multifacet to why the elder visitorship program is in place in these communities that are taking that approach.
And in the justice reinvestment work, where there has been, signs or kind of evidence that things are working, what's the capacity to be able to kind of pick up something like that and see if it works somewhere else?
Yeah, I mean, it's a really good question. I think that the Commonwealth program drew heavily from the experience of New South Wales in the Burke Justice Reinvestment program project that had been in place for something like 10 years prior to the Commonwealth's national program being created. I think there is an extent to which those learnings can be picked up and utilised. But what I would also caution is that justice reinvestment is community-led, and the very foundation of that means that there are different solutions in different communities. Some may share some principles and approaches that work, but I think that the real importance of JR is that the community-led aspect is absolutely paramount. It's not governments, it's not systems, it's not anyone dictating to communities what the best solutions are. It's communities who know their people, who know their issues, who are telling governments, who are telling institutions, this is how we need you to work with us to address youth contact with justice systems in our communities, and we need you to get on board with how we need you to operate.
Yeah, absolutely. I appreciate that. For it to be community-led, it would mean that, there might be another community who sees what's happening up on group, and they say, we want a copy of that down here. How do they get to find out what's happening on group, though? So how do they get to know what's happening in each of the jurisdictions to know we want to try what's happening in New South Wales, we want to try what's happening on group? How does that work?
Yeah,
because a part of it is you don't know what you don't know.
I mean, there's a number of mechanisms that we have, and again, it's kind of, at the moment, it is contained to those communities that are doing justice reinvestment. So we have a national collaboration group on justice reinvestment that brings different governments, philanthropic partners, peak organisations, Commonwealth agencies, not just Attorney General's Department, to collaborate around justice reinvestment infrastructure. So looking at it from there's different jurisdictions that have JR, there's a Commonwealth JR program, there's sort of investment that approximates JR but isn't justice reinvestment. How do we hang all of these things together in a more coordinated fashion? Because when you look at that whole tapestry, there's actually a lot more coverage nationally than what one Commonwealth program alone or one state program alone has. So looking at that. From the initiative's perspective, the Interim Justice Reinvestment Unit did over 300 consultations in 18 months alone that ensured that there was a level of connection between the initiatives. They also held 4 national roundtables in a co-design process for how the final unit should and would operate. And the whole point of that is that there's that collective joining of those justice reinvestment communities to share experience and learn from each other. I understand that one of the functions of the to-be final unit is likely to be a community of practice for justice reinvestment. And so that's a further mechanism that as justice reinvestment matures, that those learnings can be shared and adapted within the bounds of Indigenous data sovereignty.
So there's a couple of questions that come to mind from your evidence. One is about one of the recommendations in the Help Way Earlier report, which was a National Youth Justice Task Force, which is to coordinate and monitor lots of the work that's happening. So it sounds like what we have right now doesn't quite go that far, but it's also not the purpose of it. But sounds like it could be useful in this instance to help you do your work. Was wondering, now the question's just gone out of my head as I summarise my little Justice Task Force thing. I did. It was about data. So we also heard some evidence earlier today that not that we're collecting the wrong data, but that there are big gaps in the data that we do collect. Do you find that as well? And do you, is there data that you want to have collected to help us with policy and our work, to help with, decide what funding, the Commonwealth provides, all the things? And the other thing that was put to us, and maybe this is not with your department specifically, but that we should have like a national child death register, and we don't.
Really good questions. I might take a few blocks of that to respond. Thinking about it through a justice reinvestment lens, absolutely there are gaps in data, and we've worked really closely, and by we, I also really want to give credit to the Interim Justice Reinvestment Unit, who have worked really closely with our JR initiatives to identify what the data needs are for funded initiatives to enable them to target their interventions and their approaches under their programs. Through that, the Interim Justice Reinvestment Unit has worked with the Australian Bureau of Statistics to produce a set of, I think it's administrative data, and I might just turn to make sure I've got the right term, that is already available through the ABS, collected through the ABS, but not packaged or brought together in a way that communities can access, to develop data packs relevant to each jurisdiction for those communities that are Commonwealth-funded JR initiatives based on what they indicated were their data needs. It's one of a stage in 3 approaches that we're taking on the data front, one of which is I guess the next big thing that we're working on, which is a set of data that requires state and territories to provide information, because it's not a data set that the Commonwealth holds. And so we're in preliminary negotiations to try and essentially define the minimum data set that our JR communities are seeking to further implementation of their initiatives that state and territories are the data custodians of. And we're getting some really positive engagement from jurisdictions at the early stages of those conversations. But all of that, again, is community-led in terms of the data needs of those communities based on what we hold it as Commonwealth, not just AGD, but as Commonwealth, and what state and territories hold. Moreover, stepping outside of justice reinvestment, there is a number of data sets that we routinely work with that are held by other agencies. Absolutely agree that there are gaps in the data, and absolutely agree that there would be things that would be helpful at a Commonwealth level to have visibility of and access to readily, that we could also provide access to our communities around, because, when we think about priority reform for and data sovereignty, I think as all governments, there's a responsibility to provide the pathways that actually embed data sovereignty for First Nations communities.
Thank you. I might just ask a couple of questions of the NIAA, noting time. I'm sorry, Senator Shoebridge has got some questions here too. What's the NIAA's role in early intervention and prevention? Like, what are some of the things that you fund or do that keep young people out of the youth justice system?
Thanks, Senator Stewart, for the question. We fund a range of things under a number of different programs, and some of them are specific in relation to youth justice for children and young people that are at risk already involved in the youth justice system. But more broadly, what we do know is that culture and connection and strong and safe families are a protective factor for our young people and prevents them from going into the youth justice system. So there are a wide range of investments that we make in communities right across Australia. If I go to some of the sort of broader programs under the Indigenous Advancement Strategy in 25-26, we invested in some of the programs that I've referred to in my statement that's been tabled, so early childhood development programs, schooling projects. More specifically, though, into youth justice programs, there's a $61.5 million investment under the IAS. $31 million of that is for community safety patrols, and we heard from the previous witnesses, Senator, that providing a safe place for our young people is critical to keeping them out of contact with the justice system. We're funding youth through care for First Nations young people, so for those young people that are already in contact with the youth justice system and incarcerated, there is funding to help transition back safely into community. And there's $16.3 million for youth support and diversion. So this is that concept of a wraparound supports for First Nations children at risk of entering the justice system. We see some of that investment mirrored by some of the other jurisdictions, and Senator Stewart, you might be aware of the youth justice strategy in Victoria, Wakara Kulpa. It's an Aboriginal specific youth justice strategy that invest in Aboriginal community-controlled organisations, Aboriginal youth justice workers to work with those families and young people that are at risk or in contact with the justice system, and strengthen those families so that those risk factors are lowered and those protective factors are high.
And do you fund... So I suppose I'm interested to know how you decide where to provide some of those dollars, and is it based on where the population is, in terms of Victoria has a higher Aboriginal population than, I don't know, Tasmania, for example. So does Victoria then get more funding than Tasmania towards youth justice measures, or is it somebody's put in a grant application in Tasmania, so they might get some dollars, and because Victoria they don't get any, but actually their youth justice numbers suggest they probably should have. So I'm wondering how the decision gets made about where you allocate money based on what. Is it somebody applying, or is it you can see that because of the change in bail laws in Victoria, there's probably going to be a spike in youth justice outcomes, and you do some of the proactive work to get in early to support the Victorian government or community organisations to make sure that we're doing some diversion work early.
I might hand to my colleague, Ms Jenkins, on that, Senator Stewart, but I should also, just for the record, our colleague, Ms Powell, is online, and we did not introduce her early on, but for the record, I would introduce Ms Powell online.
Thank you. So our activities, we fund actually a really high number of activities across a range of different parts of Australia. Generally, it does follow probably more of a geographical, we would have a higher geographical need in the Northern Territory, Queensland and WA, but we do have services that are delivered in lots of, throughout Australia.
What determines the higher geographical need? And I ask that because, and I would be interested if you can on notice provide a jurisdictional breakdown of funding towards youth justice measures, diversion area, and so I'm interested in the in your comment about jurisdictional need, because if child protection is an indicator of youth justice, your pathway into youth justice, Victoria has one of the highest child protection notification rates. So I am interested in what determines need.
So there are a range of different factors that go into sort of what we consider. I think it's probably best if I do take on notice in some more detail the regions that we are providing into. Because that I don't have that detail here.
No, that's completely fine. It's probably helpful to Senator Shoebridge if you do provide it on notice, so I can share the call with him as well. So that's completely fine. I appreciate you might not have that on hand.
Thank you, Senator Stewart, for your assistance. Senator Shoebridge.
Thanks, Chair. Thanks for your attendance today. Ms Woods, you spoke about some of the benefits of the Justice Reinvestment Program, and I heard you. So what's going to be the effect of the savage budget cuts proposed to justice reinvestment in the budget? What's going to be the effect of those savage budget cuts?
There's no budget cuts proposed in the budget for justice reinvestment, Senator. Well,
I'm on page 20 of the budget, and it says justice reinvestment for this financial year is $30,999,000. It says, for last financial year, $30,999,000. It says justice reinvestment for this financial year is $24 million. And then it says for the 3 years ongoing, it'll be $20 million.
Yep.
So is the budget right?
It is, but I can explain why those figures are what they are. So there hasn't been any cuts or changes. The government's original commitment was, over the first 4 years, a $69 million investment. Some of that money was carried forward because from the time of the commitment, the program didn't actually establish for about 18 months to 2 years. So there's carry forward, which is why from next financial year, or this now, sorry, we're in July, 26-27, you'll see that figure of 30. So the original commitment was for $69 million over 4 years, with $20 million per year ongoing annual funding from the 26-27 financial year, which is this financial year.
So last financial year, 31 million.
Because of carry forwards, yes.
Well, was that how much was spent? Is that how much was spent? 31 million?
Correct.
This year, there'll be less spent. There'll be 24 million spent.
Correct.
And the year after that, there'll be even less spent, just 20 million. Now, I call that budget cuts. Put to one side, what is going to be the effect of taking $11 million out of the justice reinvestment expenditure between last financial year and next financial year? What's not going to be funded when there's $11 million less?
So I understand the question. What I would reiterate is that there hasn't been a cut. That $69 million original
investment. It was always intended to go down. I understand that. What's going to be the effect of spending $11 million less on justice reinvestment next year than was spent last year?
So we have transitioned all of our justice reinvestment initiatives to the ongoing funding arrangements. They've been funded beyond their baseline levels of funding for the next 3 years. So there's actually, because that $69 million original commitment was over 4 years, there has not been an in-effect cut to our justice reinvestment initiatives. They have all transitioned prior to 30 June to ongoing funding arrangements from 1 July. Those arrangements have provided for baseline funding of what their baseline funding was, plus additional over those 3 years. And we were able to do that because of our consultation with initiatives over a 2-month period, and then some, robust briefing to government to ensure that our allocation ensured the baseline operations for all of our initiatives were able to continue.
The Attorney General's Department budget for this financial year is close to $1.2 billion. There is a national crisis in youth justice, and your principal response is the justice reinvestment budget, about half of which goes to youth justice. So that's about, this year, 12 million out of 1.2 billion, which is what, 0.1% of the budget on justice reinvestment. And that's the principal response that we get from your department to this national youth justice crisis?
So my branch's interest is in First Nations justice. That's my branch. In terms of First Nations justice, justice reinvestment is one of the practical mechanisms that this department portfolio invests in. But addressing youth justice is across all of Commonwealth. It is multiple agencies looking at all of the drivers, inclusive of justice reinvestment.
Well, there's a figure for Indigenous justice in the budget, in the AG's budget, and do you want to remind the committee how much that is, the Indigenous justice budget?
You've got it in front of you, Senator.
Yeah, it's 1.5 million, which is 0.01% of the AG's budget. That's what you bring to the table to deal with a national youth justice budget. 0.011% of the budget.
That is an investment in our communities or programs. That's to service the personnel costs of running that from within the Attorney General's department.
I might, if I can, Senator, note that there is a whole range of programs that the Attorney General's department is responsible for that serve First Nations Australians. Clearly it's in the justice portfolio where we operate, and a number of those programs go to support the sorts of issues you're raising. The budget, of course, has the names of government programs as they're listed, and as Ms Woods noted, you're referring to one particular program within one branch.
I've read your submission. You reference generic budget you reference generic funding to the Northern Territory. You mention generic funding to First Nations communities. From a justice reinvestment point of view, though, I can find in this year's budget $12 million.
I think, Senator, the submission you're referring to is it the letter from December last year? I just want to make sure I'm talking to the right document.
Yes.
Yes.
Is there a more up-to-date submission?
No, I just want to make sure I'm thinking of the right document in responding to your question. I think some of the funding programs you're referring to go to NIAA. That document was a letter from both NIAA and the Attorney General's Department.
NIAA actually have some funds going towards some of the kind of diversion programs. We'll get to that in a second.
Sure.
But to be clear, the justice reinvestment expenditure for this financial year is $24 million. And if we look at the funding to date, about half of that is going towards youth programs. Is that right?
Yeah, that's correct.
And there's about 6 million kids in the country. So on a per kid, 6 million young people aged under 18. So on a per child expenditure, about $2 a child.
I think that's an unfair comparison, Senator, because justice reinvestment is for First Nations communities. So there aren't 6 million First Nations children in the country.
So for the poor kids who aren't First Nations in Western Sydney or across the country, there's no funding?
Well, for this particular program, no, because this particular program is a specific intervention for First Nations people.
What is being spent to keep non-First Nations kids out of jail from your department across the country?
That's something that I can't speak to. My remit is First Nations justice.
Mr. Collett, because you have the responsibility.
Yes.
If it's nothing, then say nothing.
The department doesn't run a justice reinvestment program for the general community. The justice reinvestment program is for First Nations.
So we have heard, yes, that First Nations kids are tragically, massively overrepresented, about 60% of the kids in jail. But we have heard that the other 40% of the kids in jail are overwhelmingly just poor kids. Many of them from multicultural communities, but not just multicultural communities. Just being poor is why you find yourself in this situation as a child. Is there any funding going from a federal level for programs to keep those kids out of jail?
The Attorney General's Department doesn't run a program in the manner to which you've described.
Are you aware of any other government program to keep just poor kids out of jail?
It's not the role of the Attorney General's Department, of course, Senator, to speak for other departments. There are other interventions that the Commonwealth Government is responsible for that do go to supporting vulnerable Australians and vulnerable children. It depends on how broad you want that question to be, Senator, not to...
Well, I'm just simply asking... Well, I don't want you to speculate on things you don't know or can't speak to. So maybe we'll just keep to the Attorney General's Department. I withdraw that previous question. So the answer is nothing.
Well, if I can add, the point I was trying to make, Senator, is that there are a range of policy responsibilities that our department hold that goes to supporting Australia's children. They are not specific to youth justice.
Yeah, I actually know that there are other Commonwealth payments that go towards children generically. I'm asking you about Commonwealth payments from your department to keep kids out of jail, and outside of justice reinvestment, the $12 million out of your $1.2 billion that go towards First Nations kids. Is there anything else you can point to?
No, not to my knowledge, Senator. The Attorney General's Department is predominantly a policy department. We run some programs in areas like family law, in First Nations justice, as Ms Woods talked about, but by and large our responsibilities are in the policy and legislative domain. We're not a large program department.
Well, you say you're not a large program. There are programs that are administered out of the Attorney General's Department. The Access to Justice Partnership program, is that administered out of your department?
It is. You're talking about when you say access to justice, the legal assistance related act? Yes, that's
a program that you fund for services.
It depends, Senator, on how you want me to apply your question. So the department is responsible for
This isn't a semantic discussion, right? We've heard days of evidence of a national youth justice crisis. Kids going to jail because the library isn't kept open. Kids going to jail because they haven't got food and they're choosing to go to jail because they're hungry. Kids going to jail because they are scared about going home. And pretty much every submission has said the Commonwealth needs to do something. And we have the Federal Attorney General's Department here, and you can identify $12 million that you're spending on it.
Well, that's not the.
Well, tell me apart from that $12 million, your department, how much are you spending?
So if you're talking more generally, the Attorney General's Department, of course, is responsible for legal assistance funding under the National Access to Justice Partnership. Now, that's a $3.9 billion commitment over I think it's 5 years, that provides legal assistance services to Australians across a whole range of areas.
Do you know what?
Not a single
Senator,
person,
if I could finish. Not a single person has called for that hasn't been the call from any of the submissions. That's a baseline separate service, the legal services. They've been asking for spending on services like I was just putting to you.
Well, Senator, if I could finish the comment I was trying to make. As I said before, it depends on how you're applying your question. If you're asking about programs we're responsible for, we are responsible for legal assistance. That partnership provides legal services to a whole range of Australians, including children. It's not a specific youth justice program, but it is the core funding arrangement for legal assistance for vulnerable Australians, which includes youth.
Anyone who has followed the course of this evidence over the course of this inquiry and then had the intestinal fortitude to wait to the end of this session with the Attorney-General's Department, I challenge anyone to tell me, or to anyone who's watched it, that the response we've got from the Attorney-General's Department is within a bull's roar of meeting the need. And thankfully, we're now at 5:30.
Thank you very much, Senator Shoebridge. We have reached our hard marker of 5:30 for this hearing. Thank you for coming in and giving evidence to the committee. If you have been asked to provide questions on notice, we would ask that that's provided to the Secretariat within 2 weeks. And that does conclude today's proceedings. Thank you to all witnesses who have given evidence to the committee over the course of today. I'd also like to thank Broadcasting, Hansard and the Secretariat. And with that, I declare the hearing adjourned.